Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are going to pick up on a new trial. Michigan versus Christopher Schurr. So let me bring us over here. And who is with us today? And Special K, thank you so much for that generous gift. We really appreciate your support. Thank you for that. And you became a member of Dial-Up too. Well, you're two. Yeah. So you're 2 months in now. Fantastic. So Crystal H made it through. Sherry M made it through the portal. Only Fan and Jenny, good to see you. Sherry M, Fala and Lily Wayne. Golden Girl. We will finish the Dr. Turek. We will finish him. We'll work on him. We'll do him over the weekend. I promise. We're not done with Dr. Turek. We will absolutely stream him probably tomorrow. Shore Life, ouch, you got stuck. Nice. Ken Rosenberg joining us. Sarah in a shock and horror. Mike Morrow, did we port? Where am I? Who am I? Hazel, oh wow, this sounds hectic. Yeah, we definitely have to talk about this, you guys. Brenda and Terry, good to see you. Queen Olive and Tammy, awesome. Mike W, thank you. Therapist, you know. What do y'all think? Some good rules. Yeah, so let's, hold on a sec. We definitely have to consider wow, why am I so blown out? Hold on a sec. Let me open that up a little bit. Okay. Baka, real happy. Thank you for joining us. Appreciate it. Irish Amy. Dwayne, good to see you. Just Shamrock and MEG. Rona and Martha. Fantastic. Babaloo. Marley Mum, thank you. Selena K. Alice, good to see you. Everybody made it over. Bertie. All right. So this is going to possibly elicit some emotions. So we have to remember to be courteous to each other, respect each other. We're going to maybe have difference of opinions. We're going to do some pre-trial prep today. So we're going to go through pre-trial hearings, some news footage, all that stuff. So just to guys give you a overview here. So this is Michigan. This happened in Grand Rapids, right? So the date of the incident is April 4th of 2022. Patrick Lyoya. I'm going to get that. I have to get that name right. Patrick Lyoya. Well, I'll have to work on that. We'll go with Patrick for now. He is the victim, and the defendant is Christopher Schurr. Now, this happened April 4th. Patrick, he was 26 years old. He's from Congo. He was fatally shot by Officer Schurr during a traffic stop. So Officer Schurr pulled Patrick over. His license plate did not match the car. Right? This happened in Grand Rapids, Michigan. The incident escalated when Patrick attempted to flee, leading to a physical struggle over Schurr's taser. Schurr ultimately shot Patrick in the back of the head while he was face down on the ground. The shooting was captured on multiple videos, so there's going to definitely be warnings because it was. I have not seen it yet. So it was his body cam, his dash cam, a bystander cell phone, so there was somebody in the car with Patrick, right? And then ring camera captured it as well. So this has sparked widespread protests and calls for police reform. Independent autopsy did confirm that Patrick died from a single gunshot wound to the back of the head. Now, Officer Schurr, he has been fired from the Grand Rapids Police Department. He was placed on administrative leave following the incident and was officially terminated June 15th of 2020 after he waived his rights to a discharge hearing. He is out on bond. He posted his $100,000 bond, which basically he paid $10,000. So that's where we stand. Yeah, so it's pretty brutal. They fought, they struggled. Patrick ended up on face down, and officer shot him in the back of the head. So it's gonna be a tough one. I'm not gonna say this is gonna be an easy one to get through. So we just have to remain adults and respect each other and respect the process. I'm going to just start off by saying this could have been avoided, I think, on both sides. We've learned through watching so many trials that as soon as you start to struggle with the police, it's not going to end up in your favor. So that being said, law enforcement has to figure out a better way to sort these situations out, because you're in a battle for your life at this point. What do? It's going to be a tough one. I'm not going to say. It's going to be a tough one, you guys. So I think, Patrick is no longer with us, so he's paid the ultimate price. So let's see what we have. Let's go to, here's the news conference. This is the first one we're going to watch. So this is a news conference with the charges. So oops, sorry.
We are getting word.
Sorry, guys. All right, let me back down some of my gain, because I had gain on. I can back off some of our gain here. Okay. Okay, this is a news conference.
That news conference where we are expecting his charging decision has started. We're going to send you to that news conference now live.
I deeply appreciate what they've done, especially some of their calls for peace and calm during this entire time. I think it's been tremendously beneficial for this community, and I can't say how much I appreciate what they've done in regards to that. I just had the opportunity to speak with the family, express my condolences and tell them essentially what I'm just telling you here. I have prepared a letter in their native Swahili, because obviously this is difficult even under the best of circumstances, much less with a language barrier. So I had a letter translated into Swahili to provide to the family so they can be fully aware of what my announcement is here today. And I've conveyed that to them and their family. I also want to thank the Michigan State Police for their dedication and really doing a thorough investigation in this matter. Detective Sergeant Aaron Tubergen really did an excellent job. He's done everything I requested of him, even on some of the follow-up, and so it's made a difficult situation obviously a little bit easier to have a partner that you can work with. Based on his investigation, based on everything he has provided to me, I have made the decision to charge Christopher Schurr with one count of second-degree murder. Second-degree murder is a felony offense. It is punishable by up to life in prison with the possibility of parole. As it stands now, this is merely an allegation, and as with any defendant, he is presumed innocent until proven guilty beyond a reasonable doubt in a court of law. The elements of second-degree murder are relatively simple. First, there was a death done by the defendant, and then when the killing occurred, the defendant had one of these three states of mind: an intent to kill, an intent to do great bodily harm, or the intent to do an act that the natural tendency of that act would be to cause death or great bodily harm. And finally, that the death was not justified or excused, for example, by self-defense. Taking a look at everything that I reviewed in this case, I believe there's a sufficient basis to proceed on a single count of second-degree murder, and that charge has been filed with the courts as of today. Given that I filed charges, and we have all of you here today, the Michigan Rules of Professional Conduct severely limit what I can say. I'm not going to be able to get into the facts, the circumstances, the decisions I made through this process. The rules of professional conduct are pretty strict. This case needs to be tried in a court of law and not necessarily in public. So I will answer some questions. I can try and answer them, but I may not be able to given the rules that I have to face. This case will be tried in the court. One other thing, for the local media who's here, I think they cover us quite a bit. They will notice that we did not file a felony firearm charge. Felony firearm is a separate charge. It's a 2-year that is added on to whatever underlying felony is, and we very often charge it when a gun is used in a homicide. We cannot do so in this circumstance. In 1991, the Michigan Supreme Court in People v. Khoury, Khoury, ruled that a felony firearm cannot be charged against a police officer who used a gun in the performance of their duties. So that is why you do not see a felony firearm charge, as is often the case under these circumstances. It is my understanding, I've been in contact with the Michigan State Police, that Mr. Schurr has turned himself in. He has been being processed. He will be arraigned in the 61st District Court in the city of Grand Rapids. It is my understanding that arraignment will take place sometime tomorrow. I do not have a specific time or date. That is up to the court. That is a function of the court, if you will, to take care of that. So that concludes my statement. As I said, I'll take some questions. I'll answer the questions that I can. I may not be able to answer all, and I'm just doing the questions here. I'm not going to do any individual interviews after this is all completed. So,
Officer Schurr, did he talk to MSP? Did he sit down and do an interview with MSP?
I can't get into that. That would be a factual question in terms of that'll come out in court.
Mr. Becker, this incident happened on April 4th, so why did it take so long to come out with this charging decision today?
Hey, this is I just got the full report on the Tuesday after Memorial Day. So in terms of getting a complete report, I've only been, 8 days, 9 days after that. I mean, part of it was and it's not the Michigan State Police fault, it's getting the Taser report, the forensic report from the company. And, things take time, and I want to be obviously thorough. This is obviously a major decision. We've never had to use a room like this for a case here, so it's just wanting to be thorough and go over everything. But I never got that, the full report until about 8 days ago, so I don't think this is outside the bounds of what we normally do. We have cases that sometimes takes months to charge. I have a case going on right now that took almost 6-7 months to charge. We make a decision when we have all the facts.
Mr. Prosecutor, you had said you wanted to talk with some experts in your deliberation in this case. Can you give us a hint of who you talked to? Were they use of force experts? Can you tell us who you used as sounding boards?
There were use of force experts. I'm not going to get into my witnesses in terms of the case, but I know that came up in one of the questions in terms of the Michigan State Police. I did request the Michigan State Police, ask them if they could maybe give their expertise, but there's an issue in terms of they are kind of the fact finders, and then trying to ask them to be opinions on top of the fact finders. We were a little bit uncomfortable with that, so that's part of the reason I went kind of outside, because that's been one of the things I've heard is why not use the Michigan State Police. So we tried to use them, so we went outside of that, and you'll find out about them as this case progresses.
Chris, 2 questions. One, do you think that this case should be prosecuted in Kent County, given how much attention it's gotten? And 2, will your office be requesting that he not be given bond, or are you fine with having him released?
2 questions. Yeah, I don't see why it wouldn't be tried in Kent County. I mean, to be honest with you, I don't know where else is it going to be tried. I mean, this is not like only Kent County media is here today. So we've handled high-profile cases, very high-profile cases. I think I'm very confident with Kent County juries to look at the facts and kind of block this out. I've handled high-profile cases, so I'm not concerned about that. In terms of the bond issue, we don't get involved in bonds in our office. I don't know how it's done in other cases or other counties, but we're not at arraignments. I don't have the bodies to cover at arraignments, so that we have court services that comes up with a report. I can go into that, a praxis, if you will, and they come up with a, prior history, mental health history, what the crime was, and they provide that to the judge. The judge makes the decision on bond. So that will be essentially a court function, and we generally stay out of it. I can't say every single time, but generally stay out of it in the vast, 99% of the cases. Let's give him next to you. He had
manslaughter charges, and talk about the difference between manslaughter and second degree in this case.
Obviously, we considered, we looked at everything, and so manslaughter will be a lesser included offense. The difference in manslaughter is a heat of passion. There's some sort of provocation with heat of passion, so that is something we took a look at. I felt based on the evidence I reviewed, I think a second degree murder charge is appropriate, but that is generally a lesser included instruction should it get to a jury.
Was Grand Rapids Police Chief Winstrom informed of your decision before you just announced it?
Yes, I talked to them. Yes, I let them know yesterday.
Can you share anything with that conversation?
I will let him. I'm not going to speak for him, or I'll let him answer that. I'm sure they'll probably have something to say.
Mr. Prosecutor, given the second-degree murder charge, does this make it more difficult for you to prove this in court? And do you have any concerns with the jury? We're from Detroit. We came to town to cover the plot to kidnap the governor, and 2 men were found not guilty by that jury. So what are your thoughts about a jury, and does this charge make it a higher bar for you to win in court?
No, I don't think so. I think, obviously, I wouldn't charge if I didn't think I could prove it. I don't, be it manslaughter or second-degree murder, it's almost the same. It's the same elements, to be honest with you, except that manslaughter has the negating factor, if you look at the law, that it was done under the heat of passion. So the jury will have the opportunity to consider that. So I don't think it's a higher burden. The Whitmer jury, and I'm not a federal, so I can't comment a whole lot. I wasn't involved in that, but I have faith in Kent County juries. I mean, I think they're very conscientious. They listen, they pay attention, and they're not swayed by outside influences. I think they're very considerate. So I guess they will take the seriousness and take the time to do what they think is, a right in a situation like this. I really do believe that. On the back?
Sir, did you hear from when you presented to the family, did you get feedback from them? And were they able to express themselves to you?
Very briefly. I mean, they said thank you, and it was a very brief phone call, so I did not, really talk to them a whole lot, with the interpreter. It's difficult. I mean, it's difficult. I also wanted them, they didn't have an opportunity to read my letter. I said, why don't you, read the letter? And, we're going to talk later since we did charge, so we'll have an opportunity to speak as this goes through.
Do you think that this sends a message to police officers here in Grand Rapids that they can be charged with murder if they shoot someone?
I don't think so. I'm never big on sending messages with charges. I think most police officers realize that it could happen. I know there's been a lot of, coverage of my prior decisions, and I look at every decision and try and take every decision as the facts of the case, and I stand by all the decisions I made in the past, and I'll obviously stand by this one. So I'm not thinking that Kent County officers or even any police officers in general thought they had a license to go out and do something like this. I think this is not a message. This is just based on the facts. I'm making a decision on this case.
And you talked about having only 8 days since you've received the full investigation materials. I know you can't talk about what those materials were, but having all those, how were you able to make that decision in those days?
Well, I had a lot of the material. I mean, that was one big piece of the report, so I had a lot of it, so I was going over it, and like I said, I asked Detective Sergeant Tubergen to follow up on that, so I had a good chunk of it, so I knew what was going on. It wasn't like I was just starting from fresh 8 days ago, so this was just kind of, okay, I got the final thing, and it is a process in our office. I mean, this is, it's my decision ultimately, but I've consulted with, attorneys in my office, I've consulted with attorneys outside my office, I've consulted with people I respect, I think I've done everything I could to be as thorough, and it's, Scripture says that decisions are, best made when they're made in in a group, and I tried to do that.
What do you think the reaction is going to be from people out there on the streets hearing this news?
Attorney Hicks, whether or not it's appropriate to change the name.
All right, well, that came out of nowhere. That just ended like that. That's crazy. All right, so that's the charges. Second degree, he faces life with the possibility of parole. All right, let's go to... this one next.
In the week... In the week since the deadly shooting, we have learned details about both men's backgrounds, Chris Schurr and Patrick Lyoya. Target 8 investigator Susan Samples shows us.
At 8:11 this morning, officer initiated a traffic stop.
Hey, stay in the car! Stay in the car! The final minutes before the fatal shot, dissected again and again. But what of the lives these two men led before? A 26-year-old from the Democratic Republic of Congo who spent years of his adolescence in a refugee camp fleeing violence. 31-year-old Christopher Schurr grew up in West Michigan, graduated from Byron Center High School, became a record-setting collegiate pole vaulter.
Just an outstanding young man.
John Riley retired from GRPD in 2015, the same year Christopher Schurr signed on with the department.
He could go anywhere and do anything he wants in his life and just chose to be a police officer here in Grand Rapids and just try to make a difference with the community.
Riley said Schurr tried to make a difference internationally, too, made multiple mission trips to Kenya, even married his high school sweetheart there. After 7 years with GRPD, Schurr's personnel file shows 2 minor reprimands, one for failing to document damage to a safe and another for backing up unsafely, striking another vehicle. But the bulk of his record reveals a dedicated and driven officer, commended 14 times for his proactive and diligent policing. Half of the awards stemmed from traffic stops where Schurr found illegal guns in the vehicles.
He didn't stop the car to kill anyone.
Patrick was a human being. And Patrick life mattered.
He was his parents' firstborn, the eldest son, described as warm and loving, willing to do anything for family and friends.
Good heart, help, even if he doesn't have it, he's gonna give to you.
His cousin said Lyoya checked in on him often, was always the first to welcome new refugees. Lyoya loved soccer, holidays, making people laugh, and teaching them to dance.
I still don't believe that he's gone.
Friends say Lyoya worked factory jobs, delivered DoorDash, and stayed in close contact with his 2 young children.
Patrick was a very strong boy. He was a hard-working guy.
People with good hearts, they don't last longer.
Lyoya struggled to stay out of trouble. On that April morning, there was a warrant out for his arrest on a domestic violence charge. He had prior arrests related to stolen property and drunk driving, including this traffic stop on 131 a year before he was killed.
You know why I'm stopping you? You're driving 45 miles an hour and you're swerving all over the place.
Lyoya complied with directions.
I think you see right there, don't move, please. Thank you.
And the trooper later drove him to jail.
You guys got to sober up and then you'll be on your way.
They say that don't judge a book by cover.
Lyoya's cousin said you can't judge a person by his mistakes, and no matter what Lyoya's criminal history, he did not deserve to be killed.
Watch the video. Even you can be arrested 100 times, still they can kill you.
Our top story at 5 today.
All right. So we have that one. Just giving you a little background on everything here. And again, we're not doing this to upset anybody. We're doing this because we don't shy away from cases where it may make us uncomfortable. We do this because we feel the victim needs a voice. You know, that's why I do this. The victim needs a voice. All right, well, let's rip the Band-Aid off. This is the raw footage. Let's just rip the Band-Aid off. If you guys need to look away, let's just, if you need to look away, this would be the time. I understand if you need to look away. This is going to be difficult, but we need to understand.
Now you say he's good, but man, yo, what's up, man?
Stop. Okay. Stop resisting.
No, you good, you're not resisting nothing, bro. Come on, man, get the key. Come on.
That was the sound of a taser discharging.
Let's call the taser. Let's call the taser.
No, like he's good. Like you can talk to him, bro. Yeah. Like he's good, bro. Like can you talk to him like good, like can you? Yeah. Stop grabbing him like that. No, he's good like for. Yo, you hear him too.
Let's call the taser.
No, he ain't grabbing the taser. I see that.
Let's call the taser.
6010, how many cars you got going?
Drop taser.
Everyone.
Should have given more warning, but this is the second point where the fatal gunshot will be heard.
Yo, you hear him too.
Let's call the taser.
No, he ain't grabbing the taser. I see that.
Let's call the taser.
I see the fatal gunshot in 10 seconds.
6010, how many cars you got going?
Drop taser. Get back. Get back! 1915, I was just involved in shooting Nelson Grant.
This is video from the Grand Rapids police officer's body-worn camera. Hey, stay in the car! Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. Do you have a license? Do you have a license? What? I'm stopping you. Do you have a license? What? Do you have a driver's license? Do you speak English? Yes. Can I see your license? The plate doesn't belong in this car. Do you have a license or no? Do you have a driver's license? Yes. Where is it at? Get it for me. The plate does not belong in this car. No. Stop. Put your hand up. Stop. 1915. Got one running. Door top. Stop. 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 Get your hands behind your back! Hands behind your back! Get your hands behind your back! Officer's body-worn camera deactivated at this point.
Hey, stay in the car! Stay in the car!
Nelson and Griggs.
You'll see shortly, well, you won't see it, out of view shortly, the first responding officer for backup is going to arrive. And instruct the passenger of the vehicle to walk backwards.
Suspect down. 1920, I've seen it.
1950, that's my taser.
That sound was a taser discharging.
Let's go, taser!
In about 10 seconds, the fatal shot will be captured on this video.
No! Let's go, taser! Let's go, taser! Stop, taser! Get back! Get back!
All right, there's a lot to unpack there. We could probably talk for 4 hours just on the video alone. I'm not going to stay too long on it. I do see your comments, and it's tough. It's tough. So many things that both could have, should have done, And it just came together in a perfect storm, unfortunately. What would you guys do if you were either one of them? What would you guys do? Would you not resist? Would you not run? If you're Patrick, if you're Schurr, what do you do? You know, he's fighting for his life at that point in time. You know, I personally don't think he should have shot him in the head. I don't think Patrick should have been resisting, but he was. He clearly is on his back, so he's got the position of dominance. He could have very easily shot him in the shoulder. That would have incapacitated Patrick for sure. But then he doesn't know if his friend has a weapon. And it's interesting, his friend didn't even really react, right? He's videotaping this, and his friend doesn't really react. Like, if that was my friend that just got shot, that was odd. I thought that was an odd way that he reacted, meaning he didn't react. I don't know. I thought that one was weird. But what are you guys saying? Psychosaurus Rex. I mean, I never run or resist law enforcement. I don't even like seeing them in the grocery store in uniform. I get anxious. I can't imagine trying to run or fight back. Yeah. Cleverly Twisted. I'm here in Grand Rapids, and I just fear the riots that may occur after the trial. They're there. Sharpton's there. Crump is there. You know, they're there. And they have every right to be there. Lily Wayne, don't resist, don't run, stay in the car to start with. Curvial, yeah, sadly, we cannot see what happened at those final seconds before the shot. For all we know, he had the taser and was about to use it, or was trying to use it. Something caused him to grab his gun. Well, he says drop the taser. So Patrick got a hold of the taser. So he says drop, Schurr says drop the taser a couple times. Mike W., at what point is the cop fighting for his life? Is he wrestling with the man that tried to flee, but the only person carrying a lethal weapon is the cop? Well, when you're in hand-to-hand combat, and Patrick clearly grabbed the taser because he says, Schurr says many times, drop the taser, drop the taser. So he pulls out his gun. Patrick had no desire to just lay there, and he was wrestling, so he could have very easily gotten the gun from Schurr, I think. So that's why I think it was a life or death struggle for both of them. Dana, it's easy to say, where do you shoot? That's a high stress situation. 100%. Yeah. I mean, yeah, I got the luxury of being the armchair, court watcher. So that's why I think maybe more education training is required. You know, I don't know what kind of training these officers get on a, daily situation, but if you're on somebody's back and you pull a gun on them, do you have to shoot them in the head? Or can you shoot them in the shoulder? I mean, he clearly had the upper hand. So shooting him in the shoulder, who knows what that would have done? I don't know. I just don't know. I don't think there are any answers, to be quite honest. Sadly, there are no right answers or whatever. Special K, I'm teaching my teenage son never argue with authority, even if you think they are in the wrong. It's a weird line to walk, because then there's people that impersonate officers and they pull you over. There's a story the other day I think an ex dressed up as ICE and went to her ex's new girlfriend's place of work and said that she's being deported. Come with me. And the woman went with her. And then she said she got suspicious when they pulled into a parking lot or an apartment complex. there's people impersonating cops all the time. It's just crazy. I don't know if he stole the car. We don't know that yet. We'll find out in the course of this trial, but the license plates did not match the car. So I'm not sure how the officer figured that out. I guess he ran the plates and it came back. It was a different style car. I guess that's how it came back. I guess that's what happened. But he also had a warrant out for his arrest for DV. So, all right, let's be kind to each other, guys. I see it's starting to get a little chippy. Let's just be kind and courteous. Nobody's attacking anybody, and it has nothing to do. Okay, so please just be respectful of each other. If you need to step away, please step away. Okay? Golden Girl says, didn't appear he had a license. He said the license plate didn't match the car. That's what he said. If you guys need to step away, please step away, okay? Do not attack each other, okay? We will put you on timeout, okay? Do not attack each other. Please be adults. I know this is very, very emotional. I get it, but we're doing this for Patrick. We're doing this so that his voice is heard. And if you guys need to step away, step away. Do not attack each other. Okay, I'm going to leave it at that, okay? All right. All right, let's move on. And we found this trial because we thought that you guys could handle it. So please show us that you guys can handle a trial like this. Okay? I know it's going to be difficult, but show us that you can handle this trial or a trial like this. Terry, the trial starts Monday. Jury has been selected and seated. The trial starts on Monday. Thus, we are doing the pretrial prep. All right, so we're going to continue on. We have a lot of preliminary hearings. We have, this is the defense attorney. This might be Mr. Crump. We'll find out. I think he's representing, no, I'm sorry. No. He's not. Sorry, hold on. All right, this is the defense attorney. I was wrong at that statement. I apologize. All right, so this is Schurr's defense attorney.
You've all seen the video. You've seen all the steps that Officer Schurr took along the way. And when we have a trial in front of the jury with all the evidence after we have a chance to review it, we feel very confident that a jury will find him not guilty.
So far, the media coverage has been one-sided. How prepared is Christopher Schurr? How much is he ready to tell his side of the story? And how ready are you to tell that story as well?
He certainly wants his day in court, and that's what this process is, and that's what we're doing now. I understand all the attention to the case. He understands all the attention to the case. He understands the media's role in this, and now we're looking forward to having the process go forward as it should in the court of law. So then it starts with the prelim. We haven't got to a trial yet. The judge hasn't bound it over yet, so he's still technically, those charges haven't been affirmed by the court yet to be bound over to the circuit court.
When he does appear in court, how do you plan to handle that with all of the attention that this gets?
The court issued a management order. I think that perhaps that will carry over into circuit court. I don't know.
What does that mean for people who don't know?
The court issued a management order that this court wants to maintain control of the courtroom. There can't be any outbursts. There's certain things that they don't want any signs or things that aren't normally in the process are going to be excluded from the courtroom. It doesn't mean people can't peacefully protest outside the courtroom, but that's hopefully how they can maintain order. And Officer Schurr, he'll be here when he's required to be here. He's looking forward to his day in court. Obviously, he has a lot of supporters as well, and we hope that everybody just maintains a sense of decorum so the process in this country, the system of justice, can play out and not turn into some sort of sideshow outside the courtroom.
You've been to the 61st District Court a million times, I'm sure. How often has this type of thing happened, where they've done something like this with management to this scale?
I've seen it in several other cases. I don't know about 61st District Court, but I've been on other cases where the courts have just reminded those that are in attendance that while they have a right to be there, it doesn't mean they have a right to interject in the proceedings when the proceedings are going on. And that's all the court's trying to do, is make sure it's a fair process for both sides and that Officer Schurr gets his day in court without any distraction from any outbursts. That's all the management order is. Everybody's still allowed to be in the courtroom. There's a limit. It's a small courtroom, so you can't have people standing everywhere. And you can't have any sort of outbursts or public display of any verbal display as well.
He got bonded out a couple weeks ago. How's he doing? Have you spoke with him? How's he doing personally?
He's doing as well as you can be expected under the circumstances.
You guys obviously disagree with the second-degree murder charge. Do you think political pressure played a role here?
I don't know. You'd have to ask the prosecutor that.
Forgive me if you've answered this question already, but do you think that this case should be tried here or moved to a different county or courthouse?
That remains to be seen. Well, we may make a decision on that issue.
And as far as the plea bargain or anything, do you intend to take this to trial all the way?
We intend to take this to trial. Thank you.
Thank you very much.
Thank you.
All right, so that's that one. That's his name is I just dropped it in there. Michael, what's his? I'm sorry, Matthew Borgula. That's the lead defense. He's a partner at SBBL Law, 4 former assistant U.S. attorneys and former FBI special agent. So he was the. All right. So that was Matthew Borgula. I'm going to go with that. That was his last name. All right. So here is another one. This is 2 minutes long. I'm just kind of giving you. We're going to get into the pre-trials soon, but we're just going through this first and foremost.
Tonight, police also giving us a... Tonight, police also giving us a closer look at Officer Christopher Schurr's file. We took the documents to former Detroit Police Chief Ike McKinnon.
What I noticed that he does a lot of stops.
Schurr's file had several awards and letters of praise from his superiors for stops he made where he was able to get guns and narcotics off the streets.
If you look at this on his face, it appears as if the officer is doing a great job with stopping people, with recovering guns, recovering narcotics off the street. There was nothing that I saw in his file that said that he was doing anything that was egregious or was stopping people unwarranted.
Michigan State Police sent the case to the Kent County prosecutor, Chris Becker, yesterday. Becker says he's still waiting for a forensic report from the maker of the body camera and the taser before making a decision on if that shooting was justified. You can listen to the recordings and read the full incident reports inside the story at woodtv.com. Brian.
Officer in court, Christopher Schurr.
We begin this afternoon with breaking news from Grand Rapids. Police releasing video of that officer-involved shooting that sparked protests across the city. Thank you for joining us today at 5. I'm Glenda Lewis.
And I'm Brian Abel. There are growing calls for justice tonight in the death of 26-year-old Patrick Lyoya. Police releasing 4 different pieces of video from the incident. Dash cam video from the officer's cruiser, body cam video, home surveillance video from the neighborhood, and cell phone video from the passenger in the car.
What started as a traffic stop for improper license plate quickly turned into a struggle between the officer and Lyoya. The officer and Lyoya appear to be struggling over a taser. The fatal shot was fired as Lyoya was on the ground.
7 Action News reporter Jim Kirshner is live for us in Grand Rapids tonight. Jim, you were there as that video was released during the press conference. What are city leaders telling you?
They're saying they want to be transparent in this case, and as you guys just outlined, the family of 26-year-old Patrick Lyoya actually saw this video last week and said at the time in this community that it showed him down on the ground, face down, getting shot once in the head, killing him. They were absolutely correct. And now that everybody is seeing this video, they're all asking, was this much use of force actually needed?
There will be understandably expressions of shock, of anger, and of pain. We acknowledge that this is a necessary process.
There are 4 angles on 9 videos that are part of this case. The traffic stop was for an improper license plate on a car. Bodycam video on the officer shows he asked Patrick Lyoya for a driver's license. Lyoya tries to run off, resists being detained.
1915, got one running.
The officer pulls out a taser, and there's a struggle over that goes about a minute and a half. The officer deploys the taser twice, but it does not hit Lyoya. After about 3 minutes or so, the officer pulls out his gun. One shot ends it all, ends Lyoya's life.
The test is going to be whether in the view of a reasonable police officer, whether that deadly force was needed to prevent death or great bodily harm to that officer. That's the test which will be used for the policy.
This incident is under investigation by Michigan State Police, working with the Kent County Prosecutor. The officer's name is not being released. He has 7 years on the job.
Foot pursuits, things like that, when to de-escalate, that's something that we train heavily on.
But that's that officer's discretion at that point. In other words, he could have stopped.
Consistency with the officer's training.
And he could he have stopped, is my question.
That's a policy conclusion. I'm not going to come to a conclusion until I know all the facts of the case.
Now we're going to have much more on this coming up next hour at 6. People here are calling this a sad day for this city, Grand Rapids, a sad day for the state of Michigan, a sad day for the country. Put that into perspective. What does it mean with this case moving forward? Brian and Glenda will have that part of the story for you right here next hour at 6. Live in Grand Rapids, Jim Kurtzen, 7 Action News.
And Jim, we appreciate you asking the difficult but necessary questions of the chief. Thank you. We'll see you at 6. And Governor Gretchen Whitmer releasing this statement following the release of the video. It reads in part, "The Lieutenant Governor and I spoke with Patrick's family, and our hearts are with them and the Grand Rapids community who are dealing with the unimaginable pain and loss. Patrick's father asked me to convey his hope that any demonstrations in his son's honor remain peaceful, and as governor, I share this view."
Well, joining us right now is former Detroit Police Assistant Chief Steve Dolan, and thank you for joining us tonight, Steve.
No problem.
Yeah, we always appreciate hearing your perspective, and particularly in cases like this. You've seen the video. We've all seen the video. What are your thoughts as a former assistant chief?
I find it troubling that anyone has to lose their life. From an officer's perspective, he did deploy the taser twice, which is good. Unfortunately, he missed both times. Then I hear him saying, "Let go of my taser, give me my taser," something to that effect. At which point you can see him reaching for his weapon, and then the fatal shot is fired. Jim asked the question, could he have stopped? Could the officer have stopped the interaction? Again, you have to go to the state of mind of the officer. Do you wonder if the guy had a weapon? The guy had his taser. The guy would use his taser. He could disable the police officer and get his gun. But again, state of mind of the officer.
Right. I mean, and to see this video, I mean, he's on top of his back. You know, he reaches back as he has him detained with one hand and pulls out a gun and shoots him in the head. How does that come together in terms of state of mind?
State of mind coming together, it's a difficult thing to assess. He makes an initial traffic stop. It is for a misdemeanor. They qualify that. The individual, I don't know if he has warrants or not, tried to escape, struggle ensued. The officer's trying to detain him, calling for backup. Apparently there's no backup available. Struggle ensued, kept going. He did say, you know, or I think he said, "I'm going to taser you." I'm not sure. Fired it twice. People have to understand that both he and the victim are struggling. He did have him with one hand because technically you're only supposed to fight with one hand, because if you fight with two hands, you lose your gun. If that goes to state of mind to the officer and he feels he's in fear of his life, okay. The victim is just trying to get away. It's tragic. It'll be interesting to see what conclusions they come up with as their fatal force policy. Detroit had a force continuum policy, so we'll see if they use that. It's tragic.
Yeah, hard to see.
Very hard to see. Very hard to see.
Assistant Chief Dolan, we always appreciate you. Thank you so much for being there for us and about this.
Thank you.
All right. And please stay with us on air and online as we continue to follow the deadly police shooting of Patrick Lyoya.
All right, now we're going to get into court. So now the next bit is going to be. Wait, hold on a sec. Okay, yeah. So now we're done with the videos of the incident and the news reports, the charging, the press conference. Now we're going to get into the preliminary hearings and all that stuff. So, yeah, LEB, it's easy to say for us. Victim should have complied. Cop shouldn't have shot. I mean, it's like, it's going to be one of those, what side are you going to be on? Cop should have shot him in the shoulder. Patrick shouldn't have resisted. It's we've seen too many things that, once you start to resist, it's never going to end up good for you, unfortunately. So it's sad. It's sad all the way around. Hey, Krista, thank you for joining us. I see some new people have also joined us. I haven't said hello to everybody, but I do see you coming in and watching this trial. This is going to start on Monday. Jury has been selected and seated. It is going to start on Monday, and we will carry it, and we'll see what happens. All right, so this next one is 3 minutes. Let's see what this is. Hopefully we'll like this judge. Let's see what we got. I'll try and find out the judge's name.
All right, 22 FY0827, the State of Michigan versus Christopher Schurr. If we could have appearances for the record.
Chris Becker, people.
Good morning, everybody. All right, for the record, the court has previously acknowledged the substantial public interest and media attention in this matter, and in order to accommodate that, the court is using YouTube to broadcast this hearing. The YouTube is live at this point, so anyone with interest or media not able to make it inside the courtroom would be able to access that, and the court will, I'll add at this point, it doesn't appear the courtroom is completely full at this point, so there is room for, I would think, for some physical access to the courtroom as well. The court will also add for the record, and I'll mention to counsel, the court did issue a courtroom management order yesterday, and counsel, you both received that?
We did, Your Honor.
Okay.
We did, Your Honor.
All right, very good. All right. The rule that was filed by defense counsel and signed by defendant and defense counsel and the prosecuting attorney. And so my understanding is there will be a brief adjournment of the preliminary examination that's currently set for next week.
That's my understanding, Your Honor. I think it's set for July 18th at 8:30, and parties are agreeing that day works, and we'll set for preliminary on that day.
Okay.
That's our understanding as well, Your Honor.
Very good. All right, is there anything else we need to address then today?
I think we are. Not from the defense, Your Honor.
Okay, then we'll see everyone July 18th at 8:30 a.m. and the courtroom management order, of course, will continue and would govern that hearing as well. All right? All right, thank you, everyone.
All right, that was quick. Next one up is the bond arraignment.
Please.
Yeah, bond arraignment.
Please rise. This court is now in session. Honorable Nicholas A.U. presiding.
Thank you. You may be seated, everyone. Good afternoon.
Good afternoon.
All right, the court will call the matter, case number 22FY0827, the State of Michigan versus Christopher Schurr. If we could have appearances for the record.
Mark Dodge on behalf of Officer Schurr.
Matt Perdula, on behalf of Officer Schurr.
John Hamilton on behalf of Officer Schurr.
David Dodge on behalf of Officer Schurr.
All right, good afternoon, everyone. Good afternoon, Mr. Schurr.
Good afternoon.
All right, you can hear everything okay? Your counsel are here physically present in the courtroom.
Yes, Your Honor.
All right, very good. Mr. Schurr, it is alleged that on April 4, 2022, that you did with the intent to kill or to do great bodily harm or to act in wanton and willful disregard of the likelihood that the natural tendency of said act would cause death or great bodily harm, kill and murder a Mr. Patrick Lyoya, and that the act was committed without premeditation or deliberation. That, if true, would constitute the felony offense of murder in the second degree. It is punishable by a maximum of life incarceration or any term of years. Do you understand the charge and the maximum penalty associated with the charge?
Yes, Your Honor.
And you had a chance to talk to one of your attorneys, Mr. Dodge, one of the other attorneys, about your rights?
As of today, I have not.
All right. Have you reviewed the felony advice of rights form?
No.
Mr. Dodge, have you had a chance to talk to your client about his rights?
No, Your Honor, because of the issues here with where Mr. Schurr is housed, we have not been provided those yet or had the opportunity. So it may be wise, Your Honor, to go ahead and review those in court.
Very good. All right, Mr. Dodge, number one, you have the right to remain silent. You have the right to be presumed innocent until proven guilty. You have the right to a trial. And at the trial, you have the right, you have a number of procedural rights. You have the right to call witnesses to testify on your behalf. You have the right to cross-examine witnesses that are called against you. You have the right to ask the court to compel witnesses to come in and testify on your behalf. Are you familiar with the rights that you would have at a trial?
Yes, sir.
All right. Very good. And Mr. Dodge, are you satisfied that your client understands his procedural rights at this point?
Yes, I do.
All right. Very good. Then I will advise everyone that the matter will be set for a probable cause conference that will take place on June 21, 2022 at 9:30 a.m. And if necessary, a preliminary examination will be held on June 28, 2022 at 1:30 p.m. The court notes the defendant's not guilty status. Finally, as to the matter of pretrial release, the court would first like to hear from court services.
Thank you, Your Honor. Article 1, Section 15, preventative detention does apply as the defendant is being charged with a capital offense. Therefore, the court may deny pretrial release. However, court services is not opposed to a cash or surety or a 10% bond, as there is no risk of flight, and in fact, Mr. Schurr did self-surrender. There is also no prior criminal record. He is a lifelong resident of the Kent County area with strong, supportive family ties. There is no known history of substance abuse and also no known mental health issues. And there is a willing co-signer for bond if that were to be requested by the court, along with a stable release address that he also provided court services.
All right. Thank you. Mr. Dodge, did you want to address pretrial release?
Thank you, Your Honor. I know the defense had an opportunity to file a motion for bond, which I understand the court had.
And the court has received that and did have an opportunity to review it.
Thank you, Your Honor. And we would also ask that the court follow the recommendation of court services here and set a reasonable bond in this case. The defense would request, based on all the particulars, that the court consider a 10% bond. As noted, for assessment of bond purposes, Officer Schurr is not a flight risk. He's a lifelong resident of Michigan. Other than some mission trips, he's resided in Michigan his entire life. No prior criminal charge or conviction history. Very stable employment and family, as noted. Your Honor, if there's any question as far as how Mr. Schurr is going to behave in the next, while this case is pending, the court can simply look to the last 2 months since this episode arose, Your Honor, and that's been nothing but cooperation by Officer Schurr and his attorney. So I strongly feel that there's not going to be any risk to the public, and there's no issue whatsoever of a flight risk. As noted, as soon as learning of these charges, Mr. Schurr and his attorneys immediately coordinated. He's surrendering himself to these charges. Your Honor, the defense mentions a couple of generic facts in our bond motion, and I don't plan to get into many more facts today. We'll obviously get to those in future proceedings. But, Your Honor, the defense submits that Officer Schurr on this charge was justified in his use of force in this episode and is not guilty of this crime. And we ask that the court honor that presumption of innocence and set a reasonable bond here. So, based on those factors, Your Honor, we would ask that the court consider setting a reasonable 10% bond.
All right. Thank you, Mr. Dodge. Certainly the presumption of innocence follows along at all stages until there has been a plea of guilty or a finding that the defendant is guilty. Nonetheless, there is the question of what to do with a criminal defendant up until the time that a trial can take place, up until the time that the procedure can be carried out as far as determining whether indeed a defendant is guilty or not guilty. Those things are there to ensure that the defendant will be in compliance with court orders, that the defendant will appear when required. They are not punishments. The court does have to and can, to a certain degree, as long as it is reasonable, which is the constitutional standard, deny certain liberty to ensure that a defendant will appear in court. In Michigan, by Article 1, Section 15 of the Michigan Constitution, certain enumerated crimes, we should say it the other way, the right to bail generally exists. It can be withheld and a defendant held pretrial without bail when they are charged with one or more of the enumerated offenses in Article 1, Section 15. The offense here is one of those. So the first question for the court is indeed whether the defendant is eligible to be released pretrial at all, whether the defendant is bailable. Based on the factors here, particularly the fact that the defendant did surrender or turn himself in, has retained counsel, the defendant has no criminal history to speak of, the court can make the general finding that indeed the defendant at this point in time is bailable. And I will make that determination. The next question then becomes whether, or the terms and circumstances under which the defendant can be released. Our court rules require that the court generally presume a personal recognizance bond unless the court finds that a personal recognizance bond won't reasonably ensure the appearance of the defendant, or that release on personal recognizance presents a danger to the public. Again, the court weighs heavily on the fact that the defendant did turn himself in. And at this point, there is no demonstration of non-compliance. However, the nature of a particular charge itself is another factor that the court considers. And there are certain charges, there are capital offenses, that by the sheer nature that is the charge that the person is facing, elevates the risk, elevates pretrial risk. And I think the court does have to take that into account here. And so while certainly it weighs heavily on the court that the defendant has turned himself in, is in compliance, has no criminal history, those things weigh heavily, but the court also has to consider the charge. And so I don't think that a personal recognizance bond is appropriate under those circumstances. What I do find is that a cash surety bond is necessary, and I will set that bond amount $100,000 cash surety. That will also be subject to a number of special conditions that will be imposed as a condition of pretrial release. We'll order the defendant not purchase or possess any firearms or dangerous weapons while the case is pending. That defendant report to court services or remain under their supervision while the case is pending. That defendant not use any intoxicating liquors, marijuana, or illegal drugs. Undergo substance abuse assessment if that is directed by court services, if that is deemed necessary. And not engage in any assaultive, threatening, or intimidating behavior. Do you understand all those requirements, Mr. Schurr?
Yes, Your Honor.
All right. Mr. Dodge, anything further from your perspective?
No, Your Honor. Thank you very much.
All right. All right, good luck with everything. And again, for the record, and so everyone has it down, the probable cause conference will take place on June 21, 2022 at 9:30 a.m. and preliminary examination, if necessary, will be conducted June 28, 2022 at 1:30 p.m. All right, take care, everyone. Thank you.
Thank you very much.
Stop. Okay, so that was his bond arrangement. So they were able to get him bonded out. This next one's 3 hours and 3.5 hours. So this next one is a preliminary hearing. I almost said herring. A preliminary hearing. All right. Special K, $100,000. So he only had to pay $10,000, and he is out on bond. He was able to pay that. Yep, $100,000, and he was able to post that. All right, so this one is preliminary hearing. Let's check it out.
Please rise. Court is now in session. Honorable Nicholas A.U. presiding.
Thank you. You may be seated, everybody. All right, good morning, everybody. I'll call the case in just a minute. There's only one case on the docket today, people be sure. Before I do that, I want to go over some housekeeping matters. We have a full courtroom today. I want to make sure that everybody is safe, relatively comfortable, and that we can ensure maximum access for the media, for anyone interested in being here, and for the members of the public that can't be in here that would rather be in here. We're at capacity right now. I can see that. We are streaming on YouTube. That is available for anyone who was not able to make it into the courtroom today. That YouTube access can be found on the court's website. I also want to bring to everyone's attention the court's case management order. I think we have a few copies here if you haven't seen it. It should answer all of the housekeeping questions or any of the housekeeping questions anyone might have. That also has a link to the YouTube access point. And so if you pull that up on the court's website, you can get right to the link, and that will take you to the live streaming on YouTube. A couple of important points. Everybody does need to be in a seat and remain seated when the court is in session. Also, traffic in and out of the back doors is very disruptive, specifically when we've got someone on the witness stand. We're all human. We understand that, and nature calls it. That does happen, and somebody absolutely needs to leave the courtroom while somebody's on the witness stand. Then what will happen is you won't be allowed back in until there's a break in the proceedings, either a recess or a change in witnesses. I want to encourage everyone to be patient. Be patient not only with the court and respectful of the court, but respectful and patient with each other. All right? I do want to provide just a bit of an overview for everyone's benefit of the procedure that will be followed today. Here for a preliminary examination. In Michigan, when the prosecutor files a felony complaint, the first stop for the case is here at the district court. The district court is a lower court than the circuit court, an inferior court of the circuit court. The stop here is just a check to ensure that there is probable cause to justify the case going any further, going over to the circuit court. If the court finds that there is probable cause that a crime was committed and that the defendant was the one that committed it, then the case will go to the circuit court for further proceedings, up to and including a jury trial. The issue here is not whether the defendant committed a crime beyond a reasonable doubt. It is a far lower standard. It is a lower standard than even more likely than not. The proceeding itself will look a lot like a trial. The people will call witnesses. They'll examine the witnesses. The defense will have the opportunity to cross-examine those witnesses, and vice versa. When all of that is completed, then the parties will make brief arguments, the court will listen, and the court will make a decision, either that there is probable cause and the defendant should be bound over for the charge as charged, for a lesser charge, or the court could find that there's no probable cause, in which case the case would be dismissed. All right. I hope that gives you a little bit of an overview so you understand where we are, what we're doing, and makes your observation and access to the proceedings a little bit more meaningful. All right, with that, I will call the case 22FY0827, the State of Michigan versus Christopher Schurr. And if we could have all appearances,
Chris Becker for the people.
Good morning.
Good morning, Your Honor. Matt Porgula, Kayla Hamilton, and Mark Dodge on behalf of Chris Schurr, who is seated to the left of Ms. Hamilton.
All right. Good morning to all of you. All right. Before the people call witnesses, is there anything we need to address, counsel?
I don't believe so. I think we've talked it over. I think we're pretty much in agreement on most things, Your Honor. We concur, Your Honor.
All right. Then, Mr. Becker, we'll turn it over to you.
I guess before a witness, though, Your Honor, we do have one that both parties are stipulated with. Dr. Cole is unable to be here, so we have a transcript. On Tuesday, October 11th, we took his deposition in this matter. He's the medical examiner. So we have a complete transcript for the court to review. Part of that is we have People's Exhibits 1, 2, and 3, which are photos from the autopsy. There's also Defense Exhibit A, which is another photo from the autopsy. Both parties stipulate to the use of the court using that in place of Dr. Cole's testimony. Cutting to the chase, I think the manner of death was homicide. This is his opinion. It was a single gunshot wound to the head was the cause. And then finally, I think for the purpose of the prelim, there's a .29 blood alcohol level for Patrick when the autopsy was performed. I think that covers the main points that we want to cover. We get the whole period.
Mr. McGill?
We agree with that summary, Your Honor. We would just add that vitreous alcohol level, the fluid in the eye, was 0.33.
Okay. Very good. All right.
Call Nicholas Colati.
Swear that the testimony you're about to give will be the truth and the truth and nothing but the truth? I do. You may be seated. And you would state and spell your full name for the record.
Sergeant Nicholas Colati. You want me to spell my first name?
Please.
Nicholas, last name Colati, Calati.
Mr. Becker,
So you've already identified yourself as a sergeant. You're a sergeant with the Grand Rapids Police Department?
That's correct.
I'd like to take you back to April 4th of 2022. Did you go to the area of Nelson and Griggs on sometime that day?
I did.
Could you tell the court why you were going there on that day in that area?
A fellow officer at the time called out a traffic stop, and subsequently the traffic stop did not go as planned.
Could you tell the judge exactly how you became, you said the traffic stop didn't go as planned, what drew your attention that it wasn't going as planned?
The officer communicated that he was in a pursuit with the subject of the car.
Did you respond at that point in time and start going towards his direction, or what did you do?
I started going toward the location of the stop.
Did that ever escalate, if you will, or cause greater concern?
Yes.
Could you tell how that happened?
You could hear the tone in the voice of our officer that it has escalated, and then he also communicated that the subject was fighting with him.
Did you, when you initially went, were you going lights and sirens and then switch, or?
Initial lights and sirens.
Initial lights and sirens. Approximately how long did it take to get to the area?
Minute-wise, I'm not sure. It took a while.
Describe the scene when you arrived at the area of Nelson and Griggs.
When I arrived, I could see Officer Schurr's patrol vehicle positioned behind the suspect vehicle. 2 or 3 other officers had arrived before me. They were addressing a unknown suspect vehicle at the time. Then I also had the other suspect in the yard between 2 houses.
Do you have give the judge an idea approximately what time of day was this?
It was morning. I don't remember the exact time.
In the morning, though, before lunchtime?
Yes.
What did you do when you got there?
Basically, I maintained the scene. What first we did is we had to check our unknowns, which was the vehicle that was stopped, if anybody else was in there or anything else. Once that was cleared, we went to go render aid to the subject in the yard.
The subject in the yard, when did you become first aware of a subject in the yard?
In the actual location is when I arrived, where it was, where I could see it.
What did you see? What did you see of that subject in the yard?
I saw a subject between two houses laying on face down on the ground with his arms underneath his body.
Did you see Officer Schurr when you arrived on scene?
I did.
What happened with him?
Upon contact with him, I could see that he was stressed out and was physically tired. At the time, I decided it would be best for him to fall back to my police vehicle.
How did you communicate with him?
I did.
How did that go?
I just asked him to replace his firearm into his holster and go wait by my car.
For purposes of prelim, Your Honor, it's my understanding the defense will stipulate to identification of the defendant at this point in time. That's correct, Your Honor.
Oh, very good. Stipulation.
Did he make any comments to you or say anything to you when you first made contact to him and called him back to your position?
Not right away. Not that I can think of right now.
Where did you go with him after he came back to your position?
He went back to my car, so I was not with him.
Then what did you do after he went back to your car?
At that time, another supervisor showed up and spoke with him.
This car, the car that he had stopped, you recall what kind of car it was?
I don't offhand.
Any description of it?
I just remember that it was a sedan with not a SUV, it was just like a 4-door car.
Okay. Did you do anything in terms of the search of that vehicle?
I did not.
Okay. Did you render aid to the individual who was lying on the ground?
I did not put hands on it. I did walk up to the body at the time, but no, I'm not physically render aid.
Okay. Any signs of life or anything like that when you came upon the body?
Not that I noticed, no.
One moment, Your Honor.
Take your time.
I have nothing further, Your Honor. Thank you, Your Honor.
Good morning, Officer Colati.
Good morning, sir.
So you were not the first one on the scene, correct?
No, sir.
All right. And you responded when you heard a call from one of your fellow officers that he was in distress.
Correct.
And I think you testified that Officer Schurr called out that he was in a foot pursuit?
Yes.
Okay, and on your way over, he also called out that somebody asked, does he have any weapons, meaning the person he was pursuing, right?
That's correct.
And the response was, he has my taser.
That's correct.
Okay. So you're approaching this scene with caution, right?
That's correct.
Because you think there might be a suspect that has a weapon.
Correct.
Because a taser is a weapon, right?
Yes, sir.
Okay, so you were approaching it as if he was armed and dangerous.
That is correct.
And there were other officers that were approaching at the same time?
Yes, sir.
And there were other officers that were already there when you got there?
Yes, sir.
And everybody is approaching the situation with extreme caution, right?
Yes.
They have their weapons drawn or their access to the weapons readily available, correct?
Yes.
And they're clearing the scene?
Yes, sir.
Because they're making sure that the officers are safe?
Yes.
And there were residents milling about, right?
Correct.
And you want to make sure that everybody in the area is safe, right?
Yes.
Okay, so everybody's approaching this scene with extreme caution. Is that fair to say?
That is.
Now, by the time you got there, I think you said there were a couple officers already on the scene. So is 2 about right, or do you think there maybe were more?
I think there's 3.
3. Do you remember who they were?
Sergeant Tim Johnson, Officer Jordan Grace, and Officer Mott, I believe it was.
Okay. And so, did you recall, I think you said that they were addressing whether there was another person in the car.
That's correct.
What did you mean by addressing?
We were calling out the car verbally to make sure that nobody was in there before we walked and cleared to make sure no one was in there.
Okay. And again, the concern is that there could be someone that's potentially going to harm either the officers or bystanders.
That is correct.
All right. So you're approaching this, excuse me, Your Honor, the situation as armed and dangerous because this person you suspect has a taser.
Correct.
And it's the officer's taser.
Correct.
Okay. So you knew that he had disarmed a police officer at that point, right?
Yes.
Okay. And now you know that taser's a weapon because you've been tased before, right?
That is correct.
Okay. How did it feel when you got tased?
Not good.
Okay. Were you incapacitated?
Yes.
Okay. Have you ever been drive stunned before?
Yes.
What does it mean to be drive stunned?
I basically take the taser away from the wires, and it's full contact to the body, straight from the taser itself.
So there's going to be electrodes that come out. That's a cartridge, right?
Yes.
And then there's the drive stun, which if you put it up against somebody, it will inflict some...
It completes the circuit, yes.
Okay. Now, when you were drive stunned, did you feel incapacitated?
Yes.
All right, so you at some point approached who you later learned was Mr. Lyoya, right?
Yes, sir.
Okay. And when you approached him, he was still face down?
That's correct.
Did you or another officer roll him over?
Another officer did.
Do you recall who that was?
I believe it was Sergeant Tip Johnston.
Okay. As he was rolled over, did you see a taser?
I did.
Was it in the position of where his hands were?
Yes.
Okay. Did anybody move the taser or put the taser there?
No.
Okay. So you have no doubt that that taser was in the area of Mr. Lyoya's hands when he was rolled over?
Correct.
You indicated that Officer Schurr was physically tired.
Yes, sir.
Would you say he's exhausted at that point?
Yes.
Okay, and you arrived, you said some time after Mr. Lyoya had been shot, right?
That's correct.
Can you estimate how many minutes it took for you to actually engage with Officer Schurr from the time he was shot?
With morning traffic, I would say anywhere between 6 to 8 minutes, maybe.
So 6 to 8 minutes after the shooting, Officer Schurr was still physically exhausted?
Yes, sir.
Nothing further.
Nothing further, Your Honor.
What is the excuse?
You may. Oh, maybe she may.
Break one of the microphones?
I have some concern about that, but it just fell, it slid down, and I'm playing a game of Jenga here, and I don't want it to...
Gotcha. Thank you. You may be seated. And can you state and spell your full name for the record?
You want me to okay, my name is Eme, A-R-M-E. Last name is Tuyshime, T-U-Y-I-S-H-M-E.
Thank you, sir. Mr. Becker.
Maybe speak in the microphone and speak up a little bit louder. I could hear you, but it probably could do a little bit louder if you could.
Okay, can you hear me?
That helps. That's a little bit better. I'd like to take you back to April 5th. You know Patrick Lyoya?
Yes, sir.
How do you know him?
He's a friend, but like a brother.
Were you with him on that day?
Yes, sir.
Why were you with him that day? What were the two of you doing?
He was hanging out with friends. Just hanging out.
Where were you hanging out with friends at?
Wolfie Apartments.
In terms of hanging out with friends, how long have you been hanging out? Was it all night, part of the night? What were you guys doing?
Yeah, all night, because he was sleeping at night. Then he woke up in the morning early.
So when you woke up in the morning, what did you do?
We have to take one of my friends home.
You had to take all your friends home?
One of my friends home, yeah, one of them.
Who is that friend?
His name is Mar.
And how did you take that friend home?
How?
How?
With Patrick car. With Patrick car.
Patrick what?
With Patrick car.
Patrick's car.
Yes, sir.
So Patrick drove?
Yes.
Drove the three of you?
Yes.
And so did you drop off that friend at his house?
Yes, we did.
After you drop off the friend at his house, where did you go?
We stopped by Patrick's friend, a new place he just moved in. Who was outside just talking about the place.
So you're supposed to move in a new place. He was kind of showing you off his new place?
Yes, he already been moved in. It's just my first time seeing it.
So after you see his new place, what did the two of you do?
We just took off. We took off.
Took off?
Yes.
Where did you go?
Don't remember exactly where it was going. We just took off before.
So you're essentially just driving around?
No, not driving around. I just don't remember where it was going.
But in terms of, but you're back in the car. At least you're driving.
Who?
After you left Patrick's place, are you driving in the car with Patrick?
Yeah, I was in the car with Patrick.
And as you're driving with Patrick, did you stop again?
Yes, we did.
Why?
We had to get something to drink.
So where did you stop to get something to drink?
I don't remember because that area I don't go to a lot. I just don't remember. By Walgreens, something like that.
By where?
Walgreens.
By Walgreens, okay. Do you actually get something to drink?
Yeah, we did.
What did you get to drink?
Budweiser.
A Budweiser?
Yes, sir.
Now, at this point in time, is this in the morning?
Yeah, it was in the morning.
Why are you getting a Budweiser in the morning?
Don't remember why. We just grabbed them.
So after you get the Budweiser, do you get back in the car?
Yes, sir.
And you start driving again?
Mm-hmm.
You have to answer
yes,
yes.
Sir. Yes,
that's
sir.
just a recording.
Sorry.
That's okay. So as you're driving again, do you stop after that?
Where Patrick car was making noise.
What kind of noise?
It was something in the back. It was like real bad. So he turned right somewhere, and then he parked the car. He was about to go check what kind of noise the car was making.
So you think you're having car trouble, and so he stops the car. Does Patrick say anything?
Yeah, he did. He said, "Why my car?" Because I can hear it was very loud, so I can hear that. Why is my car is making noise?
Does he say he's going to stop and check it?
Yeah. Yes, sir.
So describe what happens when he stops. What happens?
So I was on the phone. I don't know exactly what I was doing, but I can hear the noise. So he used the F word and then say he want to go check his car. So once he get out the car, I didn't know. That's when I saw police. I didn't even see police, but that's when I saw police officer and him, both of them going back and forth.
So describe that for the judge in terms of, so you're on your phone. When do you first notice there's a police officer there? Is it after he gets out of the car?
Yeah, because I didn't know. Yeah, once he get off the car, yes.
Where do you see this police officer?
He just on his drive side, like he was going back forward with Patrick.
So you see the police officer on the driver's side. Can you tell what's going on between Patrick and the police officer?
They were just because I was on the other side as a passenger. I could record a conversation they was having. I know they was going back and forth.
All right. So what happens after they go back and forth?
Patrick, they was going back and forth, and then around the car, they went by the house. So I saw something was going on. It was very serious.
What do you mean they went by the house? Can you describe for the judge what you saw?
Okay. That's when they started going back and forth and found the car, and then they went by the house and they started by the house. So at first I was just sitting in the car. Okay, so when I see him in the office, I started wrestling. I know something was wrong, so that's when I get off the car and then took my phone and then started recording.
Okay. I want to make sure that I understood you say you saw the officer and Patrick wrestling?
They was going back and forth. Yes, sir.
All right. And they were wrestling over by the house. And
In front of the house, yes, in front of the house.
So why did you get out of the car?
It looked something was wrong.
So when you get out of the car, what do you do?
I get out the car and then I took out my phone.
And what do you do with your phone?
I recorded the video you guys saw. I don't know if some of you guys saw it.
Okay, so you start recording what's going on between Patrick and the officer.
They're still going back and forth.
Okay, so they're still going back and forth when you start recording?
Yes, sir.
Okay, if we play at this point in time. Your Honor, we've marked for Exhibit 4, which is actually a flash drive with a number of different videos on that. I believe the defense has stipulated to the admission of Exhibit 4. That's correct, Your Honor.
All right, very good.
So within Exhibit 4, we have the passenger video.
So we're calling that the passenger video?
Within Exhibit 4. Exhibit 4 passenger video of this. I don't know, is that going to pull up on... Maybe you hit play here.
Kids, I'm reaching back, okay?
Yeah, you good. Don't bring him like that, though.
I want to pause real quick. Can you see this video? Are you able to see this video?
I'm looking at it.
Okay, I just want, is this the video that's on the screen, is that the video you took?
Yes, sir.
Okay. Can you play it some more?
Yeah.
1915, turn one more car.
Man, it's good, man. Great, yo, what's up, man?
Stop. Stop resisting.
Now you good, you're not resisting nothing, bro. Okay, why you gotta do all that, bro? He good, man.
Let go of the taser. Let go of the taser.
No, he good, like you can talk to him, bro. Yeah, like he good, bro. Like, can you talk to him like good? Like, can you, yeah. Stop burying him like that. Now he good at it, bro. Yo, you hit him too.
Let go of the taser.
Now he ain't brought no taser. I see.
Let go of the taser. Stop the taser. Get back. Get back.
Now, you could hear your voice during some of that. You're saying he's good. Can you describe what are you saying? Why are you saying that?
All that taser was going on, and then I remember like we were told that he's at the office.
I'm sorry, I didn't understand you there.
I remember like Patrick saying like he said okay, so that's why I just remember okay.
Do you remember Patrick saying okay?
Yeah.
Do you remember Patrick saying anything else?
No, I'm done recording.
What was going through your mind as you're recording this? Why are you Why are you yelling out what you're saying as we hear on the video?
Because again, I knew something was wrong.
After the video stops, after the shot is fired, what do you do?
Well, the officer said, move back. So I did move back.
So you moved away and stepped back.
Mm-hmm.
Did you go back to your car?
No, I did not.
What did you do?
They came and grabbed me, put me in handcuffs.
Who came and grabbed you and put you in handcuffs?
It was officer.
The police, after more police officers showed up?
Yes, sir.
Not the original officer on scene?
Yes.
Not the officer that was involved with
I don't remember if it was him or not. I don't remember.
Okay, but just other officers came and put you in handcuffs?
Yes, sir.
You talk about you were drinking Budweiser. Were you drinking before you and Patrick left?
No, I was, but Patrick was sleeping.
Okay. And you drank earlier that night then before you went to bed?
Yes.
Okay. Do you know how much you had to drink the night before?
No, I don't know because just friends sitting down. I won't keep in the account, so I mean he was drinking.
I have nothing further, Your Honor.
Good morning, Mr. Tuyashime.
Good morning.
Am I pronouncing your last name correctly?
Yes, sir.
Please let me know if I don't.
Okay.
So you said that you have been friends with Mr. Lyoya?
Yes.
All right. What did you call him when you talked to him? I mean, what name would you call him?
I'll call him Patrick.
Patrick. Did you know his last name before this incident?
No.
No. So you didn't know his last name?
Yes.
But you considered him a friend, right?
Yes.
Okay. But not well enough to know his last name?
No, I was interested. I just called him Patrick.
Okay. You would text him occasionally?
What you said?
You would use your phone to communicate with him?
No, I don't remember. I had my phone in my hand. I don't remember exactly what I was doing.
I meant in general, not just that day. Mm-hmm. But have you ever texted Patrick before?
I don't recall it.
I'm sorry, I didn't catch that.
I don't remember.
You don't remember if you ever texted him before?
I called him, yes.
Okay, well, maybe I'm saying the wrong word. Did you ever use any form of communication on your phone to communicate with Patrick?
Yes, I have it before, yes.
Okay, and what forms of communication did you use?
What form did I use?
Text, WhatsApp, maybe?
Oh, just text.
Just text, okay, so just the phone. And you said you've known him a couple of years?
Yes.
All right, but all that whole time you never learned his last name?
We don't watch your name, Patrick, or I don't ask extra name of it.
Okay. So on the morning in question, you testified, I think, that you were drinking, correct?
Yes.
And Patrick was drinking?
In the morning?
Yes.
When we were working, my people were sleeping.
In the morning, right before the incident, right before you were filming, Patrick was drinking, right?
Because the beers were still full, so I don't remember if he was drinking or not.
You don't remember if he was drinking or not?
Yes, I do remember him drinking, but we had Budweiser in the car.
You had Budweiser in the car?
Yes.
Okay, were you drinking Budweiser in the car?
I was.
You were, but not Patrick?
No, I don't remember, because just did too much going on.
Okay. Now, you've known him a couple years, you know him by Patrick, you drink together?
Yeah, we hang out together, not just drinking. We hang out. Went to his birthday and everything.
You went to his birthday party?
Yeah.
Were family members there?
I think his girlfriend and his brother came.
How often do you drink with him?
I don't want to use to drink with him. He might give me a ride to work. If I don't have a car, I don't drink before work. So I don't want to use word drinking. Every time we link, we didn't have to drink and hang out.
All right, so on the morning in question, April 4th, that's the day that you took the film on your camera.
Yes.
I want to back up to the night before, April 3rd. Were you with Patrick on April 3rd?
Yeah, because he was at the house. I remember he came, we hang out, they went to sleep. So I don't know how to answer that exactly, if I was with him all day.
Were you with him at any point on April 3rd?
Yes.
Okay. You said you woke him up on April 4th?
No, not me, somebody else did.
Who woke him up on April 4th?
I don't recall it.
You don't remember?
Yeah.
Where was he when he was awakened?
At a friend's house.
Whose friend?
David.
I'm sorry?
David.
David?
Yes.
What's David's last name?
Bukuru.
Can you spell that by chance?
Bukure. I spell it right.
So the night before, April 3rd, were you in Patrick's presence?
Yeah, we was hanging out together.
Okay. Were you hanging out at David's house?
Yes.
And you were drinking?
I was.
You were drinking?
I was.
You were drinking. How about Patrick? Was Patrick drinking?
Yeah, we hanged out, but he went to sleep. Of course, before he went to sleep, yeah, he was drinking like that, I think. But he went to sleep because I remember everybody was kind of drinking.
Okay, so he wasn't drinking while he was sleeping, right?
That's not possible, drinking and sleeping.
It's not possible, right? Was he drinking before he was sleeping?
Yeah, I think so.
He was drinking a lot, right?
I wasn't. I'm not his counter to count how much he was drinking.
He was drinking Budweiser?
I think he liked Budweiser.
He liked Budweiser?
Yeah.
And you like Budweiser too?
Yeah, sometimes.
Okay. And on April 4th, you guys went and got Budweiser?
After we dropped my friend off.
Okay. Well, who is your friend that you dropped off?
His name is Mark.
I'm sorry, could you repeat that?
Mark.
Mark?
Mark.
I'm sorry, can you spell it?
A-M-A-R-K, something like that.
M-A-R-K?
Yeah, Mark.
Mark, okay. Do you know Mark's last name?
No, I don't.
I'm smiling because your attorney's behind you and his name is Mark, but he wasn't there, right?
No, he wasn't.
Okay. Do you know Mark by any other name or last name?
I just call him Mark. Like when you don't ask really what's your last name or where you was born, we just.
All right, so he needed a ride to work on April 4th, right?
To work?
Yes.
Who, Mark?
Yes.
No, you have to take his baby.
Oh, you take his child?
Yeah.
He had to take his child to work?
No, not to work. When we drop him off, he said gotta drop him off at home so he can take his baby to school or something. I don't know.
All right, so I thought you testified that the reason you were in a car driving around, at least in part, was to take Mark to work. Is that not right?
No, we had to drop him off at his house.
Okay. And where does Mark live?
Madison, somewhere around there.
Was Mark present the night before?
Yeah, he was with us.
Was Mark drinking?
I don't remember because I don't remember.
You don't remember because you were so drunk?
No, I just don't keep accounting who's drinking or not. It's not my job.
Who else was present on April 3rd at the house?
Ben, David, Matendo, I think.
I'm sorry, what was the last one?
Matendo.
Matendu?
Do.
Anybody else?
I think that was it.
So it was all men?
Yes.
And this is all at David's house?
Yes.
What time did Patrick go to sleep?
Very man.
Was it before midnight or after midnight?
I wasn't checking the time. I just don't remember what time I took it. So.
Did you sleep there?
No.
Where did you sleep?
I was still up because we started just listening to music and I was just still up still. I didn't sleep over there.
So you went all night long?
Yeah.
Okay. And you were drinking all night long?
No, just some grab a beer, put it down, talk to a friend. Just.
Okay, so Patrick, you said he was drinking and then he went to sleep. It's not like he went to bed, right? He passed out.
No, he went to sleep on the couch because he had a blanket on. He did not pass out.
Did he have his clothes on still?
Yes, sir.
And so he's sleeping on the couch, fully clothed, right?
Yes, sir.
And somebody threw a blanket on him.
I think he asked for it.
Did you drive around at all before you and Patrick got into Patrick's car?
No.
Okay. So the first, and let me rephrase that. You're up all night, right? And you're not really keeping track of what time it is. Is that fair?
Yes.
Did you and Patrick go for any rides before 8 a.m.?
No.
You don't remember? You guys didn't go driving all around town after 7 o'clock for about an hour?
Like I said, I don't remember.
When you got in the car that morning, had you ever been in that car before?
I have.
Okay. Do you remember the condition of the car when you got in?
Before the morning.
That morning?
Yeah, the car, it was making noise.
Okay. That's the engine. I'm talking about the interior. Was it a mess?
The interior.
You know what I mean by interior? You got inside the car and outside the car.
Mm-hmm.
When you sit in the car, you're in the inside.
Yes.
Okay, you understand that. And when you got in the car, it was full of papers, right? On the floor?
Don't remember.
You don't remember? You don't remember Social Security cards just sort of laying around?
No, sir.
You don't remember IDs of people other than Patrick Lyoya just sitting there?
No, sir. I think I saw some envelope or something. Envelope.
Some envelope?
Yeah. So.
Who's Janse Bakuma?
Say that again, please.
Do you know a person by the name of Janse Bakuma? Jeancy, last name B as in boy, Okuma.
Janse, yeah. Now I remember who I used to see him around too, but before but yes.
Now that's not Patrick, right? Janse Bakuma is a different person than Patrick, right?
Yes.
But Patrick has Janse Bakuma's ID in that car, right?
I don't know what's his person stuff. I don't go to people person stuff.
Well, he's got a work ID that says Janse Bakuma with Patrick's picture, right?
He doesn't have to object. He's asked and answered. He doesn't know what is in the car, so...
I'd like to explore it.
I'll give you a little bit of latitude.
Did you ever see his ID that had a false name on it?
Whose ID?
Did you ever see an ID, perhaps hanging from something in the car, that said Janse Bakuma with Patrick's picture on it?
I just don't remember what was. Yeah, I don't remember.
Do you remember seeing bridge cards in the car?
Bridge?
Do you know what a bridge card is?
No, I don't remember. I don't know what it is.
You know what benefits are that the government can give people?
Can you repeat that again, please?
Have you or anyone you know ever received benefits for like food or the things you can buy at a store that comes on a value card?
No.
So Patrick didn't offer to sell you one of those?
The card? No.
He never offered to sell you a bridge card?
No.
He didn't text you and say, I'll sell you one for 60, you can use it for 100.
Don't remember if he...
You don't remember that, do you?
No.
So you're in the car at some point in the morning, and it's your testimony you didn't drive anywhere with Patrick before 7 or 8 in the morning. Is that fair?
April 4th? You talking about before accidents happen?
Before the incident happened, yes.
Like I said, we have to drop a friend off because he have to take his baby to school, something like that.
Do you recall when you dropped the friend off?
No, the sun was out at the about the time.
In relation to the time you took the video, how much time had elapsed from the time you dropped off the friend till you took the video?
About 10 minutes. 9 minutes or so.
And before you dropped off, I want to retrace your steps here. When you got in the car with Patrick, did you have this friend in the car as well?
What you said, please?
About 7:30 or so in the morning, it's your testimony you went directly from David's house with Patrick, got in Patrick's car, and you had another passenger in the car too.
Yeah, it was
right?
3 of us.
3 of you. And then did you go directly to that person's house?
Yes, sir.
And what is that person's name again? I apologize.
Mark.
Okay. So you've been up all night. You get in the car with Mark and Patrick. Patrick's driving. And you drive to Mark's house because he's got to take his child to school, right?
Yes.
Prior to that trip, had Patrick left David's apartment?
He was in David's apartment.
He was at David's the whole time until he left with you?
Yes.
So he wasn't driving around at all?
No, don't remember.
Do you know a person who you call MT?
That's Matendo.
That's who?
Matendo.
Matendu? And do you know their last name?
No. It's some African name. Sometimes it's hard to try to.
I understand. But you don't recall his last name?
I think
Is the MT, is that first initial, last initial, or is that
yes,
just?
I think so.
Okay. So it's Matendu and then something to begin with T. Is that fair?
I think maybe that's right.
And Matendu called you at 7:53 a.m. on April 4th, right?
When I was having a conversation with him, he said call, but I don't remember exactly.
You recall having a conversation with Matendu?
At the moment, I don't remember.
Okay. Do you actually remember talking to him?
I think I did, yeah.
All right, and then you received a text from MT shortly after that, right? You received a text, bro, y'all coming back? I'm trying to get to work. Do you remember that?
No, I remember seeing a text.
No, you received a text.
I received the text, but I remember me looking at the text.
You remember looking at the text?
No, I don't remember.
Do you have any reason to doubt that you received a text at 7:53 a.m. on April 4th that said, bro, y'all coming back? I'm trying to get to work.
Any doubt, you said? Sir?
Do you have any reason to doubt that your phone shows a text from MT On April 4th at 7:53 a.m. that said, "Bro, y'all coming back? I'm trying to get to work."
I still remember seeing the text. I don't know.
Do you recall calling Matendu after that at 7:54 and talking for about 1 minute and 2 seconds?
Yes, I think we spoke exactly. And then it's been a while, so it's not like in my head.
Do you recall what you talked about?
No.
Who was Allie J?
That's Dave.
That's David. Okay. Do you recall getting phone calls from David at around 3 in the morning on April 4th?
No, sir.
Because it would be unusual for you to get a phone call if you're hanging out with David, right?
Yes, sir. Yes.
So do you have any explanation for why your phone shows that you're getting calls from him at 3 in the morning?
No, sir.
And the GPS shows that you're not at David's apartment?
The GPS?
Your phone shows that you're not at David's apartment.
I remember him calling me, so I don't want to say anything out of
Who is Pimp?
That's Patrick.
That's Patrick. So you call Patrick Pimp on your phone at least, right?
It's just a nickname.
Just a nickname. I understand that. And you called him on April 3rd at 10:55 p.m. Is that right?
I don't remember having called.
You don't remember?
Yes, sir.
But you were hanging out with him in the same apartment, right?
Yes, sir.
So you wouldn't call him on the phone?
No, if we're together, why would I call him?
Do you recall when Patrick switched phone numbers?
No, sir.
Okay. All right, on the day of the incident, I think you testified that Patrick said something about his car not working?
Making noise.
It was making noise?
Yes, sir.
And so he got out to check it out?
Yes, sir.
All right. And you didn't have any other conversation before that about the fact that there was a police officer behind him?
No, just flipping my phone around. That's why, if I remember correctly, that's why I put it aside, trying to go to check the car out. He said F word, they went to check the car out. That's when I saw the police. I didn't even see the police.
And Patrick was in the driver's seat, right?
Yes, sir.
And it's your testimony that he stopped the car, not because there was a police officer with his lights on.
If I recorded it, because the car was making noise.
Okay. And at some point you noticed there was a police officer behind.
That's when you open the door, that's when I started hearing the words. I wasn't paying attention.
So it's just a coincidence that he pulled over. Right at the moment there was a police officer behind him with his lights on.
I just remember him getting in the car and get out the car, and then I saw the police officer.
And you indicated that he yelled, and I'm going to say a swear word in court, which you're not supposed to do, fuck.
Yes.
And then jumped out of the car.
Yes.
Do you recall Patrick talking to the officer outside the car, right?
Yes. Yes.
And do you recall seeing the officer approach?
Yeah, once he opened the door, because again, I don't know exactly what had gone on in my phone. So when he said the A4 was wrong with my car, when he get out, that's when I see them go back. I didn't see the police officer.
You saw the officer ask him to get back in the car, right?
I don't remember what they were talking about outside because I was in the passenger seat still.
At some point, Patrick opened the door back up after he had already exited the car, right?
Yes, I remember that.
And he told you to get his license, right?
Yeah, get my ID, sir.
Okay, did you give him his ID?
I couldn't. I checked, I couldn't.
You looked in the glove box?
Yes.
There's nothing in there, was there?
Yeah, I couldn't find his ID.
Okay. Did he ask you to look in the glove box?
I was just. I don't remember if he asked me. Just I remember him said, check or get my ID. I don't remember exactly what he said. I remember looking for it. I remember the part.
Did you tell him that I can't find your ID?
Yes.
And then he closed the door.
Don't remember if it wasn't. But I remember me telling him I couldn't find it.
Did you observe I think you said wrestling between Patrick and the officer?
They were just going back and forth.
And before that, they were talking, right?
Yes.
But after Patrick closed the door, you saw Patrick run.
I don't remember him closing the door. It just I remember they was going back and forth. They went in front of their house. That's when I knew something was wrong. So that's when I decided to take off get out the car and then start recording.
Okay, and you got your phone out. And that was after Patrick and the officer were wrestling on the side of the car, right?
Mm-hmm.
That's a yes?
In front of their house.
And then they went around to the front of the house, right?
When he got out, they weren't rest. They were just words. I remember. I didn't hear what they were talking about again on the side, driver's side when he was out. So when they went and found the house, that's when I saw it start again like a physical. So that's when I started recording.
All right. Well, let's talk about the little bit because you're saying that you don't remember what happened on the side of the car.
No, I do, but I didn't hear the words they was talking about outside the car because I was in the passenger seat.
But you saw Patrick run around the car?
Yes, him and the officer.
And before that, you saw them wrestling, right?
No, they were not. They had a conversation first, words back and forward. And then that's when I know, once I saw them go around the car, that's when I started recording, when they started getting physical.
Okay. So they got around to the yard and the officer caught him pretty quickly?
I was still in the car when they started wrestling.
I'm sorry, I didn't understand what you said.
See, I was still in the car still when they was in front of the house.
Well, there were windows on the car, right?
Yes.
So you could see through them?
Yes.
Could you see them through the windows as they wrestled on the yard?
Yes.
Okay. Did you see Patrick run around the back of the car?
They both did.
They both did?
Mm-hmm.
And you saw Patrick and the officer in a physical confrontation before Patrick ran?
Yeah, I have in words. I don't know what the words you want, but yeah, before they was going back and forth.
Okay.
They didn't. Yeah.
All right. At some point, you stepped out of the car.
Yes, sir.
Right, and you decided to film with your camera, right?
Yes, sir.
There was a neighbor that came out, another gentleman, right?
I didn't see nobody. I thought it was just.
You didn't see anybody else there?
No.
Okay. And you said you heard Patrick yelling, "Okay, okay."
Yes.
You also heard the officer tell him, "Stop resisting," right?
Mm-hmm.
You heard him say "stop" over and over again, right? Right?
Everything went so fast.
You heard him say "stop" over and over again, right?
Yes.
You heard him at some point yell to Patrick, drop the taser, right?
Yes.
Okay. But you didn't see any other neighbors in the area?
No, I didn't see it because I was just focused on the video. I didn't see any other neighbors.
Okay. So Patrick said okay, but he also said some things to you, right?
Yes.
He told you to get the keys.
I didn't hear that.
You didn't hear him say get the keys?
I heard him calling my name, but I didn't hear what he said.
Okay, you heard him say Amy and then something.
Yes, sir.
You just heard the video. Did you hear him say get the keys on the video?
I wasn't looking at the video. I looked at a little bit, just looked to the side.
Want to play part of the video? Do you want me to do it, or?
Put it through others.
If you don't mind, we'll carry out one.
You can just go to the 20 seconds in. I'm going to play for you what's been admitted as Government Exhibit 4, passenger video. And I'm going to start at about 20 seconds in. And there's some comments directed to you from Patrick.
Now he said he's good for me. Great, yo, what's up, man?
You stop it right there. Now there he said Amy.
Mm-hmm.
What did he say after?
Get the keys.
Get the keys. And you keep playing it?
I really don't want to watch this video over and over.
Now you good, you're not resisting nothing, bro.
Stop it there, please. Yeah, I believe we need a break. He's talking with counsel.
We need more? No. You just had a question. Okay. Very good. You good?
Yes, sir.
Let me continue.
And if for whatever reason you need to talk to your counsel, you can just let the court know. Okay?
Okay.
All right. Okay, so I don't know if you heard the last one because I played it. I didn't realize your back would turn. Can we go back? Play it again.
Now he said he's good for me. Great, yo, what's up, man?
Not resisting.
Now you good, you're not resisting nothing, bro.
Stop it there. Thank you. Okay, so you were filming the action, right?
Yes, sir.
And then Patrick yelled, get the keys, right?
Yes, sir.
And then your vision goes down to the ground, right?
Yes, sir.
So you're looking for the keys, aren't you?
No, I wasn't looking for the keys.
At some point you saw Patrick in a tussle over a taser. Do you know what a taser is?
Yes, sir.
It shoots electrodes and can cause you to seize up. You're generally familiar with what that is?
I know what taser is.
Okay. Have you ever used one before?
No, sir.
Have you ever been tased?
No, sir.
Okay. But did you recognize on the morning of April 4th that the officer tried to use his taser against Patrick?
Yes.
Okay. So you knew that. You knew what was going on.
When the officer was tasing Patrick, they would just continue wrestling. Really, that's if I remember exactly.
So the officer drew his taser, and Patrick grabbed the taser, right?
At some point, I don't remember him grabbing the taser, but I know if you get tased, it's hard. You're trying to take it off.
So you don't know if he got tased?
Right? No, he got tased, I remember, but
Well, the taser went off. Do you remember Patrick dropping to the ground, shaking?
No, I ain't seen him.
So was there any indication that the taser prongs actually hit Patrick from your point of view?
Don't remember.
You don't remember?
Yeah, if he hit him, I do it, but I know they was going back and forth.
When Patrick reached out for the taser, he used his left hand, right?
I don't know which hand he used.
Do you know whether Patrick is right or left-handed?
Yeah, I know. I don't know what hand to use. I don't pay attention to details.
You don't know if he's right or left-handed?
Yes, sir.
As they continued to struggle over the taser, at some point you moved a few steps closer towards the sidewalk, right?
Yes.
And you told the officer, stop grabbing him like that, right?
I just heard that, yes. Sir, yes, sir.
So you were telling the officer to let him go?
Yes, sir.
After the officer shot Patrick, he told you to get back, right?
Yes, sir.
And you didn't move, did you?
Took a couple steps back.
And later on, the police showed up, right?
Yeah, a lot of them.
Okay. And then you were taken into custody at that point?
Yes, sir.
Have you met with Mr. Becker before today? Mr. Becker, the prosecutor?
First time.
First time today. Okay. Nothing further. Thank you.
Thank you.
No further questions, Your Honor.
All right. Witness may be excused. Sir, you may step down.
Thank you, Your Honor.
Wayne Butler.
Sure that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may be seated, sir. And if you would state and spell your full name, please.
My name is Wayne Butler, B-U-T-L-E-R.
All right. Thank you, Mr. Butler. Mr. Becker, whenever you're ready, you may claim your
Mr. Butler, good morning.
Good morning.
I'd like to take you back to April 4th of 2022. Were you living on Nelson Avenue in the city of Grand Rapids?
Yes, I was.
And were you home that morning?
Yes, I was.
Did something unusual happen, I guess, in the front of your house or right by your house that morning?
Yeah, yes, there was.
Could you tell the judge how you first became aware of something happening?
I was getting out of the shower and I noticed police lights outside of the window. And I found it kind of funny because we're like a couple blocks in each direction off of Burton and Kalamazoo. So it seemed like, somebody there was a traffic. Anyways, there's not a lot of traffic stops that occur in front of my house, just because of the proximity. And so when I noticed the lights, I, kind of glanced out my window and then, I proceeded to get dressed and I went downstairs just to kind of, I guess you call it maybe just oversee the situation, kind of see what's going on. I was on my porch, obviously. I wasn't in the mix, but I just wanted to observe what was going on.
I can stop you there. Before, when you say you're getting out of the shower, you're upstairs? It's a two-story house. You're upstairs or downstairs?
Upstairs. Yeah, so I'm looking out of my bedroom window.
I guess when you first look out of the bedroom window, you see the lights. Do you see anything going on at that point?
Yes, so you're gonna have to bear with me. My memory is
it's right on, but this was a very, very traumatic incident for me, very. And so, anyways, digging this up kind of hurts a little bit, but I do remember there was, you know, a regular traffic stop kind of situation, and then I got downstairs, and as far as I remember, that's kind of where.
Sorry. If you do, when you say you looked outside the window initially, what did you see initially when you looked outside?
Okay, so I saw Officer Schurr. He was going to just proceed with the traffic stop, you know, headed to the driver's side of the car, and I guess beginning that a regular traffic stop.
Did you see the driver? Did you see the driver outside the car at that point in time?
No, I didn't see the driver outside of the car, I believe, until I came downstairs.
So you see him approach, you decide to put on your clothes, you go down the stairs, you say you go on your porch. This is a
screened-in porch, yes.
So you go out on the porch.
Yes.
I guess when you first come out your door or on that porch, could you describe for the judge what you saw at that moment?
So at that moment, I saw them. Patrick was outside of the vehicle, I believe, at this point, and that's what kind of struck me as like a African American male, because obviously nobody's supposed to get out of the vehicle, but you know, it ends up that we end up dead when we get out of the vehicle. And not to say that that's not the procedure. Nobody should get out of the vehicle, but that's what struck me as a 41-year-old African American male, just wanting to make sure everything went okay.
So you were worried at that point in time because you saw
Right, because out of the vehicle, and I didn't know what reason he would be out of the vehicle for.
Could you hear anything between the two at that point in time?
There was like a dialogue. I wouldn't go on record to what it was that I heard, because I don't know specifically. I don't want to be wrong, but there was a dialogue, and I could tell in the dialogue he was confused. And the reason I say confused is because Patrick was confused. And the reason I say he was confused, this is what I say in giving the context of confused. The confusion is, first of all, you shouldn't have been out the car, you know, as an African American male, the way I'm seeing it. You know, and so I'm like, there's got to be something going on where he's having a discussion with the police officer. Don't you know he's got a gun? He's got a taser. He could kill you. You know, I mean, that's what I say is confusion. Not like I saw him disoriented or anything like that. Like, clearly he didn't know what the rules in America are about traffic stops.
So what did you see next? After you see this dialogue, you say there's a dialogue that you don't know what it is. What do you see happening?
Then I see him... And the word I used before I even saw the videotape, when I gave my testimony to the state police, I said there was like a tussle, like he was trying to evade him. And when I went back and I saw the video, that's exactly what it was. It was, you know... Now
you're talking about this tussle. This is a tussle by the car?
Yeah, well, that wasn't a tussle at that point. It was kind of... he was just trying to evade going to jail that morning. I guess that would be...
John, I'm going to object. Or at least I would like some more foundation. Is the witness testifying from the video he obviously watched afterwards, or from his memory of that?
No, actually, you could go to my state police.
Okay. All right, hold on. Mr. Becker, did you want to explore that further?
Are you testifying? We're just looking for what you testified from your memory now.
Yeah, I'm testifying what I told the state police when they interviewed me right afterwards.
Okay.
And there was a sidestep that I specifically remember. Because I remember that, I said, why is he trying to sidestep the officer? You know, like, just call it good, whatever it is, you know, and then it proceeded to the chase. And it all happened so fast, I can't really second for you.
Just do the best you can, that's all.
But what I'm trying to convey to the court is what I saw.
Yep. So when you say the chase, what do you mean by the chase? What chase ensued? So,
I mean, there's a sidestep, and hey, where you going? Hey. And then it's kind of like what I told the state police is he didn't appear to be running to freedom for me. I know that might sound kind of crazy to you, but it doesn't seem like he was running like people that have committed big crimes, they run far away. Like they run in a straight line away from whoever's chasing them. This wasn't that. he was running like he was disoriented playing tag in 2 front lawns. And so that was the kind of disorientation I'm talking about, the type of like, I don't know where I'm going to go, but I don't want to be here. And at this time, then I look over and I see the guy that's in the car with him, and he's got a videotape recording, or he's got his phone recording, you know, the situation. And so at this point, I see Officer Schurr trying to get Patrick together, and I see the guy in the car recording this situation. And then that's when I start yelling to the guy in the car, hey, get your guy, get your guy, get your guy. Tell him to stay down. Get your guy, get your guy. Because I didn't want to jump in the middle of a police chase and get shot myself. I've got 5 daughters. I need to stay alive for them. But I didn't want this man, regardless of what he did, you know, to die.
Okay. So in terms of there is this chase, what happens in terms of how does the chase end, if you will? What happens between the
So what happens is they get to kind of running around. And when I say running around, they go around the car and just, you know, they're chasing, they're tussling. The officer has control of Patrick the whole time. And when I say control, I mean physical control. Like if it was a wrestling match, the officer's always winning 60-40. It's like a football game where one team always has the lead. You know, he always had the lead, wasn't by much, and you could tell he was getting worn out, but he always had the upper hand.
So where is this wrestling match, as you described it, taking place?
So the wrestling match, it starts, I see a flip-flop fall off, and I don't know if it's an officer's gun, I don't know if it's a walkie-talkie. I guess it ended up, maybe it was a walkie-talkie, maybe it was a flip-flop, but I saw something black fly off, and that's when I kind of stepped out my door a little bit to just kind of see what's going on, and then it hit me, and I jumped back in. I don't want to get caught in any of this, but I believe it was right in front of my driveway, and then it went right to the next door neighbor's house. And then at that point I ran upstairs because I tried to communicate to the guy videotaping. I tried to communicate to the officer, or to Patrick, to just stay down. And then I went upstairs to go get my camera. You know, because at first when I left, my phone was on the bed. You know, I went down there just to just keep an eye on it, make sure everything's good, there's nothing crazy, you know, there's eyes watching in the neighborhood. So I didn't go down there with that intent. But then when I realized that it was escalating so quickly, that's when I went to go get my phone. And about halfway downstairs is when I heard the pop.
Okay. Now I can take it back though, in terms of, I want to take it back a little bit in terms of when you come out, you talked a couple times, you're yelling to his friend, Patrick's friend.
Yes.
You said you're yelling at Patrick too?
Yeah, I'm telling him to just to stay down.
Do you hear Patrick saying anything at that point in time?
No, I don't remember him saying anything.
Do you remember the officer saying anything during this?
I do, but I don't know. I wouldn't be 1,000% sure of what the officer was saying. I mean, I'm sure it was just stay down or something along those lines. I mean, it was. Yeah, I wouldn't go on record and say specifically with either one of them. But I don't remember Patrick saying anything.
At the time you were down there, you talk about going back upstairs. At the time, before you go upstairs, do you see the taser ever out?
Yes, I do see the taser.
Describe for the judge how that came out. What happened going up to that point?
So, there was the chase, the shuffle outside the car, then it got to, hey, where you going, get on top, wrestling, then it went over to the next door neighbor's house, and then I saw the officer grab his taser and shoot it, and I remember in that moment that it didn't work. I'm like, oh man, the taser didn't work, you know, and then that's why I was like, oh my gosh, I got to go upstairs to get my phone because this might be, you know, in the moment you don't process all the stuff, but I do remember the taser not working, and I do remember Patrick being surprised at the taser. Like everybody, I think, was kind of surprised that the taser didn't work. I think the officer was surprised. I think Patrick was, and there was like a pause, you know, and it's like, okay, well, what's next, you know? And I don't know what's next. That's not what I'm here for.
And I guess once again, at that point in time, did you ever hear Patrick saying anything? Any yelling from Patrick when the taser came out? Any comments at that point in time?
The comments, I just don't, I think I've suppressed those comments, to be honest with you. I really don't, my brain can't. I remember the situation like it was yesterday. It's like a movie that I was in, you know, but I don't remember any of the words necessarily.
You remember anything from the officer?
I know the officer was tired. I know the officer was definitely tired. That tussling that went on in my front, like near my house, I mean, it was probably a good 60 seconds of like wrestling, you know. I mean, and it was.
Now, I guess I'll ask you now. In terms of you've had other statements, you said something. You don't think the officer did anything wrong. Why did you say that? What were you describing at that point?
So what I was describing, as far as what the officer did wrong, is the first part. You know, I mean, he tried to prevent the situation from getting there, but then I think at the end he made the wrong left turn. And that's my personal opinion. Yeah.
He's making an opinion on something. That's fine. Not about your opinion. I'm not looking for that itself. Right? Not your opinion. But you stopped watching after the taser because you're going back upstairs at that point in time.
Exactly, because I know it's going to get worse.
Okay, so you don't see anything after that. What happens after the taser?
No.
Okay. I think if we look to the in-car video, we're going to put Exhibit 4 in-car video. Maybe I'll go over some of this a little bit more. We have no objection to that.
Okay.
So you recognize this as your neighborhood?
Yes.
Now we don't have a laser pointer, but which is your house?
My house is the one with the black car in the driveway, the SUV in the driveway.
Okay, kind of to the right of the vehicle pulling over, just in the
Exactly. And my bedroom window is the second window on the top left of the house.
So kind of a far window?
Yes, exactly.
Continue. Now, is this about the time you would have seen?
Yeah, this is probably the point right where I'm coming downstairs right now. Once I see them both outside like this, this is, I think, now my door. Like I said, it's like a movie, but you can see my door right there, and I have a white T-shirt on. I don't know what point I come into the.
We'll watch and see.
Okay. Yeah, right, and that's where I was like, hey, just stay down, man, just stay down.
Now from the video, it actually looks like you actually come outside.
Yeah.
Once again, at this point in time, you don't recall anything being said by Patrick.
1950, very short car.
No.
Okay. And do you recall anything being said by the officer?
No. No.
passenger ever respond?
No, never said anything to me.
It looks like you're still standing in the doorway there?
Yeah, and I'm trying to tell, that's where I was trying to communicate to his friend, tell your guy to just stop.
Now, we just heard the shot. Where were you when you heard the shot?
I was coming down the stairs.
Did you have your phone already?
Yeah, I had my phone. Yeah.
What did you do then after? Did you continue to come downstairs after?
Yeah, I continued to come downstairs. I had, I was in so much shock. I think I might have had like a 4-second or 2-second video I took on my phone, and then I just turned it off. Like I went back and I saw it maybe a couple of months later and deleted it. You know, I mean, there was no even, I was so taken back seeing the body laying there.
So you actually then came outside after hearing the shot?
I was on the porch. I mean, looked over and saw.
Let's see.
Yeah.
What did you see when you came out after you go get the video?
I hear shots fired, and I see Officer Schurr backing up and getting up, and he called it in. I guess he said shots fired, officer involved shooting or whatever, and he just kind of backed up, but he looked just as shocked. Yeah, he looked just as shocked.
Did you all try and render aid or anything like that?
No.
And how long did you see other police officers?
Police officers were on the scene providing, trying to do CPR or whatever, maybe about 30 seconds. Probably about 30
after
seconds.
You see Officer Schurr back.
Yeah, after he calls it in, then the black starts. The whole bunch of police officers start coming. So.
Okay. And maybe I just want to cover that before we play more.
Okay.
You can see you.
It is high up, those are very. Oh, just all the shooting. That'll be great.
And you can see that's you coming out the door?
Yeah.
Sorry, Michael.
Now, in terms of, you talk about this kind of arresting, did you ever did Patrick ever throw any punches?
No, Patrick was never on the offensive, and at the time in my state police report, they asked me definitively, did Patrick have a weapon? And I said he absolutely did not. He said, how can you be so sure? And my response was because he would have had more than enough time to use a weapon if that was his intent. But between the chase, like it all happened so fast, but my brain recalled in between the chase and running in circles and him having enough space to be able to operate and then the taser not working, all those things put together, a person that was trying to go on the offensive against the police would have, or had a weapon, would have had more than enough time to use it or to do so.
I have nothing further, Your Honor.
Good morning, Mr. Butler.
Good morning.
My name's Matt Borgula. We haven't met. Right? So let me just start with this. You're providing some opinions today, some lay opinions. Is that fair? And one of which,
I was there, so yeah,
right. Yeah.
They aren't lay opinions. I would just say they're eyewitness opinions. Yeah, go ahead.
That's actually the same thing under the law. What it means is you're not an expert. You just saw something and you formulated an opinion in your mind of what occurred. Is that fair?
Correct.
Okay.
Based on my experience in America. Yes.
Absolutely.
Yes.
And no one expects you to make your opinion based on something that
my experiences are different than yours. Yes.
Because you bring all your experiences to your memory.
Yes.
Okay. And no one has questioned that. But at the time that you were first interviewed, you indicated that you thought Officer Schurr did nothing wrong. Correct?
I did.
And that was based on what you saw. You didn't see the shooting.
I didn't see the shooting. Right.
And you might have an opinion about the shooting.
Right. Correct.
But you didn't see it.
Right.
Okay.
The execution style is what changed it for me.
Okay. So someone told you it was execution style.
No, after I saw the video.
All right.
After I saw the video. Because I believe Mr. Schurr to be a good man. Like, I believe Mr. Schurr, you don't sign up to be the police to be because you're a bad guy. And doesn't mean that police don't do things that are wrong, but I do believe him to be a good man. I do believe, and this is my opinion once and again, just like him being a good man.
Mr. Butler, I'm going to cut you off.
Yes.
Because you're entitled to your opinion of what you saw.
Okay.
And how it made you feel. But you're not entitled to the bigger opinion.
Okay.
Of whether or not he's a good man, or whether or not it was an execution, because you didn't see any of it, right?
Correct.
Okay. You saw the video later, and it's really not relevant what your opinion is of what the video. It's actually the judge's job to figure out whether or not a crime's been committed.
Okay.
So I appreciate your opinion.
Yeah. And
I certainly respect your experiences, but this is not the forum in which you express your opinion about things you didn't see. Is that fair?
That's fair.
Okay. And I just want to confirm that your opinion at the time was that the officer did a good job, did everything he could, based on what you saw at that time.
Correct.
Okay. All right. And so you live in this neighborhood. How long have you lived in that neighborhood, sir?
About three years.
All right. And you've had some incidents with stolen cars in that neighborhood, right?
Yes, I had a 2006 Honda, my mom's car actually I was using, and it was stole out of my driveway. It was running, but I don't know this to be a fact, another one of my opinions, but I believe Mr. Schurr was one of the officers who came and filed a police report. And that's what leads to I believe him to be a good man that was trying to do his job, but I know you don't care for my opinion.
Well, it's not that I don't care about it, sir. It's just this is not the time for it. We can talk afterwards if you like. Okay? If you had interaction with him before, though, that might be relevant. Do you recall seeing Officer Schurr before?
I don't. Like I said, I can't be positive.
Okay. And but you did have a stolen car out of that same driveway that we just saw on the film?
Yes, and it actually got returned.
Okay. Because the GRPD recovered it?
GRPD, yep, fantastic.
Okay. So they did a good job there?
They did do a good job there, yeah.
Okay. Are you aware of other stolen vehicles in the neighborhood?
No, not necessarily.
Okay. Now, during the incident, when we saw you come down, prior to that, you were upstairs.
Yes.
How many bedroom house is that?
3.
How many up? How many bedrooms up?
3.
So all 3 are up?
Yes.
Okay. This is a Monday morning around 8 o'clock.
Yes.
Are you getting ready to go to work?
Yeah, I'm actually getting ready to head to the auction, yes.
Okay. What's the auction?
I was buying and selling cars with a dealer out of Lansing at the time, yeah.
And do I recall correctly, you have more than one job?
No, not at the moment.
Okay, all right. So you're upstairs, you're getting ready to go to the auction, your work,
yeah.
Right? And you see the lights in the neighborhood, and that draws your attention.
Yes.
And I think your testimony on direct was that you don't actually remember what people were saying.
Can you clarify?
You don't recall hearing from the upstairs what anybody said?
No, not necessarily, no.
You just recall that there was some sort of interaction after Mr. Lyoya jumped out of the car?
Yes.
And it startled you that, or you became alarmed that Mr. Lyoya jumped out of the car.
No, I was more alarmed that the police were pulling over somebody this far in my neighborhood. That was the first alarm.
All right.
Like, because there's main streets, you know, so if somebody's speeding on Kalamazoo or Burton, you pull them over, they turn one street in, pull over. So this, to me, was, you know, a little bit further in, so it raised some, you know, a little more flags.
It was out of the ordinary, right?
Exactly,
Okay.
yeah.
And whatever caused alarm, and you thought enough that you need to go outside, right?
Correct, yes.
Okay. And so you went downstairs. At the moment, he was basically circling towards your house, or the area in between the two houses?
Yeah.
Okay. And you saw the officer catch him and tackle him?
Yes.
And the purpose for you going outside was in part to maybe try to stop Mr. Lyoya from making a mistake.
No. See, that's what I'm saying about our experiences being completely different. My reason for going out there is because I'm a 41-year-old African-American male who's a deacon at my church, and I wanted to make sure no African-American young man's civil rights got violated.
Okay.
And I also wanted to make sure nothing went too crazy in front of my house as a steward of the neighborhood.
Sure. So it's 8 a.m. in the morning
Yeah,
on a Monday.
it's not about justice for me, necessarily. It's about making sure everything's okay. Everybody can be okay on Monday morning. That's it.
Absolutely. And it's a Monday morning.
Yeah.
It's unusual that someone would be in a police chase on a Monday morning at 8 a.m., right?
Correct.
And you see a black man and a white officer. Based on your personal experiences, that raises additional alarms for you.
Right. I didn't want anyone's civil rights to get violated.
Sure. And so you went outside and you started talking to Mr. Lyoya.
Yes.
Okay. And you were trying to convince him to just comply with the officer's commands.
Yes.
And this went on for, I think you said, over a minute, where they're wrestling, right?
Correct, yes.
And at the same time, the officer is providing commands to Mr. Lyoya to stop, right?
Right.
And eventually he's talking about stop resisting, right?
Like I said, I don't recall the exact words that were said. So, I mean, that would be a contradiction right there. So I'm not going to start saying what I remember saying, but I'm sure there were something along those lines. You know, I'm sure there was some conversation, but I don't remember specifically.
Okay. And that's all we're asking for is your memory. And so, but you recall that whatever he said, the officer, it was designed to get the Patrick Lyoya to comply, right?
Correct, and he was in control the whole time. So that's why, as if there were commands being shouted, they were in that time when he was grabbing him and he had him held and he was on top of him. And I could, now one thing I did notice when they were wrestling is the officer was extremely out of breath. And I know, I mean, he's just trying to do his job. I understand that, or whatever the case is, but he was tired.
Okay,
that's
so
one
the
thing I
officer
know
was
for a
tired?
fact. He was exhausted after this physical encounter, and he couldn't.
And Mr. Butler, I'm sorry. I know you wanted
No,
go ahead. But let me ask you a question, because it's real hard for the record if we're talking over each other.
I'm sorry.
We'll get through all of it.
Okay.
And I'm going to ask you about everything you testified on direct, okay?
Okay.
All right, so, and we'll talk about the fact that the officer was tired. But I want to talk about these commands that you heard. Did you ever hear the officer say anything that was designed to hurt Patrick Lyoya?
I just said I didn't recall any words. So any questions you have regarding the words, I don't remember any specific commands that are being shouted. I know we're asking the same question over and over. I get it, but no, I don't.
Well, it's a little bit different question. You didn't hear him say, "I'm going to kill you," for example.
I didn't hear him say anything.
Okay. Well, you heard him say something.
I heard him say something, I just don't recall.
And I think you just testified that it was, whatever he was saying was designed to get him to comply.
Right, exactly. Yeah.
Okay. And it's, during this whole time they're fighting, and you indicated that Officer Schurr was tired.
Yes.
Right? And you saw him out of breath.
Yeah.
Could you hear him exhaling hard and
yes.
difficulty breathing?
Yes, I could.
Okay. And could you hear Patrick Lyoya?
Yeah, they were, I mean, it's wrestling. Yeah, they were both breathing hard and And, you know, it was what you would expect in grown men wrestling.
Okay.
For,
do you have any sports background?
yeah, I do.
What did you play?
Basketball and football.
Okay. So you've done ladders where you run? Okay.
Yeah.
If you do a ladder for 60 seconds, could you do one today?
Yeah, probably.
Okay. Well, you're a better man than me.
Yeah. Hey, man,
But that will wear you out, right?
Yeah.
If you go back and forth on the 10-yard line, 20-yard line, 30?
Yeah, I was bred for it.
Okay. Now, if you put 30, 40 pounds on top of you, like pads, for example,
yeah,
it's much harder.
Yeah, absolutely.
And that's why you think at this point, the officer, you can hear and you know from your experience that he's absolutely exhausted.
Yes.
And that's before you went upstairs, right?
Yes.
Okay. Now, you talked about sort of a ratio of who's in control.
Yep.
And I think you said the officer was 60% in control and Patrick was 40%.
He wasn't losing the game.
He wasn't losing.
Yeah.
But had he won?
No, he definitely hadn't won.
He never had him in the point where he had him completely in control.
Right, because he wasn't strong enough.
He wasn't strong enough. He could not control Patrick Lyoya completely.
Right.
All right. So he never had 100% control over him.
No, he didn't.
All right.
But he was also never threatened.
Did you see the taser?
Yeah, no, I'm saying he was never threatened. He was never punched. He was always the one delivering the blows. He was never headlocked. He was never. Patrick was always in the motion of getting away like a runaway slave. He wasn't the one that was trying to. No, I don't mean it like that. But I'm just saying he was just trying to get away from what I saw. Now whether that's right or wrong.
Right. Well, and let's talk about that. What you perceived. So when in his effort to get away, he's resisting the officer.
Yes.
Okay. At a minimum, you see that, right?
Yes.
Okay. Did you see the point where he grabbed the taser?
Yes, I did see the point where he grabbed the taser.
So the officer pulled the taser out.
Yep.
And Patrick grabbed it.
Yep.
Okay. So he didn't. The officer didn't shove it into his hand.
Right.
It was an affirmative act by.
It was a defensive act to not. To
not get tased.
To not get tased. Yeah. What anybody else would go through in a situation where they felt like they were threatened and they had to get away.
Okay.
It was a natural reaction to me. If he was a criminal and had a gun, at that point he would have used the gun against the officer. Right. But he was trying to prevent himself from being further harmed, whether that's right or wrong.
Have you ever met Patrick Lyoya?
No, never in my life.
So you don't know what was in his mind?
No, I don't. But okay.
So, and what we're talking about is your experiences, what's in your mind, and what you saw.
Right.
Okay. So your opinion about what was in Patrick's mind. Again, I know you have an opinion, but it's not really relevant for the judge. Okay. Now, after the taser shot, is that when you went upstairs?
Yeah, once the taser didn't work, yeah.
Okay. So when you say it didn't work, nobody looked like they got tased, right?
Right, nobody, yeah, exactly. There was no shaking, there was no, yeah.
Okay. And then by the time you came back down, the shot had already happened?
Yes, sir.
Okay, so you didn't see anything in between those two moments?
No.
All right. You indicated that the blows were coming from the officer. Did you actually see Officer Schurr punch?
Well, yeah, in the beginning part, I mean, when they were wrestling, the officer was, he hit him a couple of times, like in the rib cage, you know, when they were kind of wrestling. I did catch that.
Right. Was it maybe with his knee?
Maybe with his knee, maybe with his arm. It was, yeah. But there was some kind of blows, whether punch or knee or whatever, yeah.
Okay. And so he did that after he had tackled him around the side of the house, in the front yard, right?
I guess, yeah.
Okay, so before he did the knee strikes, he tried to get his arms behind his back?
You know what, as far as the sequence of this, you would probably go to the video and probably get a much better, I don't want to tell you anything that's not true to be discredited, so.
Okay.
The video will probably give you more evidence.
Well, but you know, we rely on human beings to give their personal
Well,
account,
I understand it was 6 months ago, though, and you don't understand how my brain has had to deal with this trauma and compartmentalize this. Okay. So the video might be a better source as far as what happened first.
Now, at some point, you noticed that there was a passenger in the car, right?
Yes, sir.
And you were talking to him?
Yes, I was.
And you were telling, I think something like, tell your boy to chill?
Yeah.
Because you were trying to get him to talk some sense into Patrick.
Yes.
Okay. Do you know whether or not, or do you recall him doing that?
No, there was no communication with him.
Was anybody else in the area saying anything that you can recall?
No, not that I recall, no.
So it's you, the passenger, and the officer?
Right.
No other neighbors do you recall coming out?
No, no.
Nothing further, Your Honor. Thank you.
Okay, Mr. Brother. Mr. Beckman, anything further?
I have nothing further, Your Honor.
All right, thank you. Witness may be excused. Thank you, Mr.
Thank you.
You may be excused. Thank you.
Oh, Fred Hunter?
Oh, Mr. Beckman, it's 10:30 now. I think we've been
I just
2 hours.
we have the Zoom guy at 11. I thought maybe we could break at that point in time. Because
Before we start the Zoom?
Before we start the Zoom,
Okay.
that'd be good. Hopefully, we got a half hour for this. I'm hoping we get it in.
This would be about
This witness maybe take a break. We can probably put off the Zoom call a little bit.
Okay. Does that sound good, Mr. Picola?
That's fine with us.
All right. Thank you, everyone, then, for being patient, hanging in there. We'll get a break for you as soon as we can. So would you raise your left hand? You swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. You may be seated. If you would state and spell your full name for the record.
Fred Hunter, F-R-E-D, Hunter, H-U-N-T-E-R.
All right, Mr. Becker, you may continue.
Mr. Hunter, if you could speak up just a little bit. I could hear you, but it was very faint. You're kind of soft-spoken, so if you just speak up louder so we can hear you back here.
Okay, Fred Hunter.
Yep, thank you. Mr. Hunter, I'd like to take you back to the morning of April 4th of 2022. Were you at home and your address on Nelson Avenue?
Yes.
At some time in the morning, did something unusual happen, I guess, essentially in your front yard?
Yeah, pretty much. I saw that there was like some ruckus going on in the front because my dog was like going towards the door. And that's when I saw Patrick and Officer kind of like tussling and running in the yard and stuff.
All right, maybe slow you down a little bit. Going back in terms of is it your dog that kind of makes you aware something's going on?
Yeah, my dog barks. And so
Where are you at when your dog starts barking?
I'm in the living room. So like my living room is right in the front of the house. So.
All right. Do you look out your window then?
Yeah, the door is open. Yeah, the door is open, and like there's a screen door, so I can look through the window and I can see the front.
So the first time your dog starts barking, you look out the window. Can you describe for the judge what you see out your window at that point in time?
I saw the officer chasing Patrick, and then they went toward the right side to my neighbor's house. And then from there, I couldn't see anything. So at that point, I just kind of walked off and just did whatever. And then when I heard the gunshot, then I went back to the window, and then that's when I saw the officer standing over Patrick with the gun.
So when they go to the side off, is your driveway over there, or is it
No,
neighbor's driveway?
It's my neighbor's driveway, right there on the right side. So like my house is here. So on the right side, that's where they kind of like cut. It's like a blind side, so I can't really see. So yeah, that's pretty much where I saw him on that side first.
So describe once again for the judge. You just see a chase. Do you see any struggle before the chase, or you just see the officer chasing Patrick?
It's a little bit of both. I see him trying to like grab and get a hold of Patrick, but Patrick is trying to obviously leave. So I guess they were just kind of tussling back and forth, and then eventually, once he went to the side where my neighbor house is at, after that I couldn't see anything until after I heard the gunshot.
So you didn't go try and look outside and try and see what happened after that?
No.
Okay. And did you ever see a taser being taken out or anything along those lines?
Well, I saw that. I assumed that they were reaching for a taser or something when they were tussling and whatnot, because I mean, like, he started, I guess, from his car. So once he got in the yard or whatever and whatnot, they were in the grass and stuff like that, running back and forth. I assumed that they were testing over a taser or something like that. So.
You assume. So when you say assume, that to me it means you didn't see it. I mean, can you describe to the judge what you saw in terms of that? What makes you thought there was a taser involved?
Well, because the officer was reaching for something and whatnot, and I assumed that he was going to tase him, because if he would have shot him, he probably would have shot him maybe when he got out the car. That's what I would assume. So, but I just assumed that he was reaching for like a taser or something. So.
But did you ever see one out?
No, I didn't. I don't think I saw one. Maybe I did, maybe I didn't. I don't really remember a whole lot when it comes to like seeing the taser, but I do know that the officer was reaching for something. So.
Do you recall anything being said between the two of them?
No.
You remember anything? Did Patrick say anything from your memory?
I'm inside the house with the screen. I can't hear anything really. I can just see, so I didn't hear anything really until the gunshot.
Didn't hear anything from the officer then?
No.
So you kind of think, okay, there's a struggle. Are you going back in the house to call more police, or are you just going back in your house to
I'm going back in the house just to do my routine.
Not your business. How long after you go back into the house do you hear the shot then?
Maybe within I want to say 2 minutes. Within 2 minutes I heard a gunshot go off, and that's when I went back to my front window in my living room, and when I opened the blinds, that's when I saw the officer standing over Patrick with the gun. So.
Can you describe a little bit more when you say you see the officer? What's the officer doing at that time?
Well, at this point, Patrick is obviously shot already. So when I open the blinds, I see that he's laying on the ground. The officer just sitting there, still just waiting with the gun, just sitting there.
Did you ever see the car where the person, where Patrick came from? Did you see the car? Where was that in relation to your house?
That car was literally right in front of my house.
And did you see the passenger for that car?
Did I see what?
Did you see the passenger in that car?
Yeah, the passenger in the car. He was just standing outside of the car, just sitting there. So.
Did you hear anything from him?
No.
Yeah, I think I'll go to the Exhibit 4, going to the body cam. No objection, yeah.
And that's
still Exhibit 4, just another part of Exhibit 4. The body cam. We'll watch it, and I'll ask you a few questions off of this.
Hey, stay in the car! Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. You have a license?
In terms of the house we're talking about you live in, is that the one, kind of the right, where just over the hand of the officer?
Yeah.
Okay, thank you. Continue.
Do you have a license? Do you have a driver's license? Do you speak English?
Yes.
Can I see your license?
What are you?
The plate doesn't belong in this car. Do you have a license or not? Do you have a driver's license?
Yes.
Where is it at?
It's in the car.
Get it for me. The plate does not belong in this car.
Now, just for a benefit, are you witnessing any of this at this point in time? You still haven't seen anything?
No, I didn't see any of this.
Okay, continue.
No. Stop. Put your hands in the chair. Stop. 1950. Got one on it. 4 o'clock. Stop.
if I understood you correctly, you would have seen that kind of run in front of your house. That's what you would have viewed.
Yeah, but it wasn't not yet though. Like if you go further, it wasn't yet.
You think you haven't seen it yet?
No, I haven't seen anything yet.
Okay.
From this point, no.
If you maybe indicate where you think you may have picked up the activity on this, tell us.
It was a little bit. It was after this though. It wasn't before that.
Okay,
It was,
just let us know when you think.
Okay, yeah, right.
Okay. Stop! Stop! Get your hands behind your back! Hands behind your back! Turn your hands behind your back!
So at this point, I do remember hearing somebody saying like, "Put your hands behind your back" and stuff like that. So that's when I saw them going back and forth around this time period. So it was around there.
Okay. All right. Thank you. Continue.
$19.50. Sergeant for card. Stop. Stop resisting. Let go of the taser. Let go of the taser.
So did you see them go to the ground or anything like that at the end? Would you witness that?
Yeah. Like I did see them tussle on the ground at one point, but like I said, like by the time I opened the door, I saw that they were going back and forth. I walked away and then pretty much didn't come back until after the gunshot. But I do remember, yeah, they were like on the ground and stuff like that.
All right. I have no further questions, Your Honor.
Good morning, Mr. Hunter.
Good morning.
Sir, my name is Mark Dodge, and I just have a few brief questions. Now, sir, you mentioned what you saw was tussling. Is that fair to say?
Yeah.
And tussling, is that fair to say just some type of mutual wrestling, combat, just some type of mutual movement? Is that fair to say?
Yeah, from the looks, yeah.
And on the topic, the prosecutor asked you about whether the officer was saying anything. And I believe you had said you don't recall the officer saying anything. But it's been 6 months, is that correct?
Yeah.
And naturally your memory today might be different than it was 6 months ago.
Yeah.
And do you recall being interviewed by police that day?
Yeah.
And do you know if that was recorded?
I don't know if it was recorded, but I know the guy who came that day, I know he wrote notes down and stuff like that. But I don't think he recorded anything like that.
And based on 6 months in your memory, is it possible you may have said something different to the police back then on the topic of whether the officer was telling the individual to stop resisting? Is that possible?
No, like I know what I remember, yeah. If anything, the only thing I probably wouldn't remember exactly, like maybe what time it happened at or something like that, but for the most part, I remember everything that happened. I was like,
so if a recording of you talking about that topic and whether you heard the officer saying stop resisting, that would not be your recollection today, is that right?
Like I said, like when it comes to him saying stop, there is a good chance he probably did say stop. I'm not 100% sure, but like I said, like when the tussling and stuff, I couldn't really hear everything. But if I had to guess, yeah, he did tell him to stop.
Okay. And once again, I'm not. It's natural. 6 months later, your memory could be different on certain things. That's all I have. Thank you, sir.
Nothing further, Your Honor.
Thank you, Mr. Hunt.
Now an appropriate time for...
I think so, Your Honor. I think we have our schedule at 11. He's supposed to come on, so we get that set up and be ready to go.
All right, then we'll take just about a 10-minute break, and we'll take back in a little bit. Thank you for everyone's patience this morning.
Probably just take a summary video.
All right, they're going to take a little break there. I guess they're not going to break away from there. So as expected, this is a very emotionally charged, intense case. And chat is I'm not quite sure what the right word is, but I just ask you to respect each other, and your opinions matter, right? And sometimes when people are texting, things get lost in translation. So just keep that in mind. Nobody's trying to hurt anyone on our side, you know, so please don't hurt someone on your side. All right, so far we've heard from four witnesses. So this is a pretrial, right? So we've heard from 4 witnesses, and we've heard from neighbors, we've heard from Patrick's friend, and we've heard from a sergeant. All right, so I'm going to zoom a little bit here, and we'll continue on.
Thoughts on scheduling? I know we're creeping up on the noon hour.
This will be our last witness, Your Honor, for us. So we'll be good to go. Take a lunch break, and if whatever, then I know the defense is getting also witnesses.
Okay.
Yes, Your Honor, we are prepared to call witnesses today. We would like a longer than usual lunch break, perhaps, because we do want the opportunity to look at the prosecution's brief in response to the brief regarding the law.
Okay.
One of the issues is we are going to call an expert on the issue of justification, and the interpretation of the law is that there's an interplay with his testimony, and we want a little time.
Okay. Well, we can talk about how long the break is going to be, but we'll plan on breaking for lunch then after this last witness. That sounds good. All right. Mr. Becker.
I will call Brian Child. He's on your Zoom, Your Honor, so.
All right, now you have. Let's see, Mr. Childs, can you say something so we get the camera to switch its view?
Yes. Testing 1, 2.
Very good. All right, and Mr. Childs, would you raise your right hand? And you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Mr. Becker, you may examine the witness. Before you do that, Mr. Childs, if you would state and spell your full name for this.
Yes, my name is Brian Childs, Bryan Chiles.
All right, Mr. Becker, whenever you're ready.
Okay, I'm not sure I'm supposed to look. I don't know if you can see me at all, Mr. Childs. I'm going to straightforward. I'm going to turn my head and look into you on our screen here. So if I'm turning to the side, that's why. Mr. Childs, could you tell the judge what you do for a living?
Yes, I am Senior Investigations Engineer at Axon.
What are your duties and responsibilities as a Senior Investigations Engineer for Axon?
My duties are conducting forensic investigations on Taser weapons and Axon body-worn cameras, submitting reports on the findings of investigations, and potentially testifying for it as of now.
All right, thank you. I'm in possession, and hopefully you too as well. I have a 57-page report dated May 19, 2022. Are you familiar with this report?
Yes, I am.
And what is this report? What is the report, I guess, for the record?
This report is my forensic analysis of the Taser weapon used in this case, Taser probes, as well as the Axon Body 3 body-worn camera.
And this Taser weapon, when you talk about using this case, this was involved from the Grand Rapids. Michigan State Police sent you the Taser that was used in the officer-involved shooting here in Grand Rapids back on April 4th.
Yes, it was Michigan State Police that I wrote the report for.
Okay. In terms of, you conducted a forensic exam on the Taser. I guess the first thing to begin with is, can you give a general description? What is a Taser, and I guess specifically, what is this Taser that was used in this incident?
So, Taser is a device or weapon that is designed to incapacitate a person. It is typically used by law enforcement. There are civilian models out there as well. But the basic principle is that there is a cartridge with probes that are attached to wires. When that is deployed by the Taser weapon, and the probes hit and penetrate skin on the subject, and there's enough muscle mass between those probes, that will cause what we call neuromuscular incapacitation, or NMI for short. And that is basically the muscles move and respond. Basically, all muscle movement is contraction of the muscles. That is done by electrical signals from the brain. What the Taser does, it's a very, very small amount of electricity, but it mimics the signals that your muscles would receive from the brain. And so when the muscles receive the signal, they will contract. So the Taser weapon, the model used in this case, will pulse at 22 pulses per second, which when the muscles are affected by it, will give the appearance of a solid contracting muscle lock, but it's actually doing it 22 times per second.
Okay. When you say specific, what is the specific model that was used in this incident?
The model in this incident, it was a Taser 7.
Now, is it the 7th edition, or is it just, is that what it means?
It's pretty much the 7th design from Axon's engineers.
Okay. What do you do in terms of when you get this Taser? What's the first thing you do in terms of your analysis of this specific weapon for this incident? What do you go through? What is the process?
The absolute first thing I do is photograph the unpacking of the package. So typically it will be sent to me via FedEx or UPS or whatever carrier. Those are the most popular. I will photograph the unpacking of it and the opening of any sealed evidence packages. Take close-up photos of the device, cartridges, probes, whatever is shipped to me. I document how I received them. The next step will be for the Taser 7 weapon is to load the logs onto the battery pack. So that's simply plugging the battery pack into the weapon and waiting for the hourglass on the display to disappear. What happens there is the logs that are retained in the memory of the weapon are then transferred to the memory on the battery pack.
Now, exactly there, just in terms of when you talk about the log, so everything and that, what occurred with that specific taser is logged in memory, and you can kind of tell what happened with that specific weapon when you have access to those logs.
Exactly. So the Taser 7 records all of its activity, whether you see that activity or not. So all activity that you see as far as arming or activating the weapon, but also internal processes. Say, for instance, if it's trying to write to a memory block and it's busy and can't write, and then it retries and is able to write, all that is logged. So it's a lot of data in the log. Also, when the weapon's activated, every pulse is measured and recorded in the log as well.
So after you get the logs, I guess, into the battery pack, I think you said, what's the next step you do in terms of your analysis?
I then dock the battery pack into a docking station, some behind me here on the wall. The battery gets plugged into the docking station, and the logs upload to the evidence.com servers, and at the same time it charges the battery.
Do you look at the taser for any physical damage, any markings, anything along those lines as part of your analysis?
Yes, that is when I'm taking photographs of checking the evidence in, I will note if I observe any damage or flaws or extremely dirty or anything out of the ordinary. And then after the uploads and everything, I will revisit that and take additional photographs.
Okay.
Close-ups focusing on that area.
Now, maybe cutting to the chase a little bit, I'm going to, if we pull up, we have saved at Exhibit 5, which will be your page 19, I believe, in your report. Hopefully we can screen save it. We've tried to do this, but that also may help too.
Yes.
Do you see Exhibit 5 on the screen for you?
I do.
I don't know if the judge, if you want me to do the split screen so you can see him, or is this okay?
You can try it. Let's see.
We're going to mess around a little bit. All right, that worked. As long as the court can see it, I don't know if...
I think that's the best we can get, unless you. Well, that's yours, right? That video is, or the
evidence is ours.
Yeah, if you could make that bigger on yours, then I think it would show up.
No, we just didn't. It didn't. I mean, as long as the court's okay with it, I think everybody's got a copy of this. So as long as you're okay with seeing it, and Mr. Childs, you can see that okay?
Yes, I can.
Okay. I guess, could you tell the judge what we're looking at here in page 19 of your report? There's some photographs. What are we looking at here?
That is a screenshot from the officer's Axon Body 3 camera. So it's footage from his camera, and I took a still screenshot.
And what led you to take a still screenshot of this particular photo that we have figure 4.3 and 4.4, right, if I'm wrong, if we recall correctly? Why did you take a specific picture here?
I took this screen to show that just prior to the deployment of the Taser weapon, the Taser weapon, which you can see at the bottom of the image is yellow, is being pushed away. So it's pretty much that was a glaring indication of why the first deployment missed.
Okay. So you saw this in the Bodycam video. When you're looking at your logs, can you actually see a deployment, if you will, from the Taser even without looking at these photos?
Yes, I would be able to see the Taser deployment and from the weapons log perspective.
And what can you tell the judge what happened on this initial deployment? What could you tell from either A, these photos, or B, the actual deployment logs that you look from the weapon?
When I'm analyzing a deployment, I will look at the pulse graphs from the log. So the weapon, as I mentioned before, the weapon records every pulse that's generated from the weapon, or even attempted to be generated, and records the voltages and the charge. Charge is the electric current that is flowing. it records all of those for every single pulse into the log. When uploaded to the evidence.com servers, the servers will create a graph out of that data. So my analysis starts with the pulse graph.
You can go to the next screen just too. This is the one below it too. This is just right after Exhibit 4, Figure 4.3. Is this the moment, I guess? Is this from would it be from this picture or from the graphs? Is this the moment of deployment, if you will?
And if I could interrupt, Mr. Becker, Exhibit 5 hasn't been admitted. Do you want to do that? Is there any objection to Exhibit 5 being admitted? No objection. Okay, all right. I'm sorry to interrupt.
Thank you, Your Honor.
If you remember the question, you can answer the question.
Yes, so this is a screenshot at the exact time of the cartridge deployment from the Taser. The reason I did both is you can't put a video into a printed report, so I included the previous frames, 6 previous frames, and then this one to show the progression of the weapon being pushed away.
Now, from your analysis, it was my understanding that there was, I don't know if that may be the correct term, it did not engage. There was no, it did not connect. Whatever term you use, it missed, if you will.
Correct. Both probes had missed, and so therefore there was no electrical connection to the subject.
Okay. If we go to Exhibit 6 now, this would be your page 20. Do you recognize this?
Yes, I do.
And what is this?
This is a screenshot from the same, could you scroll up slightly? So this is cropped from a cell phone video recorded by a bystander. And it's the same thing. I took a screenshot and pasted it into my report.
And this gives you a pasted report because there's some things in this photo that demonstrate some of your findings in your report. Is that correct?
Yes, it does.
I'll move the admission of People's Exhibit 6, Your Honor.
Any objection? No objection. All right. Exhibit 6 is admitted.
Could you tell the judge, we all see the photo now and the 2 red circles, why did you feel it was necessary to take a picture and put this in the report?
I put this in the report because it shows proof that both probes had missed the subject and were on the ground. When you are viewing this video, you can see as the Taser 7, which is in both of their hands in this screen, if you see where the red circles that I placed, those are not in the original video. But you can see 2 very light objects in the middle of each of those circles. When you're watching the video, as the Taser 7 is moved, those move as well. So those are the probes that are attached to the wires, which is attached to the Taser 7 handle.
Okay. Now I'm going to take you to page 22. This would be our Exhibit 7. Do you recognize this?
Yes, I do.
What do you recognize this as?
This is a screenshot from the same cell phone video, and this is at the time that cartridge 2 was recorded.
Once again, you put this in there because you can see from the video as well as your logs of a second deployment. Is that correct?
Correct.
I would move the admission of People's Exhibit 7, Your Honor.
Any objection? No objection. Exhibit 7 will be.
Now, in terms of this, can you tell the judge, I guess, you say it's a deployment. Why do you say that? Is it just based on the video and what you saw in the video, or is there something else that you can tell that shows you it was actually deployed?
It's based on, one, the logs of the weapon, showing the deployment at that time, but also in the cell phone video, you can hear the pop. When a cartridge is deployed from a Taser, there's a small primer that is ignited, and then there's a compressed nitrogen gas capsule that is punctured, and the air is let out. That's what launches the probes out of the cartridge. and that makes a pop sound. Not as loud as a firearm sound, but it's distinguishable. So at that point in the video, you can hear the pop as it's pointed in the ground and deployed.
Can you tell what essentially happens with this deployment? What happens with the prongs, if you will?
With this one, you can see the front of the handle is facing the ground. It's pressed into the grass. So the probes are launched out, but there's nowhere for them to go but into the grass. So they embedded it into the grass. I don't know how deep, but the probes were caked with dirt, and the front of the weapon had grass embedded into it. As far as electricity, the ground was wet, and so the electricity conducted through the water in the ground.
So now you have 2 deployments of the Taser. How many times can a Taser do? How many cartridges does a Taser 7 carry?
There are 2 cartridges that can be deployed, but they can be reactivated any number of times.
What do you mean by that?
There's a few ways to activate a Taser. One is via the trigger, which the trigger, if there's a live cartridge available, it will deploy that cartridge and activate the high voltage. Another way is there's a button on the side of the Taser weapon called the arc switch, and if that's pressed, that will activate the high voltage as well. So, for instance, if both cartridges are deployed, but you have a chance, say, for instance, if one of the probes hit a person, you could reactivate the weapon and press it to their skin and complete that circuit and potentially get the neuromuscular incapacitation.
Okay. So it takes a probe hitting the skin of the person to obtain the neuromuscular incapacitation. Is that what I'm hearing?
The ideal way is a probe puncturing the skin, but it can happen if a probe is close enough to the skin to arc to it. Most people talk about a Taser as the high voltage, 50,000 volts. The whole purpose of having high voltage is to be able to jump air gap from, say, if the probes do not connect to the skin or puncture the skin. The high voltage allows the electricity to jump to the skin and complete that circuit.
What happens if if the prongs don't hit the skin? I guess maybe a better question is, what is a drive stun? What is that?
A drive stun is a action performed by the user of the Taser, but it's basically taking the front of the weapon and pressing it against a person to allow the electricity to flow into them. If there's no cartridge deployed, a drive stun will just have the electricity go locally to where you're pressing it, and it can cause pain. If a cartridge is deployed, say I gave that example, if one probe is attached to the subject, you can complete the circuit via a drive stun with the actual weapon in another area and complete that circuit and get more muscle mass between the probes.
Okay. But a drive stun, if there is no prong attached, the drive stun simply causes pain, is what you just said. Do I understand that correctly?
If no probes attached, yes, a drive stun can cause pain.
When you say can, what do you mean? Is that also dependent on clothing, other factors? Is kind of...
Mostly I say that because sometimes they're used on someone who is very drunk and not feeling pain, or on mind-altering drugs and not feeling pain. So that's why I say it can cause pain. Okay. For a normal person, it typically will cause pain.
But it wouldn't cause the incapacitation that you talk when I designed to with the probes?
Correct. If no probes are deployed, I would not expect NMI possibility.
Okay. And you scroll down exhibit, I believe around 8. I'm going to show you exhibit 8. This is one part of exhibit 8. Do you recognize this?
Yes, that is the Taser 7 handle.
Right. And go down to the next one. And figure 5.2 and 5.3 on exhibit 8. Do you recognize this part of exhibit 8 as well?
Yes, that is the front end of the Taser weapon handle, so the cartridges are facing the camera.
So this would be the actual Taser we've been talking about that was used in this incident, and this is how it appeared to you when you were doing your examination?
That's correct.
I would move for the admission of Exhibit 8, Your Honor.
No objection. Oh, Exhibit 8, leave me.
So clearly from here, we see both cartridges have been fired, are gone from the Taser, is that correct?
Correct.
Is there any impact in terms of if the both cartridges are gone, you just have the drive stun function, can it do that through the dirt and so forth that you see on this exhibit?
Yes, it could. Dirt is not, even when dried, dirt would be porous, and electricity can find ways through a porous material. So if drive stun was applied, the electricity would go through the, even if it was dried, especially if it was wet, because it will travel through the moisture. But even if it's dried, it would still allow the electricity to travel to the skin.
With the drive stun function, in terms of it causes pain, does it cause a burn on the skin? Does it cause injury, anything like that, or is it possible?
It can. Any electric part. Basically what that is the air molecules between the electrodes will ionize and become conductive, and the current flows. Anytime you have current flowing through air, which when the molecules ionize, it's very low resistance, which allows more current, and you get heat transfer. So when conducting through skin, which is not conductive, it can cause a burn depending on the duration that is held.
Is it the whole, would it be the imprint of, I guess, of that whole rectangle, if you will, or is it smaller than that? I guess where is the current coming from that would cause the pain, and how big is that?
It's actually small, so it would actually make 4 marks because the electricity is coming from the electrodes of the weapon. If I may, I'm not sure if I'm allowed to, but I can show a mark on the image.
I guess we could try.
Let's try. So there's an electrode here. Can you see that red circle?
No. We can barely see it on our on ours very faintly on the upper right. It's the upper right.
Right there. Arrow. Not work. All right. Can you see the arrow?
No, we cannot see the arrow. The red mark a little bit.
Oh, okay. All right. So it's not working. Anyways. All right. Looking at the empty circles in front of the cartridges, where the probes would come out. If you look just diagonal, upward diagonal from those circles, there's a small electrode. You can't see the electrode in the photo, but that's the location of it. In the upper corners and bottom corners of that cartridge area, there are electrodes. That is where the electricity would jump to the skin. And so basically, if you did a drive stun on a person that caused burns, you would see 4 small burn marks.
Okay. So would it be, I guess, maybe for my benefit, between the circle and the yellow little corner, that would be the electrodes, if you will?
Yes, sir.
Okay, I think that helps. Kind of getting away now from the gun. You also talked about the body-worn camera. You did look at that as well?
Yes, I did.
Just a couple things on the body-worn camera. From your report, it indicates between 8:12 a.m. and 8:13, the body-worn camera was pressed 16 times, 11 times for less than 1 second, and 3 times for 1 second, and then 2 times for 2 seconds. Can you I'm assuming you watch the body-worn camera. Can you give an idea of what's going on in terms of why is it being pressed so much in that sequence?
Yeah, so from my understanding watching the video is there was a physical struggle. The officer was wearing his body-worn camera on his chest, on his vest, and there was a physical struggle going on I analyzed the video on where the button presses were, and every time the button was pressed was when there was an object or body right in front of the camera, blocking the view of the camera. So basically what that means is the subject and the officer were in a struggle, and every time they bump into each other, that would press the event button, which is a large circular button on front of the camera.
Okay. And so when it was finally, it was actually, you saw the video, it was turned off. How long does it take to hit that button for it actually to turn off?
So it takes, well, I'm not going to say turn off because the camera is still powered on, but it stops the recording when the button is pressed for 3 consecutive seconds. So it's pressed and held in for 3 seconds.
So at least on a couple of occasions, it was close to that during the struggle. So it's possible that it could stop recording, using your terminology, during a struggle, even though somebody didn't intentionally turn it off, if you will.
That's correct.
I have nothing further, Your Honor.
We'll roll in, Mr. Scott. Your Honor.
Good morning, Mr. Childs.
Good morning.
Not sure if you can see me or not.
Yes, I can.
All right. Sir, I might go through some of the same materials again, so I apologize, but just to, it's not necessarily intuitive information, just to help the court better understand a certain things. Now, sir, does Axon, the creator of the Taser 7, do they create training materials, user manuals for the Taser 7 device?
Yes, they do.
And are those materials, if you know it, then administered to the police departments that purchase these devices, and then the department is responsible for training their own officers?
Yes, overall the police department is responsible for training their officers. Axon provides training to train their instructors. So basically, someone at the police department is selected to be their Taser instructor. They will go and be trained by Axon on how to instruct a class, and then they go and teach their users, what they learned and what's in the training material.
And is that instructor from the department who gets instructed by Axon, is that sometimes referred to as the master Taser instructor for the department?
Correct.
Now, the materials that Axon creates, do those include warnings on risks associated with the use of the Taser 7?
Yes, they do.
And sir, you already mentioned on direct examination that the Taser 7, it is a weapon. Is that correct?
That's correct.
And does Axon warn that the Taser 7 is a serious weapon and should be treated as such at all times? Does that sound like it's right out of a manual from Axon?
Yes, it does. It might be paraphrased. I'm not sure the exact wording, but yes, that is the message that we want to comply.
Thank you. And does Axon warn that the Taser 7 device can cause serious injury or death?
Yes.
And I believe you already testified that the device has the ability to incapacitate human beings. Is that right?
That's correct.
So it goes without saying, Axon wants to put out very thorough, very comprehensive training materials to try to minimize the risk that a serious injury or death could result from use. Is that fair to say?
That's correct, yes.
Would it be fair to say that Taser use by an untrained person may be more risk that serious injury or death could result because of their lack of training on the device?
Oh yes, I believe so. If somebody is not trained and they don't know specific rules to follow, and basically we put the training in there to mitigate risk, and if you don't take the training, you don't know how to mitigate risk.
And one of those risks, maybe for an untrained person, that I'd like to get into here is on the topic of certain sensitive locations sensitive locations on the body for taser use. Is that one of the risk factors, I guess you could say, for taser use?
Yes, it is.
And does Axon, in their education and training, stress that it's critical to avoid injury or death by avoiding certain locations of the body with taser use? Is that fair to say?
Yes. Overall, we do train that there's certain areas that you do not want to deploy at for the risk of serious injury. And there are certain situations to avoid to decrease the risk of accidental death.
Thank you. And there's certain locations, perhaps if you're shooting the probes, certain locations of the body that Axon warns to try to avoid. Is that right?
Absolutely, yes.
But there's also certain locations of the body that a drive stun can cause serious injury. Is that what Axon warns?
Yes.
Now I'm just going to go through a few topics that may have been talked about already, but just in regards to the cartridges. The Taser 7 device that we have at issue here was equipped with 2 cartridges. Is that correct?
That's correct.
In order to discharge or fire a cartridge, or the probes out of a cartridge, the user pulls the trigger. Is that right?
That's correct.
And each cartridge holds 2 probes. Is that correct?
That's correct. I refer them to as a top probe and a bottom probe.
Okay. And those probes are attached to wires, which attach back to the taser, back to the device. Is that a fair way to say it? If I fire the probes, there's a wire connecting the probes back to the Taser 7 device. Is that right?
For the most part, the wire is physically attached to the cartridge, and the cartridge is clipped into the weapon. So there's the wires aren't, I wouldn't say it's technically correct that the wires are attached to the Taser 7, like physically, but they're clipped in via the cartridge.
Exactly. Good point. Thank you. And if we pull the trigger, both probes are deployed, electrical energy begins flowing to the probes. Is that a general way of saying it?
Yes, but I hesitate on flowing because you have to have a connection to the probes for the flow of electricity, or the flow of current. So I would rather say that when deployed, the high voltage is activated and both probes are energized.
Okay. And depending on the type, I know there's some different types of cartridges, but approximately what type of distance can those probes be fired to? How far can they actually fly? Approximately.
There is 25 feet of wire within the probes. So technically, they can travel 25 feet. There is one cartridge that has a wider angle, so that 25 feet wouldn't be feasible enough because one probe would hit the ground before it reached 25 feet distance.
Okay. And we talked about the topic of NMI, as you referred to it, neuromuscular incapacitation, and which generally causes uncontrollable muscle contractions and reduces ability to perform voluntary movements. Is that fair to say?
Well, I would say under NMI it eliminates the ability to control muscle movement.
And
is NMI accomplished by delivering the electrical pulses across the two electrodes to overstimulate the motor nerves. Is that fair to say?
Essentially, yes.
And if the two probes fired make contact with a person, then is it fair to say this closes the circuit? Is that how you would refer to it, closing a circuit to allow the energy to flow between the probes?
Yeah, that's correct terminology. It does close the circuit, but I will point out that even if the probe doesn't contact the skin, because of the high voltage, there is potential for it to close the circuit without physical contact to the probe.
Okay, thank you. And I might elaborate on that in a moment here, but I'd like to turn to another topic now, and that's the term re-energizing. Now, probes are fired. If they make proper contact with a target, then the energy flows, the current flows for 5 seconds. Is that correct?
Yeah, there's a default 5-second duration to the activation.
Now, are those probes, you may have talked about this already, but probes have already been fired, 5 seconds goes. Those probes are capable of being re-energized. Is that right?
That's correct.
And so if I fired my first cartridge and I want to fire my second cartridge now, I pull the trigger on the second cartridge. That also re-energizes the probes from the first cartridge. Is that correct?
Yes. It's a technology that we call adaptive cross-connect. There's a lot of complexity in it, but yes, the deployment of cartridge 2 will also reactivate the cartridge 1.
Now, I fire backing up, if I fire cartridge 1 and I don't want to fire cartridge 2, but I would like to re-energize those probes, can I simply touch or push the arc button on the side of the device? Will that re-energize the probes from cartridge 1?
That's correct.
So, I want to talk about this cross-connect a little more. In order to achieve the cross-connect, I can press the arc buttons or I can pull the trigger to re-energize probes. Is that correct? Or am I mixing up a couple of different things there?
Could you state it again?
Sure. Let's put it this way. If both cartridges are deployed and I either press the arc button and the arc button is on either side of the device, is that right?
Correct.
And I could press it on either side or pull the trigger, so long as those probes are still attached by wire, that would re-energize all 4 of the probes from both cartridges.
That is correct.
And could you explain, if I come in contact with 2 of those probes, and I believe you already explained, the probes don't have to be touching the skin necessarily to have the energy flow to me. Is that fair to say?
That's correct.
If I come in contact with 2 of the probes, the arc button gets pressed, the trigger gets pulled, the circuit thus gets closed, then I may be at risk of the circuit closing and potentially suffering NMI. Is that fair to say?
That's fair to say, but it's kind of limited as well, because I want to include the wires that are attached to the probes. They are insulated. However, they are very thin and fragile, and we have to make them that way in order to fit them into the probe and allow the probe to travel. If it's too thick, it's not going to travel far, and you won't be able to fit the wire in there. That wire is easily damaged, so if it's stepped on or anything that could damage that thin insulation, that could allow the electricity to flow from the wire to you. So for instance, if you have wire wrapped around you, but you're not near the probes, you could still potentially experience NMI from electricity traveling through the wire.
So even contact with the wire potentially in the arc switch is arc switch is pressed or the trigger is pulled, the potential is there that I could get, lack of a better word, I could get bit by the electricity. Is that right?
That's correct. In the training for law enforcement, they're trained to cuff under power, which means to be able to handcuff someone while they're experiencing NMI. But one thing they're trained at is to pay attention to where the wires are and to avoid touching the wires. And it's for that reason.
Sir, you saw the video here and already testified about that. But basically what we had here was a couple of individuals tussling round and round. Is that fair to say?
Yeah, that's a fair description.
And the taser had been discharged in the vicinity of where they're tussling around. Is that correct?
That's correct.
And I believe you note in your report from, and perhaps it was shown right in the exhibit there, you pointed out that the probes are getting dragged around when they continue to tussle. Is that right?
That's correct.
And the probes have barbs on them. Is that right?
That's correct.
But you already acknowledged that the probes don't necessarily need to be penetrating skin in order to feel the effects of them. Is that correct?
That's correct.
Now let's say I'm laying on the probes, or maybe even the wire, or kneeling on the probes or the wire. I'm tangled up in them, however it might be. Those barbs, if the arc switch is pressed or the trigger is pulled, I could have a circuit close on me. Is that fair to say?
Yes, but I wouldn't limit it to the barbs. Say, for instance, if the probe was laying on its side and you were laying on the probe, so the barb is not touching you, but just the metal probe laying on it, even if you have clothing on, but especially if you have wet clothing on, it would conduct through the clothing to your skin.
Thank you. So the fact that the probes, both cartridges have been deployed, the taser should still be treated as a serious weapon because it still has the capability to be reactivated. The probes can be reactivated. Is that fair to say?
That's correct.
Now, I'd like to talk about the drive stun. And the drive stun is basically a mechanism on the weapon that when administered on a target also delivers an electrical charge to that target. Is that a very generic way of stating it?
Yes.
And the shock or the charge is administered by touching or pushing the device on the target. Is that right?
Correct. The pushing the device onto the target is basically completing the circuit. So when you don't have two probes connected, you can complete that circuit by pressing the weapon against the person.
So I guess backing up to the scenario, I'm kneeling on a probe, or perhaps even the wire. That's only one point of contact. If I get drive stunned, that makes 2 points, doesn't it? So that I might have the circuit closed on me and potentially suffer NMI?
That's correct.
And Axon, I believe we already talked about this, warns that the drive stun alone on certain sensitive parts of the body can crush those sensitive areas. Is that what the literature says?
I believe so. I know that's the message given. I'm not sure the exact wording, but that's the intent.
Thank you. Now, when we talked about the device, if two probes or 2 points make contact with an individual, the arc switch is touched, or perhaps if it's already been expelled, or the trigger is pulled, the electricity, the current moves for 5 seconds. Is that right?
If there's a connection, the current will flow for 5 seconds. But I guess better said is that both cartridges would be activated or energized for a 5-second duration.
And at the conclusion of that 5 seconds, if I push the arc button again or I pull the trigger again, the device would again, so long as a connection was made, it would go for another 5 seconds. Is that right?
That's correct.
So, sir, just in conclusion here, I think we've already hit these topics, but even after both cartridges are deployed, the Taser 7 maintains the ability to re-energize all 4 probes by simply pressing the arc switch or pulling the trigger. Is that fair to say?
That's correct.
And even after both cartridges are deployed, it still maintains its ability to drive stun someone. Is that correct?
That's correct.
And we talked about the drive stun can work in conjunction with contact with even one probe to close a circuit and potentially cause NMI?
Correct. One probe or even one wire.
Thank you very much, Mr. Shiles.
Just real brief. Just so I'm clear, I want to make clear, there's 2 discharges here. The first one completely missed everything. It didn't hit anything, is what your testimony is, by watching the video and by looking at the logs of the Taser weapon. Is that correct?
Technically, they hit something, the ground or sidewalk or something, but they did not hit the subject.
Okay. The second one, if you can pull up Exhibit 6, I believe, the one before this, or 7, excuse me. The second one, now they've talked about a bunch of recharge and it could recharge and everything. The second one, this is the second deployment, if you will. Is that correct?
Correct.
And this second deployment was right next to both of them. I mean, within inches, if you will, from the photo. Is that correct?
Yes, it was deployed into the ground right next to them.
And you watched the video. Did you see any indication that anybody was suffering from NMI, or there was any implication, any reaction that Taser was having any impact on either Mr. Lyoya or the officer?
No, during the struggle, I did not see indication of NMI.
They continued to struggle after this, didn't they?
Well, yeah, there was even a struggle after the struggle continued after the second cartridge was deployed.
Okay, thank you. I have nothing further.
I just well, Mr. Dodge.
Sir, just to clarify, regardless of whether there had not been any NMI yet, with both persons, I think the prosecutor said within inches of this, if either one of them were to come in contact with the probes that were already expelled, or even the wire, if it were 2 probes or 2 wires, the trigger gets pulled, the button gets pressed, the circuit could close, and that could potentially cause NMI. Is that correct?
That's correct. The potential was there.
So it's, even though neither one of them may have experienced NMI, the risk was still there given these conditions, that based on the re-energizing of the probes, that there was still risk that NMI could result. Is that right?
That's right. I'll clarify. As long as the cartridges are still installed into the handle, the potential for NMI is there, especially with a struggle going on and people moving around. The potential is there.
Thank you very much.
Mr. Becker? I have a couple questions that I'd like to ask the witness. Mr. Childs, the wire, and I think you testified this, is the wire generally stays connected to the probe. It connects the probe and the, what do we call it, the gun, the trigger?
That's correct. The wire is physically tied to the probe and physically tied to the cartridge on the other end.
Do we know here whether it remained tied at all times? Whether it came undone?
I do not. I believe at some point probes were disconnected. There was still wire attached to the probe, but I would have to look at my photos again. But I believe probes were eventually broken from the wire.
Okay. You talked about the potential that that physical contact with the wire under certain circumstances could complete the circuit. The wire is insulated. Is that correct?
My point there is if there's a flaw in the insulation. So even stepping on the wire can break the insulation. So if the wire is fully insulated, it should not, the electricity should not travel through it. However, being such thin wire and in a dynamic situation, there's a risk.
Okay. But just if the wire is intact and fully insulated, that wouldn't be enough to complete the circuit. You would have to have a tear or a rip or exposure in the conductive material, or in the insulation over the conductive material. Is that right?
That's correct.
Okay.
That's correct.
And then if there was damage and the conductive material was exposed, if that conductive material came in contact with skin, that could release the full charge that has the potential of causing the NMI. Is that correct?
Partially. You're talking about contact with skin, so you don't even need contact. It just needs to be close enough to our ability.
Okay. But the face of the trigger itself, the face of the gun itself, I guess what I'm trying to understand is if this wire, if exposed, if the conductive material is exposed, it could emit the full charge. How is it that the contact with the gun itself only creates this drive stun as opposed to a full charge?
I'm not sure I understand.
If the wire was severed, for example, 2 or 3 inches from the face of the gun, am I using the right phraseology?
We stay away from gun.
Okay. What do you call the
weapon?
What do you call the base?
It's the handle.
The handle. Okay. If both probes are discharged, the wire on each probe was severed at 3 or 4 inches from the base. If there was exposure in the conductive material, that could emit the full charge. Is that correct?
If both wires of the probes is severed several inches from the handle, your only potential to deliver charge would be at the front of the handle to to the end of the wires. At that point, the probes would not be active or energized because the wire is severed.
Once the wire is severed, you can't get the charge through the wire itself. You have to have a probe connected.
Well, what I'm saying is, if you completely sever the wire, you break that circuit. And so, if you sever the wire completely, like you took scissors and snipped it and threw the rest away, that part that is not attached to the weapon anymore would not be energized, and that would not have potential to deliver charge.
Okay, let me ask. Maybe I ask it this way. There's two probes. Yeah, that's not the wire. There are two leads for each probe. Is that correct? I'm thinking electricity and a negative and a positive and a flow like that. Is that?
Yeah, that's a good way to picture it. Is you have a top probe and a bottom probe. You can picture one is positive and one is negative.
Okay.
And they need to complete.
If the wire got severed somewhere along the line, and both of those wires, not both of the probes, but both the positive and the negative lead, there was exposure of the conductive material, and if both of those touched scanner cable flows, would that deliver the charge, even though the probe is now disconnected?
Yes.
Okay. So at some point, the wires have to attach to the internal mechanism in the remote, in the handle, correct?
Yes, and they are attached via the cartridge that's installed in the weapon. So the wire is physically attached to the cartridge, which is plugged into the handle. So if you have your handle and wires hanging out, when you activate the weapon, those wires would be activated.
Okay, but at some point, inside the probe, the wires, there's a transition from wire to metal.
Correct.
Okay, and then on the other side, in the handle itself, there's got to be a transition from wire to metal.
Correct.
Okay. Let's say the wires came apart at the joint, in the solder joint, in the handle. I mean, is that a fair characterization of it?
Yes.
Okay. If that came apart at that point, can that handle still emit the type of charge that would cause NMI?
If all the wires were removed?
Yes.
No.
Okay. So the only way, so a connection with the handle itself, assuming all the wires are intact and assuming that the probes are feet away, the connection with the handle itself only creates a drive stun. Is that correct?
That's correct. If the probes and wires are away, then the potential is drive stun.
And a drive stun cannot cause NMI?
It can't cause NMI, correct. In that situation.
Okay. Mr. Becker, any?
Nothing for your honor.
All right, Mr. Dodson.
Just to make sure that the court understands on that last portion there, the drive stun could cause NMI in conjunction with contact from one probe or potentially wire. Is that correct?
Correct. In the situation that the judge was talking about was if all the wires were removed, but if you still have one wire connected, then a drive stun could potentially cause NMI.
In the drive stun alone, no wires, the drive stun alone to certain portions of the body, axon warns, can cause serious injury. Is that correct?
That's correct. And I'll give, for instance, the eyeball. That can cause serious injury, discharging into an eyeball.
And sir, we're actually going to have another witness to talk more about this, and I know it's, but so I plan to go into it with them. But the drive stun can crush the trachea as well. Is that what axon warns?
Yes. Well, pretty much any object pressed on the trachea can crush it. Taser weapons, no exception.
And drive stun in the axon warning can crush genitals. Is that correct?
Correct.
And is there also warnings on using the drive stun on the back of the neck area? Is that another warning?
Yeah, well, pretty much the entire head is a no-no.
Okay.
That's where we advise not to use it.
And sir, we can see from right there on that picture, drive stun, both of these individuals here are, would it be fair to say they're within arm's length of each other? Arm's reach. And basically with a drive stun, just to make sure the court understands, you reach out and you make contact with the target, or you press the target to deliver a drive stun by simply pressing the button on the side or pulling the trigger. Is that correct?
That's correct.
Okay. Thank you. All right, Mr. Becker, anything further?
No, you're right.
All right. Thank you very much, Mr. Childs. The witness can be excused at this point. All right.
All right. Thank you for the opportunity to do this remotely.
Absolutely.
Thank you.
Take care.
All right, Mr. Becker.
We have no additional witnesses at this time, Your Honor.
Okay. It's 12:11. I think it makes perfect sense for a lunch break then at this point. Mr. Bergola, you mentioned you want to address something with scheduling.
Yes, Your Honor, we want to make sure we have witnesses all here, ready to go in consecutive order. If possible, we'd like normally the court would probably take an hour for lunch. If possible, we can get an extra hour to make sure that we are ready to go when we start back up.
All right,
We would appreciate it.
what if we reconvened at 2 p.m.?
That would be fine. Thank you.
Satisfactory, Mr. Becker?
The court's discretion, Your Honor.
All right, then we will we'll adjourn now. We'll reconvene at 2 p.m. Thank you, everyone. And just a reminder, I think we're still at capacity. What we'll do after lunch is it's still a first come, first serve. So if you're here now, it doesn't necessarily guarantee that you would have access.
First up tonight, a victim preparing to testify against her accused rapist.
Yikes. Man, that happened fast. Dwayne, yeah, you don't need to apologize. It's all good. Just take care of yourself. This is going to be a tough trial, I think, for a lot of us. I mean, there are no winners. Everybody loses, unfortunately. Both sides did something that they probably shouldn't have done, and one of them isn't with us anymore. So, terrible. All right, here is the second part of that hearing. And if you guys need to walk away, I get it. If you need to walk away, if something's bringing up something's bringing up stuff for you, triggering you, just walk away. Just walk away, take a deep breath, and do what you got to do. Aw. Yeah. No worries, Dwayne. We love you. We love you. We got your back. And you are always welcome in this community. Always and forever. So keep that in mind. And, just walk away. I think just walk away. All right, let's continue on. This is the second part of this preliminary hearing.
Folks, just a reminder, make sure all your cell phones are turned to silent or vibrate for me, please.
Good morning. Court will get started shortly. Just the same reminders. You might have some new faces in here, I'm not sure. Just a couple reminders. We ask that you turn your cell phones off. If you have not been granted permission by the judge or filled out a media request, we ask that you turn your cell phones off. You are at risk of having them taken in the courtroom. We don't keep them, but they will be returned. So we just want to avoid that altogether. If you have not been stopped at the door, we're asking that you, there's a court order if anyone wants a copy. You're not allowed to have any attire that represents either side. As a court, our job is to uphold being fair and impartial. So we ask that you refrain from any attire that represents either side. And once you're in, you're in. The judge will go over that, I think, today, but just in case he doesn't, if you exit the courtroom, you will not be allowed back in until there is either a break in witnesses or the court takes some recess. So we ask that you try to refrain from leaving or exiting unless there's an emergency. Otherwise, you will not be permitted back in until we take a break. And we will be here shortly. And we are also live on YouTube. So we ask that you refrain from conversation because the public can hear you. Nicholas A.U. presiding.
Thank you, everybody. Good morning. All right, 22FY0827, State of Michigan versus Christopher Schurr. And double checking here, we are live on the YouTube. If we could have transparency this morning.
Respected people. Good morning, Your Honor. Matt Bargula, McKay Hamilton, and Mark Hodge, on behalf of Christopher Schurr, who is seated in this Hamilton line.
Good morning, everybody. I know we talked briefly about the potential for one final witness from the defense or potential for a stipulation as to the fact. Mr. Pergola, I'm guessing that you figured something out?
We did. The parties did work and try to get to a stipulation. And we haven't been able to limit some of the evidence, but we're going to have two witnesses, Your Honor. And we think we've tailored it a little bit to save the court some time, so we appreciate the courtesy, but we were not able to come up with a written stipulation. So I'll let Mr. Dodge call our first witness to the court.
I'm ready if counsel is ready. Anything else we need to address? All right. Mr. Dodge. Thank you. And technology-wise, right now, are you going to need connections? I don't think we have anyone connected to Zoom for presentation purposes.
Yes. So, Your Honor, I'm going to run from here directly
To the HDMI? All right. Oh, and you've got that? Okay.
I'll turn it on when you're ready.
Okay, perfect. Would you raise your right hand? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
You may be seated, and if you would, state and spell your full name for the record.
Certainly. Chad McCursey. First name C-H-A-D. Last name McCursey. M-C-K-E-R-S-I-E.
Thank you very much.
Good morning, sir.
Good morning.
Sir, how are you employed?
I am a police officer in the city of Grand Rapids.
And can you please tell me what is your rank?
I am currently hold the rank of captain.
And sir, how long have you been a police officer with the city of Grand Rapids?
Almost 23 years now.
Can you give us a generic snapshot as far as the different positions that you had?
Yes. Started obviously as a patrol officer, like everyone does at the police department. Did a few years there, went into our special response team or SWAT team. Did about 6 years in there. Left there to become a community police officer. Did that for about a year, then I got promoted to sergeant. Went back to nights as a sergeant for a few months, and then back into the SRT as a sergeant and team leader in there. About 2.5 years after that, I went into our detective unit, supervised our general case team and our family services team. From that time, I got promoted to lieutenant and sat as a lieutenant of what we call their watch commander, where you run the patrol shifts, either on day shift or night shift. After that, I moved into the internal affairs and was the commander of our internal affairs unit. Did that for roughly 15, 16 months before an opening came open in the training unit. And then I was the commander of the training unit as a lieutenant for roughly 2.5 years. And then back in January, I was promoted to acting captain and then full captain in July of this year.
Thank you. And any other, that's a lot of work, but any other additional duties?
Yes, I hold additional duties as a firearms instructor since 2002, defensive tactics instructor since 2005 or 6. I was made a Taser instructor. I was a first aid instructor. I currently continue with my roles as a firearms instructor, hold certifications as a firearms instructor, defensive tactics instructor, and I'm currently our master Taser instructor for the department.
And sir, how many master and Taser instructors are there in Grand Rapids Police Department?
I'm the only master Taser instructor currently.
Now, sir, we've had witnesses testify yesterday. We're going to have another witness testify as well after yourself. So we're probably going to just cut to certain topics without going into, for preliminary examination purposes, just survey some topics related to you as a master Taser instructor, as well as basic training and policy components, if that's fair. Now, sir, you're familiar with this case, obviously?
I am.
And have you had the opportunity to review the videos involved here? Officer Schurr's body camera video from this incident on April 4th. Have you had the opportunity to view that?
Yes, I have.
Several times?
Yes.
And how about the video of the cell cam video of the passenger involved here?
Yes.
On April 4th? And we watched the video extensively yesterday, so I may not, for everyone, I may not play it much, but do you feel comfortable just talking about it generally?
Yeah, I think I have a good working knowledge of it.
And obviously don't hesitate if there's anything you'd like to review, we can start the video. Now, fair to say the master and Taser instructor, we don't have to get into everything, but you have a significant amount of training to be the master Taser instructor.
Yeah, I was certified by the previous master Taser instructors at the department as just a Taser instructor for the department, and then you have to attend a 1-week course held by Axon to become a master Taser instructor. Basically what that means is I can train other individuals to be instructors as a Taser instructor for the department. So I'm the only one that would do that at the department.
And you may have mentioned this, but is the manufacturer, Axon, the manufacturer of the Taser device, are they actively involved in training you?
Yes, that's the 1-week course. They give you all the materials and documents that you need to train your instructors with and follow their guidelines. They don't make our policies and procedures how we use the device, but they train us how to train our instructors.
And then your instructors in turn train your officers or personnel?
Correct.
On how to use the Taser?
That is correct.
And are all officers who carry a Taser required to have Taser training?
Yes, you have to be certified to hit the road with this device on your belt. Everyone is certified. They go through their initial certification and then annual recertifications to continue using the device.
When you train, I could say GRPD, obviously Grand Rapids Police Department, when you train GRPD personnel, do you actually provide the trainees materials that are created by Axon, the manufacturer?
Yes, we use the most up-to-date version of their PowerPoint to go through how the device works, everything from the nomenclature of what they call it to safety and precautionary measures with it as well.
So those materials are obviously reviewed and discussed in detail with the trainees during the course of the training?
Yes, they are.
And are the trainees taught that the taser is a serious weapon and should be treated as such?
He's leading the witness. This is his witness. It's not cross-examination.
Counsel, why don't you rephrase that?
I said, are the trainees taught? And then started listing that off.
Well, I mean, if you're suggesting the answer, it's a losing question. I'll give you some leeway.
Do you train the trainees that a taser is a serious weapon and should be treated as such at all times?
Yes.
All times?
Yes.
Do you train personnel? Do you warn them that the taser can temporarily incapacitate a target?
Yes.
And do you teach them that the Taser 7 can cause death or serious injury?
Yes.
Are you required to train them, personnel, trainees, that administering the taser on sensitive areas of the body could in itself cause death or serious injury?
Yes.
Do those sensitive areas that you train to avoid include the head?
Yes.
And the neck?
Yes.
Does it include, you advise them there's danger of shooting somebody in the chest?
Correct.
And the genitals, is that an area that's trained to avoid?
Yeah, all those would be considered sensitive areas.
And sir, if both cartridges, and we went through the parts of the taser yesterday in depth, and that the device can hold 2 cartridges.
That is correct.
Even after both cartridges are deployed, can the probes still be re-energized?
Yes, you can re-energize the probes and the wires by either pulling the trigger or hitting the arc switch on the side of the weapon system.
So that the device still has the capability to cause neuromuscular incapacitation. Is that fair to say?
Yes.
Now, as far as the device, does the device have the ability, even after both cartridges are deployed, to also administer a drive stun?
Yes, it is. There are electrodes on the front of the device.
And the trainees, are the trainees taught that the drive stun is still in play even after both cartridges are deployed?
Yeah, we train them as a third point of contact where we're trying to close the loop. If you only have one probe on your target or subject that we want to reach for a different area and drive stun, that would be the motion, but we call it a third point of contact to get that positive negative connection to close the loop, and the goal is to get neuromuscular incapacitation.
And do you train the trainees consistent with Axon materials that the drive stun alone to sensitive areas of the body is capable of causing serious injury or death?
Yes.
In this situation that we're here for in court today, on April 4th, was the suspect who had the taser, was he in close enough proximity with Officer Schurr to use the drive stun function?
Yes.
Now, sir, I'd like to ask you, during the course of training officers on the taser weapon, does the Grand Rapids Police Department allow for voluntary exposures of training?
Yes, they are encouraged, but they are voluntary exposures.
So this is not mandatory?
It is not mandatory, no.
Now, just generally, why is voluntary exposure offered?
There's a couple reasons that we want to show people have an exposure, to go through an exposure themselves. I've gone through it. First reason is we want to know, the capabilities of the device, of what it actually does to your body, and you can feel it firsthand. Second reason is you want to be able to know that as someone is being tased and they are experiencing NMI, that they can still hear what you're trying to say, like put your hands behind your back and follow the commands at that time. And then lastly, obviously, the device, we want to show the capabilities of how it affects you, what incapacitation feels like, and if this device was used against you, you know how helpless you would be during that 5 seconds.
And was Officer Schurr voluntarily tased during training?
Yes, he was.
And that was prior to April 4th of this year?
Correct, and it wasn't by me, but he was.
Now, these voluntary trainings, they're done in more of a controlled environment, is that fair to say?
Yeah, there's a lot of safety protocols in place to make sure our officers don't get injured during this. They're in a mat room. We have spotters holding them so they don't fall and hurt their head or neck, and it's very controlled.
Sir, changing gears a bit here, but does GRPD have training on weapon retention?
Yes.
And if you could just give me what is weapon retention, just a brief.
Weapon retention, when people talk about weapon retention, they think primarily their gun on their belt. But we have multiple weapons on our belt system that could be considered a weapon. The Taser being one, the ASP baton. So what we train is how to make sure someone doesn't grab it off of our belt or out of our hands, and available use of force techniques and to prevent them from getting it, or even actually training if you were disarmed, how to get that weapon system back at times.
Sir, would it be reasonable an officer who's been tased or even watched other trainings get tased or watched videos on the effects of it, would it be reasonable for an officer to fear that the suspect would be able to access their duty belt if they were being tased?
Yes, it would be reasonable to believe that during that 5-second incapacitation that you would be helpless in defending yourself.
Now I'd like to move to some topics involving the incident here. And you mentioned you were able to view the Officer Schurr's body camera video and the cell cam video of the passenger.
Correct.
Is that right? And, sir, rather than asking you off memory to define certain policies, does GRPD define escalation of force as an officer's increased control response to a subject's increased level of resistance or aggressive action when the level of force being used is insufficient to stop or control the resistance or aggression?
Yeah, that's in our policy.
Sir, with your review of this entire scenario with Officer Schurr, did he follow appropriate continuum of force measures throughout this interaction to meet the suspect's level of resistance and aggression?
Yeah, he was working through his available techniques and responses to what was happening in front of him.
And prior to the suspect running on foot, is it true, had the suspect already resisted or obstructed a police officer?
At the moment, he basically swung his arm back and spun on the officer. Then yes, he was resisting and obstructing a police officer.
And under Michigan law, is resisting and obstructing a police officer a felony?
Yes.
Now, the suspect, as we mentioned, the suspect then runs on foot. Is that correct?
That is correct.
And in regards to Officer Schurr running on foot, let me just ask you, can you just tell us what is MCOLS?
MCOLS is the Michigan Commission on Law Enforcement Standards. They are the governing body that hold our certifications in the state of Michigan as police officers, and they also require certain training levels for each department and police officers in the state of Michigan.
And does MCOLS have a list of essential job functions a law enforcement officer is required to follow?
Yeah, there are several.
And, sir, is it true that one of those functions states that it is essential that a law enforcement officer will, quote, pursue fleeing suspects on foot by both day and night in unfamiliar terrain?
Correct.
Now, what if a police officer fails to pursue a subject? Can you just explain, could that be a grounds for cowardice?
It could, based on the situation. If it was unsafe to do so, no. But if it was safe to do so, then you could say that.
Because let's say if a subject flees, perhaps you let them get back into a motor vehicle. Perhaps they're heavily intoxicated. They go down the street, they hit and kill somebody. The officer could be in a lot of trouble for not pursuing that individual, letting them get back in the vehicle.
There'd be a lot of questions of why they allowed that to happen.
So Officer Schurr here, he pursues the suspect on foot. Does the suspect then move from what your policies would deem passive resistance to active resistance?
Yes.
And from resistance, does the suspect then move on to active aggression?
Yeah, you can see on the video where he's spinning and throwing elbows a couple times, either to break the grasp or to assault the officer. That we don't know what the actual intent was, but that can be perceived as active aggression.
And did Officer Schurr then move on to use what his training would deem reasonable measures to attempt to gain control of the suspect?
Yes, he attempted to tackle and control him on the ground. He was unable to. Got up. He again spun and threw like an elbow around to break free or attack the officer. We'll never know. And then he escalated to introducing the taser into this incident.
And prior to the taser, did it appear the suspect continued to forcefully avoid being captured? Is that fair to say?
That's fair to say.
And at some point, and I believe you already mentioned this, the suspect ultimately began attempting to disarm Officer Schurr of his weapon. Is that correct?
Yeah, on the video, you can see Officer Schurr present the weapon to use it, and then it was immediately grabbed by Mr. Lyoya, and then he was actively disarming him for several seconds.
And did the suspect use what you would deem as force to attempt to disarm Officer Schurr?
Yes, I mean he was grabbing onto it and trying to either pull it away or not letting go of it, not following commands.
And is attempting to disarm an officer, is that a felony under Michigan law?
Yes, it is.
Is forcefully disarming a police officer, would that be deemed an inherently dangerous felony?
Yeah, it is a dangerous weapon that's being taken from the officer, and the officer would be fearful of why they're taking it, if they're going to get used against them.
Now, for the police officer, have you seen on the video, even prior to the taser, did Officer Schurr, was he already going through a physical struggle and may have been showing signs of exhaustion and stress?
Yes, you can see that in the video, just based on the breathing, the way the commands are coming out of his mouth. You can tell that he's expending a lot of energy and getting spent.
Would it be fair to say that when it turns to a suspect attempting to disarm him, that would add even more stress and fear for a police officer involved in that situation?
Yeah, that'd be a highly stressful event to go through.
We'll move into Officer Schurr's use of deadly force in just a moment here, but leading up to that, does Officer Schurr appear to have attempted to utilize other reasonable force options that were within his abilities at that time?
Yes,
Now, can you give just a brief explanation, Grand Rapids Police Department, how use of force situations should be evaluated?
We have to evaluate use of force situations. A similarly trained police officer with the same experiences, and then look at their decision of what force was used. Was it objectively reasonable at the time it was used? And you can't look back in hindsight. It's at that time, what was going on at that time when that decision was made.
And that's important, at that time, no hindsight. Is that fair
Correct.
to say?
Yes.
As someone who's been a police officer for as many years as you have?
Yes.
Now, sir, before I get into the final areas of discussion here, I just wanted to ask you a few more questions concerning other felonies that you may have observed from watching the video. Now, and actually, let me take you through something here a moment. Could you please start the video? So I'm just going to take you through several slides here, okay? This is a video that we watched yesterday, and it's been broken down into several freeze frames. I'd like to ask if you could just go ahead and go through these slides, and then I'll ask some questions. And what that is it's frames 7,432, and I believe it's 50 frames. Sir, is there anything training standpoint that you see remarkable, and we can go through it all and then come back again, but anything remarkable that you're noticing here prior to Officer Schurr reaching for his firearm?
He's really off balance. His feet and knees are off the ground at this time. Basically just hanging on at that point.
Now, how about the suspect in his body position? Is that also changing?
Yeah, it's constantly changing throughout that, but yeah, he has a much more stable platform.
That's reference point 7,450. Now, sir, under Michigan law, is it a felony to assault someone with a dangerous weapon?
Yes.
Now, under Michigan law, is it a felony for most persons to even possess a taser?
Yes.
Now, is it a felony under Michigan law to commit larceny from a person?
Yes.
And is larceny from a person basically stealing something from the person or from the body, taking somebody's property or something else from the person of another?
That would be the definition of larceny.
And the suspect here took the taser from Officer Schurr?
Correct.
Sir, I'd like to get into deadly force factors within Grand Rapids Police Department.
When an officer deems it appropriate to use deadly force, that it's now turned into a deadly force situation, are there various means that might be reasonable at that moment for the officer to administer deadly force or to use deadly force?
Yeah, deadly force is not limited to a firearm. You can escalate to deadly force in various different options of striking in the head with a baton or with your radio or hitting them with your car or choking someone out, limiting their airflow.
So basically, what's reasonable at that time to end the threat?
Yes.
And once the decision's made to use deadly force, you can use deadly force however is reasonable. Is that fair to say?
Correct. If you perceive that threat that would authorize deadly force, then yes, you can use any means necessary.
You already mentioned firearms. Certainly you have firearm training as standard protocol within Grand Rapids Police Department?
Yes.
And do you train to shoot in different areas of the body depending on what is reasonable under the circumstances?
Yes.
You sometimes train to shoot for perhaps center mass area of the body?
Yeah, the majority of our training is then hit center mass, but there are many other target areas that we focus on that are available at that time.
And you also train to appropriate to shoot for the head?
Yes.
Do you train to shoot from different positions?
Yeah, we shoot from many different platforms, from laying prone on the ground, from kneeling to squatting, while moving, many different platforms.
And you may have already answered this, but just to make sure I get this point across, are officers trained to avoid headshots? Is that something that they're trained?
To avoid headshots? No.
Okay. Now I'd like to go through this. Grand Rapids policy manual include a rather non-exhaustive list of factors to consider when assessing totality of circumstances for an officer to escalate use of force. And does that list have approximately 15 factors or so to consider?
Yeah.
But that's not all of the factors, obviously.
It's not an exhaustive list, but those are the ones documented in our policy.
But I'd just like to go through a few of those and ask you if those may have been at issue here. One factor, size and stature. Does it appear here that the size of the suspect may have been an issue in Officer Schurr's inability to gain control of the subject?
Yeah, just based on the video, I mean, it appears that Mr. Lyoya has a weight advantage over him.
It's another factor, multiple subjects. Is that something to be conscious of?
Yes.
And whether the officer is outnumbered?
Yes.
And that can that be a significant circumstance for the officer, on the mind of the officer as he's assessing what the threat may be around him?
Yes.
And is it clear from the video that was present here where the officer was outnumbered by the subject and the passenger of his vehicle?
Correct. There's a passenger and then another unknown individual on scene as well.
And Officer Schurr, I believe you've established, was he radioing for backup on multiple occasions?
He was.
And according to the video, at least, does it appear there was no sign of backup or assistance?
There was not any other officers on scene at that time.
Now, as another factor that might be considered, subject's weapon. Is that a factor to consider?
Yes.
And here, the weapon, we've discussed it already, but suspect disarmed Officer Schurr of a serious weapon, is that correct?
That is correct.
And a weapon that Officer Schurr is trained can cause death or serious injury, is that correct?
Correct.
Another factor, alcohol or drug involvement. Do we know now that alcohol was certainly a factor in this situation here?
We know that now. I just wouldn't know that just from watching the video, though.
Sure. Now, how about exhaustion? Is that another factor to consider in the totality of the circumstances?
Yeah, exhaustion, fitness level, and
Can you just explain, just generically, in the course of training, and we're going to get into this more, perhaps with some other witnesses, but just survey the topic.
No, exhaustion is one of the totality of the circumstances that need to be considered, because a long, drawn-out struggle, you can only go at 100% for so long before you start depleting your energy supplies, and then your skill set starts to diminish during that time frame. For as long as it keeps going, your abilities are diminishing and depleting at that time.
And do you have scenario-based training?
Yes, we do a lot of scenario-based training.
And do you generally try to time those routines out? Only let the training officer go at a physical struggle for a certain amount of time?
Yeah, I mean, our scenario-based training is objectively based. We're trying to meet an objective. Some of them are long, drawn-out, physical altercations on a wrestling mat where you're trying to get someone in custody, and we're not allowing them. Some of them are really quick scenarios, but.
And can exhaustion be intensified by stress, fear, or adrenaline?
Yes.
And are those basically just human factors?
Correct.
Now, one other factor, weather or terrain, does that appear to have been an issue here with rain and slick conditions?
Yeah, it appeared to be raining. I was out on the scene, it was raining. It was, you're in a yard that is slippery and muddy. You're not on the best footing.
Just a few more here, but another factor listed in policies, reaction time. Is that correct, that that's listed in the policy?
Correct.
Can you please, do you train your trainees about action versus reaction?
Yeah, action, it's not only a standard in law enforcement, it's in pretty much anything. Action is faster than reaction. So the person that wants to make the initial action, the officer in this scenario has to perceive that action, come up with a thought process of how to react to it, and then actually physically do it. So action is always putting the officer at a disadvantage, because of reaction.
Can you discuss, or I'm not sure if you show videos on the topic, but discuss scenarios as far as a suspect with a weapon and drawing?
Yeah, there's a multitude of different videos, but I mean, a good example of it, Your Honor, is, if you even had your gun out and you're in a low ready position and you're dealing with an individual that potentially is armed with another gun, they can spin and raise that target and shoot at you faster than you can perceive that threat and react to it and get shots back at that lethal, deadly force encounter at that time. And it just drives home that action's faster than reaction.
And that is a concept that you train your trainees to be conscious of?
Yes.
How about, as another factor, distance from the subject? Is that also listed in the policies?
That is correct.
And I believe we've touched on it, but here the suspect and Officer Schurr, would it be fair to say that they were within arm's length at the end of the struggle here?
Yeah, they were wrestling tied up.
And were they within range of the officer being used to cause serious injury or death?
Can you rephrase that?
Were they within range of the taser being used to cause serious injury or death?
Yes.
Last factor, sir, do the policies list imminent danger as a factor?
Yes.
And you may have just answered this with your prior two answers, but we had the suspect, as you just explained, was in arm's length distance from Officer Schurr. Is that correct?
Yes.
And the suspect had what is deemed a serious weapon that was still capable of causing serious injury or death. Is that correct?
Correct.
And Officer Schurr is trained that action beats reaction.
Yes.
Is that correct? And the suspect that he was just dealing with had just forcefully disarmed him of his weapon. Is that correct?
Yes.
So would it be fair to say that imminent danger was at issue here?
Yeah, that'd be reasonable to say.
Now, sir, based on all the factors present on the video, and I know those factors we discussed, there's several other human factors that come into play for training officers, is that fair to say?
Yes.
For purposes of prelim, let me just ask you here, in conjunction with the factors mentioned, in conjunction with what's on the video, and in departmental policy, the suspect here had forcefully disarmed a police officer. Is that right?
Yes.
And the officer was outnumbered with no sign of assistance. Is that fair to say?
Yes.
And did the officer appear exhausted from minutes of struggling with a suspect who was evading capture with active aggression and resistance?
Yes.
Did the suspect's physical strength or size, did that appear to be prevailing when he was literally lifting Officer Schurr off the ground at the end?
It appears that officer was unable to control that individual, and that may be the cause.
And the suspect had a weapon in his hand that was capable of causing serious injury or death.
Yes.
The suspect was in close enough proximity to use that weapon. Is that correct?
Yes.
And the suspect had already fought with force to disarm the officer. Is that correct?
That is correct.
And the officer had been taught that action beats reaction. Is that correct?
That is correct.
Based on the totality of those factors, was it reasonable for Officer Schurr at that time to conclude there was a reasonable threat of serious bodily harm or death?
Yes.
Thank you, sir.
Captain, I guess I'll go through your use of force. We've talked a lot about it already in terms of, you're familiar with the use of force policy that's on the website of the Mayor's Police Department?
I am.
In terms of 9-1.1, the goals of the use of force policy, I'll cite number 1. Use only a reasonable amount of force to conduct law enforcement activities. That's on there, correct?
Correct.
Number 2, use only a reasonable amount of force to save lives, overcome resistance, and maintain an advantage. That's on the website, correct?
That is correct.
Number 3, use deadly force. I'm going to summarize this because it's quite a long paragraph, but you can only use deadly force against a reasonable threat of death or serious bodily injury, and when the officer has probable cause to believe the subject poses a reasonable threat of death or serious bodily injury to the officer or others. That would be the 3rd paragraph in summary, wouldn't it be?
Yeah, that's part of it.
Going to 9.1-2, objective reasonableness. That's part of your policy. Objectively reasonable means that using the manners in the light of all the facts and circumstances, the totality of the circumstances, if you will. That's part of that you got to take into consideration.
Correct.
So I bring that up because, Mr. Dodge asked you on direct exam something about, well, if somebody runs, the officer's just going to chase him. And you kind of said yes. Under the wouldn't it be the circumstances? So, for example, since I'll throw this up there, somebody's a stolen car, driver's stealing the car, passenger shooting shots out the window, car comes to a stop, driver runs, passenger stays. What would the officer do in those circumstances?
At that point, like I said I believe in the initial, is that when it's safe to do so. So obviously, the more serious threat at that time is the person shooting, so you'd stay there.
So he's going to stay there. It's not like somebody runs and you're kind of a greyhound just chasing whatever runs. You're going to base it on the facts and circumstances.
No, it's not like a bird dog,
Yep. So it's based on totality of the circumstances. So you're going to take, and then part of that is a crime, obviously, since if somebody's shooting, that's more serious than somebody stealing a car, correct?
Correct.
Going to your use of force, I'm looking at 9-1.3, use of force, and you have kind of a level of resistance. You have potential inactive resistance, passive resistance, active aggression. You're familiar with that?
Oh, yeah.
So active aggression is listed as physical actions or assaults against officers or citizens with less than deadly force, i.e. advancing, challenging, punching, kicking, grabbing, wrestling. That's what that means?
Yeah, that would be active aggression.
Okay. So active aggression, that's what Mr. Patrick was doing, active aggression in this situation.
Correct.
Going to authorize, you have a specific section, authorized use of deadly force, and it does say to prevent the escape of a subject who is fleeing from an inherently violent felony crime. I want to ask you about that. What is an inherently violent felony crime?
That's where you have probable cause that if they're not arrested, that they will harm someone else.
Okay. Do your officers get a list? I mean, do you say, okay, here's a list of violently crime? Because I couldn't find anything, so you tell me.
No, there's not a list. It's discussed through training. A great example would be that we speak of is the Roderick Danzler incident. He's an inherently violent fleeing felon that needed to be captured.
Okay, so that was the man who killed his, I think it was girlfriend, his family, and then was, driving essentially through the streets carrying weapons like a madman.
Correct.
But I guess you list a number of felonies. Is resisting an opposing officer an inherently violent crime?
No.
Okay. I guess simply disarming a police officer, is that an inherently violent crime?
It could be, yes.
It could be, yeah. Depending on the facts and circumstances.
Correct.
So once again, there is no bright line rule of inherently violent crime. It's going to depend on what's going on in that crime at the time.
Correct, and that's what it's reasonably perceived by the officer, and it's reasonable at that time.
Okay. Now, part of your training as well, in terms of a Taser instructor, you talk about what you're trained on Taser. One of the things on a Taser is that it may not work, right?
Correct.
They're kind of finicky, if you will. If those two probes, if a probe misses, you don't have a circuit, you're not going to get the NMI, correct?
That is correct. They're imperfect, but they work.
But they're a tool, if you will.
Correct.
So one of the things you train on is if it doesn't work, you need to be ready to transition to something else, correct?
Correct.
One of the things, and then the Taser is not the only tool in your belt. Your belt has, you said, an asp.
Correct.
Your belt has a pepper spray.
Correct.
And even through your use of your training, in desperate situations, a flashlight.
Yes.
You've got a big flashlight. The flashlight can be used to, strike somebody.
Yeah, or your radio.
Okay, or your radio too. So there are other options after the Taser. It doesn't go, okay, physical Taser gun. There are other options that an officer could potentially use.
Like you said, there's no clear lines of what you have to do following this.
You don't have a okay, go pepper spray first, and then ask, and then, okay. But it's based on the facts and circumstances once again.
Again.
I guess I got to ask this question, and maybe, I guess listening to your testimony, basically you said he did everything right in this situation.
Is that a question?
Yeah. Sorry. Correct me if I'm wrong. I mean, you said he did everything as he was trained to do. He did everything correctly.
Yeah, he went through his use of force options to the best of his ability during that time.
Then why was he fired?
I did not do that, so I don't know.
But I guess by your training standards, there's nothing based on what he was trained on that should have led to his termination.
I did not complete that investigation, but it's my understanding that there was no training policy or procedure violations regarding the use of force that led to his termination.
All right, thank you. Nothing further.
Is it going to be possible Officer Schurr was fired because he was charged with this offense?
That is my understanding, yes.
Not because he did anything wrong, because he was charged with this offense. Is that fair to say?
Yeah, that's my understanding.
If you know. As far as Officer Schurr doing everything right, does the officer have to do everything perfectly? Is that the standard?
No, the law allows for mistakes. They allow for not being perfect. Was it reasonable at the time it was done?
Now, the taser, the prosecutor brought up the taser, and the taser might not work. So maybe moving to other modes of weapons. Does a officer have to meet intermediate threat, intermediate force with another means of intermediate force, such as a baton, or can they escalate that to something higher?
They can escalate if they believe that it is not working or they believe it's going to not be sufficient to control the force.
And if a suspect has a taser in their hand, does the officer need to wait for the subject to use that or to see if the taser works before they advance to something else?
No.
Chasing and arresting. It's often unsafe for an officer to go chase an individual.
There are a lot of job functions that we do that are unsafe.
And the officer's not prohibited from chasing individuals, is that?
No, they're not.
One moment, please, Your Honor. No further questions. Thank you. Mr. Becker?
You go, Your Honor.
All right, thank you. You may be excused.
Thank you.
Well, Your Honor, we take a very short break. After we're witness level. Thank you.
We'll take 10 minutes.
Defense rests at this time.
And Mr. Becker, any rebuttal?
We have no rebuttal, Your Honor.
All right. And the people have a motion.
I do, Your Honor. I would move for bind over on the count of second-degree murder. Your Honor, for a brief argument, I know the court has already gotten our brief and gotten the defense brief, but I want to touch on a few things. And to be frank, I guess we've had discussions a little bit, but I don't think this is a close call for the court. I think it's fairly easy for you. Basically, the court is very well familiar that the elements of second-degree murder are a death caused by the defendant. In the circumstances of this case, it's very clear there's an intent to kill. That's not an issue. The only issue in this case is the element number 4. Is there some sort of justification? And that's what the court to some extent has got to determine, but ultimately that's a jury question, Your Honor. I think the law is behind this. And they offer, essentially 2 reasons of justification in their brief. First, deadly force to prevent a fleeing felon. Your Honor, the fleeing felon defense, it is there, but what is the key thing? The key thing, and we agree, that's the thing, a lot of things we agree on in terms of People versus Couch. They cite in their brief, when you look at People versus Couch, when you look at it, I'll quote directly from that case. Both officers, this isn't just civilians, officers and private persons seeking to prevent a felon's escape must exercise reasonable care to prevent the escape of a felon without doing personal violence. And it's only where killing him is necessary to prevent this escape is that killing justified. Okay, necessity, that's a key thing in this one. And that goes true for their other reason, is in terms of self-defense, reasonable self-defense. Well, once again, we've cited People versus Heflin, and the general test, and the court's well familiar with it, though, is that the defendant honestly and reasonably believes he is in danger. The danger the defendant fears is serious bodily injury or death, and the defendant's use of force appears immediately necessary to defend himself. So once again, necessary, immediately necessary. We'll pull up that. We've presented well beyond the probable cause standard to show that this is somehow immediately necessary. And I was going to pull up, you have your, I don't know if that pulls up again.
Through Zoom, or you want through Zoom here?
I mean, I'm using one of the defense exhibits. This is the defense exhibit. And in terms of when you're talking about necessary and immediately necessary, this is the exhibit. The last thing where we talk about, you can see the casing discharging from the gun. This is the moment the shot is fired. Okay? As a matter of law, can the court say this is necessary to prevent a felon's escape? That this is immediately, there's self-defense that's immediately necessary when Patrick's lying face down on the ground with the taser's not even pointed at him? And then you add on with what the medical examiner said. This is a direct shot to the back of the head. This is a contact wound. There's no suit around the wound. That's in the transcript you have. It's a contact wound to the back of the head with the bullet traveling back to front and upward. Upward in terms of in the head because he's down on the ground. His face is down on the ground. So as a matter of law, the court can say this is immediately necessary. That's not your call. The cases all say that this is something for a jury to decide. The Hampton case that we cite, this is something for a jury to decide. Self-defense is something for a jury to decide. I hate to say that, Judge, this is, it's something for you to do. It's not a question of, well, they've called an expert. They called an expert. Chad McCarthy had an opinion that, yes, this is all reasonable. As you all know, jury instruction 5.10. Juries you can disregard an expert's testimony. We had a lay witness saying, well, this is an execution. That's why this is a jury question. People differ. And it's going to be up to 12 people from Kent County to make this decision as to whether this is reasonable or whether this is necessary. And I think that's the ultimate question, and it needs to be bound over based on that reason, Your Honor. Thank you.
Thank you, Mr. Becker.
Thank you, Your Honor. Your Honor, we agree with the prosecution that it is his burden to show probable cause for the court to consider on each of the elements of the crime. We also agree as to the elements of second-degree murder. A death caused by an act of the defendant, absent circumstances of justification or excuse, and done with the intent to kill. There's really no dispute here as to the cause of death. We didn't hear from the medical examiner here, but the transcript shows that the cause of death was a gunshot to the head, which went from the back of the head out to the right as the defendant turned his head to the left. So as the defendant was turning, a shot was fired, and that's in the medical examiner report as well. But there's really no dispute as to the cause of death. It was the gunshot. He didn't die from any other cause. There is a significant dispute as to the law of what the prosecution must present to the court and what the prosecution must show by probable cause to the court for the court to bind this over. So there really is this initial question, which the prosecution has briefed and also has talked about today, is whether or not this is even a crime. And we don't think this is simple, and we don't think this is not a close call when it comes to the law. The prosecution's standard is apparently that this court might find probable cause that this was not immediately necessary. I believe.
Well, I say I don't want to interrupt you, but I'm interrupting you. I want to ask you some questions, see if I can have you focus the argument for the benefit of the court.
Of course, Your Honor, and I'm happy to.
Let's presume, because I think you're right. I think that there is some murkiness in the law as far as what the actual standard is, and it appears to me that the standard in Michigan is still the old common law standard. But let's assume that it is the worst standard for your client. Then apply the facts to that.
When you say worst, meaning the most difficult
to overcome,
to overcome or defend.
To suggest that, and I think it would be the common law, obviously, the notion that it is highly privileged, the right to defend or stop a fleeing felon.
I mean, is the court suggesting that the common law is a more restrictive standard on the officer than Tennessee v. Garner?
No, I think
just the opposite.
It's the opposite.
Okay, so we agree on that. And
So the court wants to know whether under Tennessee v. Garner,
Yeah, correct.
I think that the undisputed evidence that the court has heard is that the officer acted reasonably under the totality of the circumstances. So if this were a civil case, which it is not, the only evidence the court has heard is the opinion evidence of Captain Kersey. And now there's a video of the killing, but that proves the killing, and it proves that it was Officer Schurr was the one that shot Patrick Lyoya. The question of justification under Tennessee v. Garner, the civil standard, that is...
Let's do it under the common law then.
All right, well, the common law, I think, is even less restrictive. I think the state of Michigan has one of the least restrictive laws anywhere in the country. After Tennessee v. Garner, most states, in fact, almost every state but 2, decided, we should get something on the books to decide when an officer can be charged with a crime and when a private citizen can be charged with a crime. And there's a difference.
Let me ask you this. Here's really where I'm getting at. Even under the common law standard, isn't there still the question of necessity that applies a gloss over the entire thing? It's not an absolute, because you're asking, in order for the court to not have it over, the court has to conclude that under no circumstances, no reasonable person could conclude that this was beyond what was necessary. Isn't that
and if I could ask the court a question, what does it mean for a police officer to do something that was unnecessary? Well, I'll tell you what the state of Michigan in its common law has said, because there's been a divide, if you look at the cases, before and after Tennessee v. Garner, of what an officer can do and what a private citizen can do. And the cases do not speak of necessity as to an officer. All those cases that Mr. Becker's talking about, that has to deal with a private citizen and when he can act in a citizen's arrest. In this state, Your Honor, if you go back 150 years, people will be appalled about what a private citizen could do. And, there's a great discussion in the Whitty case, which is in both of our briefs, and I would just like to read a passage talking about the evolution of common law, which this court must follow in the state of Michigan. And this is because prior to this, and Tennessee v. Garner talks about this, most felonies, you were imposed a death sentence. And shooting a non-violent fleeing felony historically would have been permitted because it's the same result as if you'd been caught and convicted. And on Tennessee v. Garner, this is no longer the situation, and for good reason. No one's suggesting that that should be the law, but whether it is, should be, or should not be is not the question for this court.
But wasn't exactly what you're suggesting rejected by the Supreme Court for people to be challenged? I'm looking at footnote 1, where the majority said, hey, to view Garner as creating a separate standard under Michigan law would essentially create 2 different definitions of murder, manslaughter, one for police officers, one for the rest of us. Such a scheme could raise a significant constitutional question. Isn't that what you're suggesting?
I think the constitutional question that they're suggesting there in dicta is that what is the due process to the officer or a private citizen if they don't know what necessary means in the circumstance? So there certainly is a due process argument, and I agree with the Supreme Court there, because this has not been resolved. And certainly on that level. That case involved a private citizen. And in the Whitty case, it says the common law in Michigan recognizes that the occasion may arise where a private citizen is confronted with the choice of attempting a citizen's arrest or letting the felon escape in order to make a citizen's arrest. It is regrettable, but sometimes necessary to use deadly force. The common law in Michigan recognizes, but still stops far short of granting a private citizen a license to hunt down and kill those suspected of committing a felony. The use of deadly force is not justified if the person is to be arrested is not, in fact, a felon. Additionally, and most importantly, the use of deadly force must be necessary. And we're talking about a private citizen, either to meet deadly force or to prevent a felon's escape.
Then what would you suggest is the standard that would apply to police officer? One that is completely unreviewable?
No, of course not. There is a standard. Police officer in People v. Fiedler, because it was an officer in that case, was charged with involuntary murder. And this is when they said he could use deadly force. The officer used deadly force when necessary to prevent the person from being arrested for fleeing. So if he's going to get away, you can use deadly force. That's
Kind of a predicate felon.
well, yes, and I don't think that's in dispute here. Even the prosecutor admits and concedes that there's ample felonies.
Can the felony be
A question of fact?
resisting arrest? I mean, that's the...
Absolutely.
And why?
Well, and I didn't get to the second prong, Your Honor, because the second prong says there's no necessary requirement in Fiedler when the arresting person is met with force from the party to be arrested. And this makes perfect sense if you look at our history of common law. Because up until now, and there is no statute, if you go back 100 years and you said somebody, if you fight with a cop when he lawfully is arresting you, not talking about an unlawful arrest, he's constitutionally got the right to arrest you, and you fight with him, resist, active resistance, like Detective McCursey said, then you have a right to use deadly force.
Would that be a felony at common law, though? It would.
Resisting and obstructing?
Correct. At common law. I mean, that's if it's a common
absolutely
law,
it's a felony.
If it's a common law standard, and the common law standard is by way of reference to felony, wouldn't that be not felony as we understand it today, but a common law felony? And those are, and there's 9 common law felonies. They're very specific.
So it comes down to whether or not he committed a common law felony.
I don't know, isn't it?
I would think disarming a police officer is a common law felony. Assaulting a law enforcement officer is not a common law felony?
There's 9 common law felonies.
Okay.
Murder, robbery, manslaughter, rape, sodomy, larceny, arson, mayhem, and burglary.
Mayhem.
All right.
If that isn't mayhem, Your Honor. I mean, there's a reason we have statutes, so people understand how to conform their behavior. And perhaps shame on the legislature for not addressing this issue. But we cannot held the officer to a higher standard than that is afforded under the law. And certainly, or what a private citizen can do. And so, when the arresting person is met with force from the party to be arrested, People v. Fiedler understands that to mean a police officer can use deadly force. And it was an officer who was shooting at someone who was running away. And he got in trouble in large part because I think there was some question of whether or not that was actually the person that did it. But there are very few cases where police officers get charged with any type of murder. And I cannot find a single case where an officer has been charged in Michigan with murder. And here, if you look at whether or not he's fleeing, I mean, I think the question of necessity. You have Patrick Lyoya, it's a lawful stop. And you had heard no evidence that this was an unlawful stop. I don't think anybody who's got any experience in criminal law would suggest that there wasn't grounds to pull him over. The methods he used through this system were perfectly in line with his training. Well, maybe not perfectly because that wasn't the standard, but they were in line with his training. The training officer told you that. Patrick Lyoya jumps out of the car. He fails to obey any commands. 30 commands. He uses active resistance, shoves the officer, and he's committed a felony at that point. And he flees. He has reason to flee. So we know he's fleeing because, as Detective Stasiak said that she found in the car, it's loaded with evidence
of identity theft. And he also has active warrants out for him. So this is a lawful arrest before and after they searched the car, which is what it would have done. And Patrick Lyoya knew this. That's perhaps, we don't know what was in his head, but that's the most likely reason he was fleeing. From the officer's point of view, he has no idea who he is at this point. It is 8 a.m. Monday morning. He knows this person is not listening to anything he says. He is calm, he is respectful, and as Patrick Lyoya escalates, the officer responds, but in kind. He doesn't, this is not the Old West where it's a fleeing felon and he's like, well, I'm going to shoot him because he's 4 feet in front of me. He doesn't do that. And he had the absolute right to chase him. Especially, think of the situation. It's a school day. It is 8 a.m. What would we be calling Officer Schurr if he had let Patrick Lyoya go? From his perspective, he has no idea who this person is other than he jumped out of the car and wouldn't listen to the thing he said, actively resisted, and ran. And he's supposed to just let him go? He's at .33. If he had got back into another car or went into a building, which are all reasonable things to consider if you're an officer, if Patrick Lyoya had run somebody over or gone to a school, which were nearby, we'd be calling him something else. At a minimum, we'd be calling him a coward. And so we're calling him a murderer here because he didn't let him go. That's the suggestion. Because it wasn't necessary. It wasn't immediately necessary.
And those, I understand all those arguments, but aren't those arguments better put to the jury? That's really what it comes down to. Is we're here. The question is simply whether there's a probable cause. Those are all arguments against it. All arguments supporting that everything was reasonable. I mean, at the end of the day, that's the standard.
Well, a lot of issues are left for a jury when there's a conflict in what the facts could be. If the issue of justification, even under the most restrictive standard, Tennessee v. Garner, is the jury going to rely solely on their understanding of excessive force laws and training of police officers in this case? No. They're going to rely on expert testimony. The prosecution decided they don't want to call their expert. So there is no evidence, no opinion evidence of what is excessive, what is reasonable, what a reasonable officer would do, except Officer Schurr's training officer, who has decades of experience, who knows exactly how to train these officers, and he said he exactly followed his training. And under the totality of circumstances, this was reasonable. So what facts do you have, Your Honor, that this, under the totality of the circumstances?
The court can draw reasonable inferences, it's required to draw reasonable inferences. So you're asking me to conclude that no reasonable fact finder would find that this is anything other than reasonable.
Yes.
That in turn really is, that question is one that to say that reasonable minds cannot differ on that.
Well, you've only heard from one mind, Your Honor.
So we've heard the facts, and again, one of the things that stuck out to me was Captain said, well, we don't really know whether Patrick Lyoya was, in his aggression, was trying to break the grass in a defensive way or attack the officer. And I don't know if that would change things or not.
I don't think that matters under the law. I don't see that it makes any difference under the law. And I'm only asking the court to make legal determinations, except to the fact there are undisputed facts. Certainly, the court's going to assume certain facts And not everything goes to the jury. I mean, the court will make a finding that Officer Schurr is a GRPD officer. There are lots of things the court finds because they're not in dispute. If the prosecution truly believed that this was unreasonable, they should have put on some evidence that it was unjustified, not just play the video. That's not the standard for this court. You are the gatekeeper of whether or not something should go forward. Because the prosecutor even said, well, if this was reasonable, why did he get fired? And the only reason he got fired is because he was charged. So no one's made a finding that this was unreasonable other than the prosecutor. And so now we're asking you, given what you've heard, the opinion testimony of the training officer, that's unrefuted, no rebuttal, how can you make a finding that a reasonable jury could find that this wasn't justified as the standard is set by Tennessee v. Garner? And Your Honor, I do want the court to consider the common law with regard to the second prong, which has not even been addressed by the government, which is that it's justified that what Officer Schurr did if he is met with force in response to a lawful arrest. This was a lawful arrest. There is absolutely no evidence whatsoever that he did anything unlawful in effectuating an arrest. And there's absolutely no evidence that Patrick Lyoya did anything but fight the entire time. He pushed, he shoved, he popped his arms. He's committing an inherently dangerous felony, according to Captain McCursey. And, you know, that's all policy, which, by the way, is not relevant for common law. But if it's going to guide or inform the court on what is actually reasonable under the circumstances, Captain McCursey said it's inherently dangerous. I would say that the court just looking at the video, that's an inherently dangerous situation. You have a person who will not comply, who grabs a taser, who ultimately takes the taser from his left hand to his right. So at some point it got transferred and is turning, as the medical examiner's report states, because the bullet went from the back of the head out the right. And he concedes, yes, his head was turning. And if you look at the video closely, you can see the taser going this way. And so the officer, in this case, is not held to a standard of what was it really necessary to shoot him. That is not the standard. The most restrictive one would be Tennessee v. Garner. Or would any reasonable officer, any, in this situation, have acted that way? We can't find an officer who would say that they wouldn't have acted with deadly force in that situation. He disarmed him of his taser. Their own expert is talking about how dangerous these things are, even in drive stun. You can lose an eye, you can collapse a trachea, it can kill you if you hit it in the right spot. So whether or not the second cartridge was fired is completely irrelevant. Nobody has said that that's sort of the question of fact for a jury to decide. Well, if it was only the drive stun, then it's not, can't cause bodily harm. So no, that's not. Their expert on tasers says this is, we train people, do not drive stun somebody in the face, in the head. Stay away from there. Why is that? Well, it's huge liability, not only for the officers, but probably for Axon. So this is not a civil case, but even if it were, you have heard no evidence whatsoever that the experts in the field think that this wasn't unjustified. So it certainly is an issue of active resistance, and under common law, when met with force, making a lawful arrest, you can use deadly force. Now, should that be the law? No, but that's a question for the legislature, not this court. Whether or not it was necessary to use deadly force when met with force, I don't think is the law. And respectfully, I encourage the court to read the cases that talk about that second standard. Almost all the cases talk about the situation where someone is running and he's getting away, and do we really want a private citizen to wing somebody from 20 feet because they think he's going to get away because he committed a felony? That's what these cases are talking about. The reason there's no cases about all the times we've charged police officers with murder under common law
is because it's not murder. He has the absolute right, in fact, he has the duty to arrest him at this point. It is his obligation. And the difference, Your Honor, too, between private citizens and police officers is that private citizens now have a duty to retreat. We don't want average guys running around making citizens arrest and feeling they can essentially stand their ground if they're met with force. If you're in Michigan, I know some states have stand your ground laws. We're not one of them. In Michigan, if you're making a citizen's arrest because you know someone's committed a felony, if you have the opportunity to retreat, you absolutely have to. Otherwise, you're not going to have a defense of self-defense. You have to retreat. If you can call a police officer, if it's reasonable in the circumstances, you must do so. Only when it is absolutely necessary, and this is where the necessary comes in, can you arrest that person. That doesn't apply to Officer Schurr. His job is to arrest people. That is absolutely his job.
But then you're asking this court to recognize something that the Supreme Court said doesn't exist, shouldn't exist. You know, it's two separate crimes, two separate standards. One standard for a private citizen of what murder. One definition actually is what the court said. Private citizen versus a police officer.
Well, if the court believes that private citizens and police officers are in the same shoes when arresting people, then I guess we're going to have to disagree on the law. But I don't think that's what Couch said.
No, but it's all part of what are the circumstances. I mean, at the end of the day, when you have a police officer, the circumstances are different. You know, ultimately what I'm getting at, though, isn't that ultimately the question of fact that the fact finder has to determine.
I think first we have to figure out what the law is.
Okay, let me ask it this way. Regardless of what the law is, though, isn't it ultimately, there's always going to be a question of reasonable necessity, no matter what the law is. Granted that it may apply differently, but it's that fact finder that's doing the application, not the court. Because if the court makes a decision, then it has to say it's an absolute privilege. And I don't think the law says it's an absolute privilege. There's some limitation.
There's a limitation on when they can arrest. For a private citizen, you have to actually, either it has to happen in your presence, or it has to actually be the person that did it to do a citizen's arrest. For Officer Schurr, the question is whether a reasonable officer in that situation would believe he had probable cause to arrest. And you have to have probable cause to believe that's the person that committed the crime. So is that a question of fact? No, I think that's a question of law for the court, as the law routinely makes that determination. Now, if the law is that there's this third element that is discussed nowhere in the Michigan common law, that it has to be necessary, nobody knows what that means. I will tell you this, Your Honor. Nowhere in their training, nowhere in MCOLs, nowhere does it say that the standard is that it has to be necessary. And so necessary to do what? Was it necessary to effectuate the arrest? Was it necessary to protect himself? What does necessary mean? I think that the reason there's no definition for the court to look at is because it's not required. So there are two prongs. Was there probable cause to believe he had committed a felony? And was, in response to the arrest, was the suspect providing force in response? And this is perfectly consistent with common law. If you go back, that case that was cited was 1980, by the way. It seems like it was from the 30s. That's 1980, the Whitty case. They're lamenting that private citizens don't have the same rights as police officers anymore to, in their words, I mean, I was just frankly stunned. The common law in Michigan recognizes that private citizens and police officers don't have the same rights. But it falls short of granting a private citizen a license to hunt down and kill those suspected of committing a felony. I know it's shocking to lose. And the legislature has had decades to lay down some protection for citizens and for officers. But we're still with the common law. And I don't think the common law says a jury is going to review whether or not it's necessary any time an officer used deadly force. Otherwise, you could just charge a crime every time an officer pulls his gun. If it's ultimately just a question of fact for a jury, what's to stop the prosecution from charging anyone any time they hurt somebody when they're resisting arrest? It's an assault with intent to do great bodily harm. Necessity is not an element of the two-pronged fleeing felon rule in the state of Michigan. And that's our position, Your Honor. I mean, it's a difficult one. There's not a lot of guidance for this court. And I'm not saying that should be the law. We're saying, I'm getting lots of notes. And so ultimately, it is the prosecution's burden to show probable cause, and whatever the standard is. And I think the court has to set the standard first before deciding whether or not probable cause has been met. Because there are circumstances where you make findings of fact, and here they're completely undisputed. That you heard no evidence that it wasn't unreasonable, even under the most restrictive standard. For that reason, we ask that the court deny the bind over order and discharge the defendant.
Thank you, Mr.
I guess the biggest thing, now that we're representing a fielder, the fielder case, and in terms of saying their idea that basically that if somebody uses force to resist arrest, all bets are off. The fielder case was remanded because the fielder decision was it's up for the trier of fact. I mean, so the own case that they cite says this is a trier of fact issue. So we can talk common law and everything else. All the cases say this is essentially something that is to be sent by a jury, and it's not for a judge at this stage to decide. And I don't know how you get around Couch. I mean, Couch is the one they cited, and they left out that section. But Couch, in that section that I read about officers and civilians, was citing a case from 1930. So to say that this is somehow new and we have no idea, they're basing case law since the 1930, and common law is based on case law. So I don't know how you can get around saying, well, there's no necessity in the common law when we have a case that's been out there since 1930 saying exactly that. This is a jury question. All these arguments, they make well-intentioned arguments, but it's for a jury. It's not for this court. There's a sufficient basis to bind this over, and we ask the court to do so.
All right. Thank you both for, thank you all for your courtesy to one another throughout the proceedings. And your professionalism. I am going to take the matter under advisement. I'm going to review all the evidence. I'm going to review the applicable law. And I am going to give you a decision on bind over on Monday. And I intend to draft a written opinion, and then we'll present it in court. It's at 10 a.m. on Monday morning. All right. Anything else we need to address in this?
I don't believe so, Your Honor.
All right. Again, thank you, everyone, for your courtesy. And we'll see everybody Monday.
And guess what? We have his decision. All right, we're getting towards the end of our pretrial prep. This is the judge's decision, but then we have another one after this, which is an hour and 13 minutes. So we're getting there. For those that are hanging on, I appreciate it. I appreciate you hanging with me on a Friday night.
Defendant is charged with...
Yikes. All right. Appreciate you guys hanging with me on a Friday night. Because what else would we be doing, right? All right. This is the Monday morning, right? As the judge said. So this is the decision on the preliminary hearings. So, yes, I will be here. I will be here all night. Did the 16-year-old prosecutor get any lines? No, he did not. That's a bummer. Psychosaurus Rex. Yes, I love this all-night stream. All right, let's get to it. This is the judge's decision.
Defendant is charged with second-degree murder, MCL 750.317. A preliminary examination was conducted on October 27th and 28th, 2022. Following the presentation of proofs by both parties, the people moved the court to bind defendant over on the single charge of second-degree murder. The relevant underlying factual background is not in dispute. On April 4, 2022, defendant Christopher Schurr was a police officer with the Grand Rapids Police Department on duty and on assignment, patrolling the city's southeast side. Just after 8 a.m., defendant initiated the traffic stop of a Nissan Altima after observing that the license plate on the vehicle was issued to another car. Before defendant fully exited the police cruiser, the driver of the Nissan, who was later identified as Patrick Lyoya, stepped out of the Nissan. Defendant shouted at him several times to get back in the vehicle, and Lyoya did not comply. Defendant asked him if he spoke English, to which Lyoya responded yes. Defendant asked Lyoya if he had a driver's license. Lyoya indicated that he did and told the passenger in the Nissan to hand him the license. Lyoya did not wait for the passenger to hand him the license. Instead, Lyoya abruptly closed the door of the vehicle and walked towards the front of the car in what appeared to be an attempt to get away from the officer. Defendant responded by telling Lyoya to stop and reached out to restrain and handcuff him. Defendant was unable to immediately restrain Lyoya, and after a struggle, Lyoya was able to break free from defendant and ran around the back of the Nissan into the adjacent residential front yard. Defendant pursued Lyoya, yelling at him to stop, and is heard radioing out, quote, "We've got one running," close quote. Defendant reached Lyoya on the side yard of the neighboring house. Defendant was able to grab him from behind. While this prevented him from running, defendant struggled to fully restrain and take control of Lyoya. Defendant continued to yell commands at Lyoya to, quote, "stop," and to put his hands behind his back. While Lyoya said, "okay," he continued to struggle and was not complying with the officer's commands. Defendant is seen striking Lyoya's abdomen with a knee multiple times with no apparent effect on Lyoya. Lyoya appears completely impervious to and unaffected by the officer's attempts to subdue and restrain him. By this time, the homeowner in the adjacent house, Wayne Butler, came outside to observe what was occurring. Butler testified that he didn't want to see anyone get hurt, and so he felt compelled to plead with Lyoya to follow the officer's orders, saying, quote, "Come on, bro. I came down for your own safety, man. Come on, comply with him," close quote. Butler testified that he was also encouraging Lyoya's passenger to tell Lyoya to comply and get on the ground. Defendant then pulled his taser from his utility belt. Lyoya grabbed the front of the taser with his left hand. Defendant immediately commanded Lyoya to, quote, "let go of the taser," close quote. Lyoya did not comply. The taser discharged one of its two cartridges, which lodged in the ground without striking anyone. The two continued to struggle over the taser. Defendant and Lyoya struggled to the ground with Lyoya underneath defendant attempting to take exclusive control of the taser. During the struggle, the taser's second cartridge was discharged. Lyoya attempted to get up, raising his legs and arms in an apparent attempt to throw defendant off of his back. At one point, defendant's arms and legs are seen fully suspended in the air as Lyoya pushed up from beneath him. Ultimately, Lyoya gained exclusive control of the handle of the taser and was able to transfer it to his other hand. All the while this went on, defendant continued to shout the commands, quote, drop the taser, close quote, and, quote, let go of the taser. Being unable to retain any control of the taser and with Lyoya continuing to attempt to force himself up, defendant used his right hand to draw his service firearm and aimed it at Lyoya's head. Defendant then straightened his left arm while keeping the gun in his right hand, pointed it at Lyoya's head. Defendant yelled one final time, quote, drop the taser, close quote. Seconds later, defendant fired his weapon, shooting Patrick Lyoya in the head. The Kent County Medical Examiner, Dr. Stephen Cole, testified as to his opinion that Patrick Lyoya's death was homicide caused by a gunshot wound to the back of the head. This court also heard the testimony of Brian Childs, a representative of the manufacturer of the taser. He explained that the taser involved here contained 2 cartridges capable of projecting electrical probes up to about 20 feet. If the probes on the cartridges made contact with a person, they will deliver electrical energy that will cause the person temporary neuromuscular incapacitation, or, quote, NMI. A person struck with the probes is rendered completely unable to move for around 5 seconds. He explained that once both cartridges have been deployed, the base or handle of the taser is still capable of delivering a drive stun. The drive stun delivers localized pain to the part of the body touching the front of the taser. However, a drive stun does not result in NMI. Once ejected, the probes can be retrieved and reactivated. However, unless the probe has made sufficient contact with a person, or unless the conductive material on the wire has been exposed as a result of damage to the wire, the taser is only capable of delivering the more benign drive stun that will not result in NMI. The court also heard from Captain Chad McCursey of the Grand Rapids Police Department. Captain McCursey trains police officers and is certified as a master taser instructor. He opined that defendant followed policy and procedure in this case, and that use of deadly force was justified under the totality of the circumstances. He explained the criteria that is considered when evaluating questions concerning the use of force. He also cautioned about the importance of evaluating questions from the circumstances as they appeared to the officer and not with the benefit of hindsight. He also testified that a number of alternative techniques and responses were available to defendant, but that the policy recognizes the discretion the police officer has to make those decisions in the heat of the moment. Captain McCursey offered an example of other tools and techniques that were available to defendant at the time of the incident, including pepper spray or the use of the flashlight, baton, or radio to strike the suspect. He explained that even in using the firearm, an officer is taught that they may aim at different parts of the body depending on the level of force that is necessary. He also indicated that it is impossible to know whether Lyoya simply intended to break the grasp of the officer or to actually affirmatively attack him. Ultimately, Captain McCursey is of the opinion that the defendant followed his training and policy based on what the totality of the circumstances required. After hearing counsel's arguments, the court took this matter under advisement to review the testimony and law in greater detail. Moving on to the analysis of the opinion. It is of primary importance to understand the limited scope of this court's authority and task as it presides over a preliminary examination. In Michigan, the preliminary examination serves the public policy of ceasing judicial proceedings where there is a lack of evidence that a crime was committed or that the defendant committed it. Recognizing the risk associated with standing trial for a felony, the preliminary examination, like the grand jury process, serves as a check on the power of the executive branch of government to proceed with a criminal prosecution. The grand jury has been described historically has been described as the protective bulwark standing solidly between the ordinary citizen and an overzealous prosecutor. And that is from the U.S. Supreme Court case of the United States versus Dioncio, 410 U.S. 1, 1973. However, the scope of judicial review of a criminal prosecution at the preliminary examination is very limited. The judicial officer at the preliminary examination is tasked with making the legal determination of whether there exists the minimal amount of evidence the law requires to justify continuing the criminal prosecution. While the court makes that legal determination independent of the prosecutor's decision to bring criminal charges, the court is prohibited from second-guessing the prosecutor's charging decision. Rather, if the magistrate determines that probable cause exists to support the charge under the law, he is obligated to bind the defendant over for trial. A failure by the court to bind the defendant over in that instance would amount to nothing less than the court's unconstitutional usurpation of power otherwise belonging exclusively to the executive branch of government, and more specifically to the county prosecutor. Stated more plainly, while the court operates as a check on the prosecutor's power to bring criminal charges, it is a very limited check. A court does not have the authority to veto the prosecutor's charging decision in the same way that the governor or president can veto a bill passed by the legislature proposing a law or policy that the governor or president does not like, does not think will work, or does not think is fair. A court can only determine whether the charge is founded upon probable cause. If it is legally sound, the court cannot stand in the way of the criminal prosecution, regardless of what the court might think about the prosecutor's decision to bring charges, or even the likelihood of conviction by a jury. In other words, the limited question for this court is whether the criminal prosecution can continue as a matter of law without any regard for whether the prosecution should proceed based on anything other than the law. At a preliminary examination, a court is tasked with determining whether a felony was committed and whether there is probable cause to believe the defendant committed it. Probable cause exists where the evidence is sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused's guilt. The evidentiary standard is far less rigorous than that required for a conviction following a trial. And I'll read here from the case of People versus Yost, which is a Michigan Supreme Court case from 2003. At the examination, evidence from which at least an inference may be drawn establishing the elements of the crime charged must be presented. The probable cause standard of proof is, of course, less rigorous than the guilt beyond a reasonable doubt standard of proof. Probable cause requires a quantum of evidence sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused's guilt. Yet, to find probable cause, a magistrate need not be without doubts regarding guilt. The reason is that the gap between probable cause and guilt beyond a reasonable doubt is broad, and finding guilt beyond a reasonable doubt is the province of the jury. In order to establish that a crime has been committed, the prosecution need not prove each element beyond a reasonable doubt, but must present some evidence of each element. And probable cause may be established purely by circumstantial evidence and reasonable inferences arising from the evidence. During the preliminary examination, the magistrate is not only the right, but also the duty to pass judgment not only on the weight and competency of the evidence, but also on the credibility of the witnesses. However, the court is not to apply the same measure as a jury because of the differences in the standard for bind-over and for ultimate guilt. Again, reading from the Supreme Court's opinion in People versus Yost, the Supreme Court explained, the gap between probable cause and guilt beyond a reasonable doubt is broad, And therefore, unlike a jury, a magistrate may legitimately find probable cause while personally entertaining some reservations regarding guilt. Accordingly, in considering credibility of witnesses, a magistrate may only decline to bind over a defendant if a witness's lack of credibility, when considered together with the other evidence presented during the examination, would preclude a person of ordinary prudence and caution from conscientiously entertaining a reasonable belief of the accused's guilt. Indeed, the magistrate or judge may very well be left with reasonable doubt the defendant committed the crime charged, and yet at the same time find probable cause to bind over a defendant on that charge. Moving on to the elements of the charged offense here. The elements of second-degree murder are, number one, a death. Number two, caused by an act of the defendant. Number three, with malice. Number four, without justification or excuse. As a necessary element of second-degree murder, malice reflects the principle that criminal culpability must be tied to the actor's state of mind. Malice is defined as the intent to kill, the intent to cause great bodily harm, or the intent to do an act in wanton and willful disregard of the likelihood that the natural tendency of such behavior is to cause death or great bodily harm. Second-degree murder is a general intent crime and does not require a finding of specific intent or harm to kill. The intent to do an act in obvious disregard of life-endangering consequences is a malicious intent. There is no real question here concerning the first three elements of the charged crime. There is little doubt that Lyola's death was caused by the gunshot wound to the head inflicted by defendant. The clear depiction of the incident in the video strongly infers that defendant knew he was pointing the gun and firing it at close range to Lyola's head, which in turn is sufficient to establish probable cause to conclude that defendant acted with malice. The only real debatable question here is whether defendant's actions were justified under the law. A person is not guilty of a crime even though the person committed the illegal act if a legally recognized justification is factually supportable. At trial, the prosecution has the burden of disproving justification beyond a reasonable doubt once evidence is introduced. For purposes of bind over, the court must determine whether there is evidence that is sufficient to cause a person of ordinary prudence and caution to consciously entertain a reasonable belief that the homicide of Patrick Lyoya was not justified under the law. Defendant presents three theories that he argues establishes clear justification as a matter of law such that no probable cause exists for bind over. Number one, that he used force reasonably necessary in defense of himself or others. Number two, that he used appropriate force in response to force used by Lyoya to avoid arrest. And three, that he used reasonable force to prevent a felon from fleeing to avoid capture. We'll begin with the theory of justification by self-defense. While modified by statute in certain respects in recent years, Michigan law governing self-defense remains primarily a creature of common law. At common law, a claim of self-defense, which is founded upon necessity, real or apparent, may be raised by a non-aggressor as a legal justification for an otherwise intentional homicide. The ultimate question requires a factual determination of whether the accused, under all circumstances of the assault, as it appeared to him, honestly believed that he was in danger of losing his life or of great bodily harm, and that it was necessary to do what he did in order to save himself from such apparent threatened danger. Thus, the homicide of Patrick Lyoya would be justified under the law of self-defense only if the defendant honestly and reasonably believed his life was in imminent danger or that there was a threat of serious bodily harm and that it was necessary to exercise deadly force to prevent such harm to himself. Our Supreme Court made it clear that, quote, the touchstone of any claim of self-defense as a justification for homicide is necessity. And indeed, the court confirmed that generally questions concerning the existence or lack of reasonableness or necessity in resorting to deadly force in self-defense are for the jury to decide after considering all of the circumstances. Some conclusions concerning the use of deadly force for self-defense can be made as a matter of law. For example, the general rule under the common law was that a person first attempt to retreat and avoid the danger before being justified in using deadly force in self-defense. However, by operation of law, both common law and more recently by statute, the duty to retreat is completely excused under certain circumstances. For purposes of this case, there is no dispute that defendant was legally pursuing Patrick Lyoya and was therefore legally on the front lawn of a private residence at the point of the shooting. Therefore, under Michigan law, MCL 780.972, defendant did not have any obligation to retreat rather than use force. Nonetheless, factual questions remain as to whether defendant reasonably believed that his life was in imminent danger or that he was in an imminent danger of suffering great bodily harm, and that deadly force was reasonably necessary. These are questions of fact that the jury must decide based on the totality of the circumstances as presented by the evidence at a trial. And indeed, our jury instructions recognize that the ultimate determination of reasonableness and necessity are questions for the jury to decide based on all of the circumstances. Among the standard jury instructions that would likely be read at trial, the jury would be instructed. And I'm going to read from the jury instructions here. The defendant must have been afraid of death or serious physical injury. When you decide if the defendant was afraid of one or more of these, you should consider all of the circumstances. And then in parenthetical, the condition of the people involved, including the relative strength, whether the other person was armed with a dangerous weapon or had other means of injuring the defendant, the nature of the other person's attack or threat, whether the defendant knew about any previous violent acts or threats made by the other person. And at the time, the defendant must have honestly and reasonably believed that what he did was immediately necessary. Under the law, a person may only use as much force as he thinks is necessary at the time to protect himself. And when you decide whether the amount of force used seemed to be necessary, you may consider whether the defendant knew about any other ways of protecting himself. But you may also consider how the excitement of the moment affected the choice the defendant made. And that's the end of the quote from the Michigan Standard Criminal Jury Instructions. While defendant has made strong arguments that the circumstances establish reasonableness and necessity, this court cannot make that determination here at the preliminary examination as a matter of law. The evidentiary record from the preliminary examination contains enough to allow a person of average intelligence to conclude that defendant's fear was not reasonable or that the defendant's shooting of Lyoya in the back of the head was not reasonably necessary. Captain McCursey testified that it's not clear to him whether Patrick Lyoya was merely trying to get away or was prepared to offensively attack defendant. Captain McCursey also recounted a number of examples of alternative techniques that may have been available to defendant. Based on the testimony, the threat or danger that the taser presented may not be the same, depending on whether it was only capable of delivering a drive stun at the time that the shot was fired without resulting in NMI. And it is not clear whether defendant knew or should have known that both the taser's cartridges had been discharged. These are all circumstances that might affect how a fact finder would assess the necessity question. While the captain is of the opinion that the techniques and actions defendant applied were appropriate, a juror would be free to conclude that under the circumstances, the use of deadly force in the manner it was used by defendant was not reasonably necessary. Importantly, The court does not raise these examples to suggest that defendant's actions exceeded what was reasonably necessary. To be clear, this court expresses no opinion on that matter or the ultimate guilt or innocence of defendant. As explained previously, that is not the question before this court. The law recognizes that law enforcement officers are required to make split-second decisions of life and death in dangerous and strenuous circumstances. The reasonableness of those actions can hardly be fully and fairly judged by one person in a black robe with 20/20 vision of hindsight and from the comfortable and safe vantage point of the high perch of the armored plated judge's bench. It is precisely, though, for this reason that questions of reasonableness and all questions of fact are determined by a jury after a full and fair trial. Accordingly, for purposes of the probable cause standard, there is sufficient evidence from which a jury could conclude that defendant did not reasonably believe that his life was immediately at risk or could otherwise conclude that the use of the particular force used was not reasonably necessary. Moving on then to the second theory of justification, force in response to force used by a person being arrested. Defendant's remaining two theories of justification concern the use of force in making an arrest of a suspected criminal. Defendant points out that the defense in that context can be divided into two categories: the use of deadly force when a person making the arrest is met with force from the person arrested, and secondly, the use of deadly force when necessary to prevent the person who is to be arrested from fleeing. The first category, however, is not a distinct theory of justification from that of self-defense. Rather, it is sometimes highlighted as its own theory because it always excuses any obligation to retreat. Therefore, for the purposes of this case, the theory is completely duplicative and indistinct from the justification of self-defense. As the court already indicated, under Michigan statutory law, the defendant did not have a duty to retreat before resorting to deadly force. And for the same reasons discussed, for purposes of the probable cause standard, there is some evidence from which a jury could conclude the defendant's belief was not reasonable or that his response was not reasonably necessary. The most complex of the three defenses raised is the so-called fleeing felon rule, which under certain circumstances justifies the use of deadly force to prevent a felon from escaping arrest. The complexity is not in its application. To the contrary, if applicable in its purest form, the rule is as draconian and unforgiving as it sounds. Blackstone, the famous English commentator on the common law, observes, quote, "Any private person and any peace officer may arrest a fleeing felon, and if they kill him, provided he cannot otherwise be taken, it is justifiable," close quote. And in 1985, the United States Supreme Court observed that Michigan was only one of 4 states that still followed the rule. And according to one commentator, today Michigan is the only state that continues to follow the rule in its purest common law form. Instead, defendants suggest that there's a lack of complete clarity as to some aspects of the rule under Michigan law. While the rule has been subject to calls for legislative reform for the past 30 years, that has not occurred. Importantly, this court's task and the extent of any court's authority is the determination of what the law actually is, not what anyone else, well, not what it or anyone else thinks the law ought to be. As a matter of public policy, reasonable minds can disagree about the extent to which police officers should be free to make judgment calls without the potential for incurring criminal culpability. This court must simply find what the law is now with any consideration of how it might be changed in one way or another. The 1990 Michigan Supreme Court case of People v. Couch controls the question of what the law is in Michigan today. And while there may be nuances that remain, the primary components are readily discernible and are, at least for purposes of making the probable cause determination required here, more than clear. Under Couch, the common law fleeing felon defense, as it existed in 1846 at the time that the crimes of murder and manslaughter were codified in the state's first penal code, continues to be the governing law of this state. Under that common law fleeing felon rule, the use of deadly force is justified if, number one, evidence shows that a felony actually occurred. Number two, the fleeing suspect against whom force was used was the person who committed the felony. And three, the use of deadly force was necessary to ensure the apprehension of the felon. For purposes of the questions before us today, it is clear that even under this broad and rather forgiving rule of justification, the question of necessity remains tightly wound around its core, requiring an answer to the question of whether the actions of the police officer were reasonably necessary under the circumstances to ensure the apprehension of the felon. And no different than the necessity component at the core of self-defense, necessity to ensure the apprehension of the felon is a question of fact for the jury to decide. In applying the probable cause standard, there is at least some evidence from which a person of average intelligence could conclude that defendant's shooting of Lyoya in the back of the head was not reasonably necessary to prevent his escape. As the prosecutor suggests, at the instant that the shot was fired, Lyoya is not in a position of actively escaping or fleeing. A reasonable juror could find a lack of necessity for deadly force strictly for the purpose of preventing escape. Therefore, for the foregoing reasons, the court concludes that as a matter of law, probable cause has been presented to support the charge in the criminal complaint. Accordingly, it is the court's legal obligation to bind defendant over to the 17th Circuit Court to stand trial on that charge.
All right, so probable cause was found. And will stand trial. All right, let's see, we've got, so that was that one. All right, here's this next one is motion to quash. Here, okay, this is the trial. Now that's the last that we're going to see that judge, Nicholas. The next one we're going to watch, this is the trial judge. This is the one that's actually going to do the trial.
His part.
Oh, wait a minute. Okay. Okay. All right. So this one is a little bit over an hour and 13 minutes. So this is the trial judge. So now we're going to actually see her in action. When was this? This was 2 years ago. February 13th. Okay, this was February 13th. All right, let's check this one out.
You're watching breaking news coverage from 13 on your side. Right now, we're bringing you the latest developments in the murder case against former Grand Rapids police officer Christopher Schurr, who is accused of killing Patrick Lyoya last April. Attorneys representing the former officer are asking the judge to dismiss the case, while the prosecutor is urging the judge to allow the case to go to trial. The hearing to decide what happens next is moments away, where the judge will either issue a ruling today or will announce her decision at a later date. Stay with 13 on Your Side as we continue to cover this story on air, on 13onyourside.com, and on our news app and on 13 Plus.
Are you arguing this motion, Mr. Bourgeois?
Yes, good morning, Your Honor. Matt Padula on behalf of Officer Schurr. With me today is Kelly Hamilton and Mark Dodge. Now we are.
Okay. And we're here on the defense motion to quash, bind over, and to dismiss the charge against the defendant. I did receive the motion in brief, which I'll state for the record that it did, because this is part of what the people's response included, but the motion did exceed the page limit without prior approval. However, I did still consider the motion in its entirety, but I did not consider the reply brief that was filed by defense, so I would like to give you an opportunity to reply orally to the people's response.
Thank you, Your Honor. I appreciate the opportunity, and I apologize we filed too long of a brief. It's a really an unusual case in the sense that there is no statute here that's governing when it's justified, in this case for Officer Schurr to use deadly force, which led to the length of the brief. I mean, we went into the sort of the history of the common law, because the common law applies. And I think the district court, recognized, as the prosecution did in its response, that the common law is controlling here. And I think the legislature has left all of us in a bit of a quandary here because they haven't acted. There's no statute governing when a police officer or even a private citizen can use deadly force or be charged with a crime. At least there wasn't for a long time with regard to private citizens. So you have to look at the common law. And in the response, the government, the prosecution, has a different interpretation of what the common law says. And the district court, Your Honor, as the court is aware, looked at the law from 1846 and went back to 1846 and asked, what are that law that it applies today or should apply today? And I think the district court did. If you commit a felony and you try to escape, in 1846, as it is today, the arresting person can use deadly force. It's the common law fleeing felon rule. And there's classic examples of this in history. And we didn't point these out in our original brief. But in response to what the government is saying, what the prosecution is saying, I'd like to go into that a little bit because I don't think it's clear that, at least to the prosecution, that common law from 1846 still applies today. There are two elements that relate to justification under the fleeing felon rule. It's a felon, someone who's committed a felony, and someone who's fleeing. And the prosecution has added a third element, if you will, that the nature and type of deadly force used is limited in some way. Either it's reasonable or is limited in weight or how it's used. So the classic example of this from 1846, Your Honor, is there used to be wanted dead or alive posters in this country. And I'm only talking about this because that's the law we're looking at. In 1846, people were wanted dead or alive. And that did not mean that you could just go out and kill them. So there is some limitation on this law of justification. What that meant was that if they're fleeing and they're a felon, you can use deadly force. The classic example is Jesse James, notorious bank robber.
And I'm going to stop you only because I believe that much of what you're arguing was contained within your motion and brief. And also because frankly, I agree that the common law rule or fleeing felon rule is still in effect to some degree. So I to agree with you with regard to that argument, and so, but I don't need to hear about Jesse James.
Well, I don't want to try to.
Understand that argument.
I don't want to try the patience of the court.
And how it's evolved over time. So.
Perhaps the court has any questions about the prosecution's argument that it has evolved to a way to be in line with the U.S. Supreme Court decision in Tennessee v. Garner, where there's these application of sort of a civil standard on the fleeing felon rule. I don't know if that's where the court's inclined to go on this, but here what the district court did and where the district court erred is the district court said that they considered only the moment in which the shot was fired, the instant the shot was fired, to determine whether or not they were actively fleeing. And I think that was error. I think that the court should have looked at the entirety, the totality of the circumstances, everything leading up to that. And the prosecution maintains, and the district court accepted, that this court and ultimately a trier of fact need only determine whether or not, in that photograph of time, deadly force should have been used, and whether it was reasonable to use it just at that moment. And I think that was there. Your Honor, I also want to address, with regard to the sort of the third method of justification, because in our briefs we indicated there's the common law fleeing felon rule, and also the use of force in response to force. But there's always the justification of self-defense. And here the prosecution maintains that it's a subjective standard, and the court agreed with that as well. The court's reasoning was a reasonable juror could find it justified only if the defendant honestly and reasonably believed his life was in imminent danger, whether that there was a threat of serious bodily harm, and it was necessary to exercise deadly force to prevent such harm to himself. And that's the self-defense standard, but that's not the standard that should be used with a police officer who's acting in the line of duty for a lawful arrest. So essentially what the district court did and what the prosecution wants this court to do is hold them to a lower burden than the plaintiff's attorneys are going to have in a civil case. Because in the civil case, the plaintiff's attorney must establish by a preponderance that no reasonable officer, given the circumstances, could believe that he was in fear of great bodily harm or death. It's not a subjective standard or test. In other words, we're not going to look at what Officer Schurr had in his head and think, am I in fear of harm or great bodily death, or great bodily harm or death? It'll be an objective, reasonable officer standard. But that's not what the district court did, and that's not how they viewed the evidence. And that was error. And so it's unclear, because from what we can tell, no officer has been charged with murder for making a lawful arrest, whether or not what the standard is going to be.
You said there's no officer.
I'm unaware of any officer being charged with murder in the second degree for making a lawful arrest.
They can't make a lawful arrest if the person's deceased.
He certainly was making a lawful arrest. He had committed several felonies up to that point, and everybody, at least at the preliminary exam, agreed that he had committed felonies.
I believe running from the police officer is a felony.
Yes, and resisting and obstructing as well.
That's the same felony that I was referring to. If you run, resist, obstruct, then that's a felony. So.
Disarming the police officer is a felony. So here, I don't think that the prosecution argument that we should treat Officer Schurr the same as a private citizen who happened to get in a fight on his front lawn. The court should look at it as whether they show by probable cause that no reasonable officer, given the circumstances of the case, could believe that he was in fear of great bodily harm. Not whether Officer Schurr individually held that belief. And the evidence at the prelim was overwhelmingly in favor of the fact that a reasonable officer could find that. And the prosecution didn't put on any evidence. They played a video and said that because he was shot in the back of the head, no reasonable officer could have found that deadly force was necessary in the instant the shot was fired. You had the captain of the police department testified that Officer Schurr followed his training. He was justified in making the arrest. He had committed, Lyoya had committed several felonies. Officer Schurr had followed the continuum of force as he was trained to do to make an arrest. And that the only finding of misconduct that followed the shooting was that the prosecutor charged him with murder. So nobody has said that he has violated any training or policies after reviewing the video. And so under the prosecution's point of view, adopted by the district court, it would be easier to convict him of murder than it would be to sue him and win successfully. That can't be the law. Unless the court has any other questions, I'll rest and unbrief.
Thank you. And Mr. Baxter, did you have anything that you'd like to say in response to Mr. Or those reply to your response?
I'll keep it brief, Your Honor, because I know the court has read both briefs and has paid attention to this case. I think the biggest thing, the issue that we're speaking the same language, but it's clearly we have complete different interpretations. They actually are arguing that there's two different states of law. You have a law for a civilian and a law in Michigan that applies to a police officer, and that's just simply not the case. I mean, you read the cases, and we've cited them in our brief, People versus Doss regarding the fleeing felon. Doss is a Michigan Supreme Court case from 1990, citing a case from 1930, saying fleeing felon, police officers and civilians have to use reasonable force and only use it when necessary. The same holds true, that was Couch. Doss is on the same provision on self-defense. I mean, we don't have two different levels of law. Civilians and police officers are covered by the same law in the state of Michigan. This isn't 1846. This is 2023. The common law has evolved. The common law has evolved through the decisions of the Supreme Court, and we've cited overwhelming number of decisions in the Michigan courts that say police officers are held to the same standard. Force must be reasonable under the circumstances. It must be immediately necessary. And that essentially is a jury question, and that's what the district court said. This is a question for the jury. We've established all the elements of secondary murder. The fourth one, was it necessary? Was it justified or excused because of the deadly force? That's the one this whole case resolves on, and that is a question for a jury. And there's overwhelming evidence that was presented at the district court level that the judge relied on, I think correctly, to bind this over for trial, so there's no basis for this court to quash. Thank you.
Well, in addressing this motion to quash, bind over, and dismiss the charge against the defendant, there was not only challenges with respect to the various defenses that are available to the defendant, but there was also a claim that the statute is void for vagueness. So I'm going to address that argument, even though it was offered last. I'm going to address it first because it's potentially dispositive. According to the defendant's motion in brief, the argument is that the criminal statute with respect to second-degree murder is void for vagueness because it fails to give a person of ordinary intelligence reasonable notice that his or her behavior may be unlawful. However, the true challenge that the defense has is not to the statute, but rather to the element of without justification or excuse. And that particular element is not in the statute, and that would be MCL 750.317. Rather, this element is listed as an optional fourth element in the model criminal jury instruction for second-degree murder. Specifically, it states, third, the third element in the instruction that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. And after that particular element, there's a use note that states that that particular element may be omitted if there's no evidence of justification or excuse, and that there are justification or excuse instructions that could be inserted, but they're more commonly given at a later time. These are jury instructions. In People versus Caviani, which is a Court of Appeals case, the Court of Appeals stated that a statute is not vague when the meaning of the words in controversy can be fairly ascertained by reference to judicial determinations or even the words themselves if they possess a common and generally accepted meaning. Furthermore, a statute is presumed constitutional unless its unconstitutionality is clearly apparent. Here, again, the constitutional challenge is to an element of second-degree murder and not the statute, so it fails in that regard. And even if that element was in the statute, the meaning of the words justified, excused, or done under circumstances to reduce it to a lesser crime can be easily, those words can be easily ascertained and do have common and generally accepted meanings. Therefore, the element is not vague at all. According to MCR 6.110, if on proper motion, now I'm going to move on to the other issues. If on proper motion the trial court finds a violation of this rule, which would include conduct of the examination, exclusionary rule violations, probable cause finding, or discharge of defendant, if on proper motion, if I found violation of those particular paragraphs, I must either dismiss the information or remand the case to district court for further proceedings. In that regard, for purposes of bind-over, the district court has to determine whether there is evidence sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief that this offense was, or this killing was not justified under the law. Again, the elements of second-degree murder are that there is a death caused by an act of the defendant with malice and without justification or excuse. These elements essentially, especially the last element, is a judicial construct cited in People versus Bailey, which is a Michigan Supreme Court case. And the district court stated in his written opinion that there is no real question concerning the first three elements. And he pointed to the evidence presented at the preliminary examination, specifically video and testimony from the county medical examiner. And the parties agree with respect to those first three elements. The district court also said that the defense raised the theories of self-defense, appropriate force in response to force used by the decedent to avoid arrest, and the fleeing felon rule as bars to a finding of probable cause with respect to this fourth element. In this motion, the defense claims that the district court erred as a matter of law regarding the common law fleeing felon rule because the district court added an element of reasonably necessary and considered only the moment of the shooting in finding probable cause that the defendant's actions were not reasonably necessary. Second, the second claim is that in holding the common law is not a distinct theory of justification from self-defense, the district court judge made a mistake. And finally, in applying the civilian self-defense rule to an officer and probable cause that the defendant did not act in self-defense with no evidence of non-justification. That's the third argument put forth by the defendant in this motion. The defendant further alleges that in doing so, the district court abused his discretion. The district court judge abused his discretion. Once a criminal case has been bound over and jurisdiction has been vested in the circuit court, there are only limited circumstances in which the circuit court may properly remand the case for a new or continued preliminary examination. And it follows logically to dismiss the case in its entirety. That's under People v. Taylor, which is a Michigan Court of Appeals case. That case goes on to say that if a motion to quash is filed and the circuit court determines that the evidence is insufficient to support the bind-over, then the circuit court is permitted to remand the case for further examination, at which the prosecutor may seek to remedy that shortcoming in the proofs that they needed to establish probable cause. The law is clear that a reviewing court, which is this court, may not reverse a judge's bind-over decision absent an abuse of discretion. That's People v. Yost. And abuse of discretion is found only where an unprejudiced person would say there is no justification or excuse for that ruling, and that's under People v. Orzane. The Michigan Supreme Court in People v. Hunt held that the function of a preliminary examination is to determine whether there is probable cause, and a preliminary examination also helps to satisfy the constitutional requirement that the defendant be informed of the nature of the accusation against him. In this case, it appears from argument and from the motion in brief that the defendant believes the purpose of the preliminary examination to be different for him as a police officer. It appears that the defense believes that since they called a witness, which would be Captain McCursey of the Grand Rapids Police Department, since they called him and he testified about policy and procedure, and he made a factual determination that the defendant was justified in his actions on April 4th, 2022, that testimony and that factual determination by that officer negates the probable cause evidence that was presented by the people. This court disagrees. In fact, in researching the cases provided by both sides, and specifically People versus Fielder, it is likely that an error was made by the district court in this case by admitting and allowing testimony about the policy of the Grand Rapids Police Department and law enforcement standards, because these policies, again, according to People versus Fielder, those policies cannot supersede the common law fleeing felon rule, which is also what the defense is arguing, which I'll discuss that later, that about the fleeing felon rule. As such, these policies were inadmissible evidence at the time that they were presented. The arguments put forth by the defendant all have to do with his possible defenses to the crime with which he is charged. And that's the arguments put forth in this motion. And it was not incumbent upon the district court to decide if those defenses are viable or not. In fact, most of the arguments in defendant's motion and brief support the district court's decision that there are definitely questions of fact that are better left for a jury to determine. In People versus Carlin, the Court of Appeals stated that evidence regarding each element of the crime or evidence from which the elements may be inferred must exist. And when the evidence conflicts or raises a reasonable doubt concerning guilt, there are questions for the trier of fact, and the defendant should be bound over. Furthermore, if the evidence introduced at the preliminary examination conflicts or raises reasonable doubt about the defendant's guilt, the district court has no choice but to allow the fact finder to resolve this at trial. And that's according to People versus Hudson. And in People versus Greer, the Court of Appeals explained further that if there is credible evidence to both support and negate the elements of the crime, it is the jury's job to determine the facts. And in its opinion, the district court judge painstakingly explained not only the basis for his finding of probable cause, but he also addressed the theories raised by the defense at the preliminary examination. Although I do not believe it was necessary for him to perform these analyses on these potential defenses, no more than he would an alibi defense or that there was a challenge to the cause of death, or if there was an issue with identity, he wouldn't go through that extensive of an analysis in determining whether or not there was probable cause. So I believe that he really went above and beyond in his opinion. But because he did that, I will respond to the issues that were raised in the motion with respect to the district court's analysis on these issues. Again, the only element at issue excuse me, is without justification or excuse. There are several claims made in defendant's motion and brief. First, with respect to the fleeing felon rule, the defense argues this was adopted in the 1800s and it clearly does pertain to civilians. And furthermore, the defense in its motion and brief states that the district court incorrectly added a prong that the element that deadly force had to be reasonably necessary, and that the court was wrong by considering only the instant of time of the shooting to say that the defendant's actions were not reasonably necessary. According to defendant's brief, and he also stated it here today, the defendant is and should be held to a lower reasonable belief standard because of his training and legal authority as a police officer, and in the brief they cited People versus Whitty. In that case, the Court of Appeals stated that it appears that the common law imposed a further distinction between police officers and private persons when the matter escalated beyond the issue of making the arrest to the question of when deadly force could be used to make the arrest. They add later that a police officer was justified in acting on the basis of reasonable belief. And they further state that, in a footnote, that an arrest is justified only if the person to be arrested has actually committed a felony, and that's regarding private person arrest, and that's under MCL 760.16. The arrest is justified only if the person to be arrested has actually committed a felony. As such, there is presently no further distinction between officers and private persons regarding the use of deadly force in making a valid arrest. However, whether it's reasonably necessary, as the defense argues the district court stated, or reasonable belief, which is the defense position, either way, these are questions for the jury to decide. It was not incumbent upon the district court judge to decide which of these apply. Either way, whether it was reasonably necessary, or whether the defendant had a reasonable belief, the jury would need to decide that. In People versus Couch, which is a Michigan Supreme Court case, the court there decided that it, meaning the court, need not resolve their authority to modify the common law rule. However, because they found in any event that the presumption of legislative adoption is in this case affirmed by 50 years of legislative acquiescence in the court's decision in People v. Gonsler. And in that case, the court approved the trial court's instruction that both officers and private persons seeking to prevent a felon's escape must exercise reasonable care to prevent the escape of the felon without doing personal violence. And it is only where killing him is necessary to prevent this escape that the killing is justified. And if a killing is not justifiable, it is either murder or manslaughter. And in their view, even if the defendant were a police officer, Garner, Tennessee versus Garner, which was alluded to by the defendant in this oral argument a few moments ago, Gardner could not apply directly, and that would require, if it was applied directly, that would require, in effect, two different definitions of murder. One for police officers and one for the rest of us. And such a scheme could raise a significant constitutional question. This is precisely what the defense is suggesting that the court and the legislature do, which is to create a separate definition of murder for police officers and for the rest of us, which would in fact be potentially unconstitutional. Moreover, that court stated that they failed to see how Garner could be applied directly in any event, since the court in that case concluded, and this is Garner, concluded only that the use of deadly force to apprehend a fleeing felon who posed no harm to the officer or others was unreasonable for purposes of the Fourth Amendment. In other words, Garner was a civil case which made no mention of the officer's criminal responsibility for his unreasonable actions, which is why it wasn't applied directly to the case that I'm referring to. Again, the higher courts are using the words reasonable care, justified, unreasonable, words which a fact finder will have to determine whether they are present in this case or not, and they would have to make that determination at a trial. As recently as 2020, in People v. Lawrence, which is an unpublished Court of Appeals opinion, the court stated that our Supreme Court has recognized that deadly force may be used under some circumstances to apprehend a fleeing felon, and they state that citing Couch, and that's as recently as 2020. Ironically, the most applicable case that the defendant does point to in its extensive brief is People v. Fielder. And in that case, a Benton Harbor police officer shot and killed a man who he suspected of murder. However, the fleeing person that he shot was not the actual murder suspect. The district court in that case found Mr. Fielder over for trial, and the circuit court, which would be my position in that case, the circuit court ruled that, and I'm not saying this is my position or my opinion right now, but in that case, the circuit court, when he had a motion like this in front of him, ruled that no crime was committed because that court found that the defendant's killing of the decedent in that case was justified under the common law fleeing felon rule, which is what the defendant is suggesting that I do. The circuit court, therefore, in that case, granted the defendant's motion to quash, and after that, the prosecution appealed that decision, and the Court of Appeals reversed. And in their opinion, reversing that decision to quash the bind over and dismiss the case, they stated that in determining that the defendant's killing of the decedent was justified under the common law fleeing felon rule, the circuit court found that the defendant reasonably believed the decedent was the murder suspect, and that the defendant was justified in using deadly force. In doing so, the circuit court in that case resolved conflicts in the testimony and substituted its judgment for that of the district court, which again is what the defense is asking me to do here. The court found whether the defendant in that case was justified in believing that not only that the decedent was the murder suspect, but also, and they use word and in using deadly force, were questions for the trier of fact. Interestingly, the Court of Appeals in that case did agree with the circuit court in one respect, and that is that, and they state in Washington v. Stark, which is a Court of Appeals, Michigan Court of Appeals case, that court, the same court that did this People v. Fielder opinion, stated that they held that evidence of the shooting policy of the Benton Harbor Police Department was inadmissible because it could not supersede the Michigan common law fleeing felon rule, which I mentioned earlier. Also, Washington was a civil case. Even though Washington is a civil case, its holding is equally applicable to a criminal case. Therefore, the circuit court correctly held that the evidence of the shooting policy of the Benton Harbor Police Department was improperly admitted at the preliminary examination, which is why I stated that that perhaps was an error that the district court did make. However, it did not rise to the level of quashing the information in that case, nor do I believe it does in this case either. Next, the wrong burden of proof under the Self-Defense Act, where is the next argument where the defendant states that evidence supports a finding that the defendant acted as a reasonable officer, and the prosecution failed to show that he was not in fear of great bodily harm or death. Again, these are questions of fact. They're not questions that the district court or myself can determine whether or not the defendant acted reasonably or whether he was in fear. These are questions of fact for a jury. Furthermore, in People v. Dawes, the Supreme Court held that, like a private citizen, the police officer who claims self-defense must have reasonably believed himself to have been in great danger and that his response was necessary to save himself therefrom. And in People v. Oster, this rule is reiterated as follows. Not only must the defendant believe himself to be in great danger, but that belief must also be reasonable under the circumstances. Again, whether or not it was reasonable under the circumstances is for a fact finder to decide. And finally, the defense argues that the district court was wrong because of his analysis under the Self-Defense Act, and that the common law, stating that the common law was not distinct from self-defense. However, this analysis must be made and can only be made by applying the facts presented at a trial. Having stated all of this, the circuit court should not substitute its judgment for that of the district court, and I'm only allowed to reverse if there's an abuse of discretion. That's under People v. Lopez. A reviewing court may not reverse a judge's find-over decision absent an abuse of discretion. Again, that was People v. Yost. And under People v. Orzain, which is a Court of Appeals case, abuse of discretion is found only where an unprejudiced person would say there's no justification or excuse for that ruling. Here, the question before this court is only, did the district court abuse its discretion? And this court finds that it did not. And the case will proceed to trial. Thank you.
May I ask a question of clarification?
Sure.
And I promise I'm not going to argue about the law. I just had a clarifying question. When you indicated it was error to admit evidence of policy and training and whether or not Officer Schurr followed his training, is that the court's inclination at trial that the evidence of whether or not he was following his training is admissible?
That's not my interpretation. That's the Court of Appeals interpretation.
I guess I'm asking.
Do I have to follow them because they're higher than I am. I have to follow what the Court of Appeals or Michigan Supreme Court has decided, unless there's some law to the contrary, or maybe there's a different aspect of it. But clearly, they held that the circuit court correctly, or the Court of Appeals stated that the circuit court correctly held in that case that evidence of the shooting policy of the police department was improperly admitted. And they state that it's not admissible because it does not supersede the common law fleeing felon rule. And I know that in that case, the policy was probably not the same as what Captain McCursey testified to. And I'm only assuming that because the circuit court sent the case, he quashed the bind over. So in other words, I did not read the transcript in that case, but I believe that he used the fact that it was inadmissible for the police department to testify to send it back. So it appears that because he believed that the officer was reasonable and the crime had not been committed, and he quashed it, that the testimony was that he should not have done the shooting, if that makes sense.
Well, the question was whether or not, because he shot the wrong person, that was the ultimate issue when it got sent back. It wasn't whether or not he used excessive force.
It was both.
Respectfully, I disagree, Your Honor, because they sent it back and they created a new rule for officers, unlike private citizens, where you actually have to shoot the right person.
I think it was just that the jury would need to decide whether or not it was a reasonable belief or not. It was not for the circuit court to substitute its judgment and say, oh, that's reasonable, sounds reasonable to me. So if I said that, hey, I believe in this case that the Officer Schurr acted reasonably, if I believe that and I said, okay, well, I think so I'm going to send it back, guess what, I'll just wind up back the case again, because clearly the Court of Appeals is of the opinion that there has to be, these are questions for the jury to decide. They're not a question for the district court or myself to determine. We can't determine that. And there was probable cause put on via the video that was shown and the testimony from the medical examiner with regard to the injuries and how they must have occurred. So that's probable cause for a lack of justification or excuse. Not that you can't have a defense to it and say, oh yes, there was, but there's probable cause, which, as you know, is a much lower standard than the beyond a reasonable doubt standard. But was there probable cause? There was for that. So, and so with regard to the policy, I read directly, I didn't make it up. I'm reading from what the case law clearly states, which is that the one thing in Fielder that the Court of Appeal did agree with that the Circuit Court decided was that that testimony from the police department regarding their shooting policy was improperly admitted because it can't supersede the common law fleeing felon rule. So that was the reasoning for it, and I don't know whether the policy of the Grand Rapids Police Department attempts to supersede that or not. I'm not making a determination with that. Again, I don't even believe that all of this analysis is required because of the fact that probable cause has been presented, and now the jury would have to determine what the actual facts are and whether or not it's reasonable, whether or not this is admissible would have to be a determination that would have to be made at a later time. I'm not making that decision right now. I was just referring to what the district court had done.
Yes, and we've indicated we will likely seek a leave to appeal. So the reason I'm asking about whether or not evidence could be admissible, because the court has indicated that it's not admissible. My understanding, the court is saying that Officer Schurr had to have a reasonable belief that using deadly force.
You also said that he had to have reasonable belief, because that is the standard. In your argument, you said it's not reasonably necessary, it's a reasonable belief on the part of the officer. I agree that he has to have a reasonable belief, but whether it's reasonable, that's for the jury to decide.
So when you talk about self-defense?
Same thing. That's for a jury to decide.
So how could we possibly prove that his belief wasn't reasonable if we can't get in all the training and all the policies that he didn't violate into evidence?
Again, I'm not making an evidentiary determination at this stage. I'm saying that at the preliminary examination, as in this case, I don't necessarily believe it was admissible in the prelim. But I'm not making an evidentiary decision right now at all, because I do not have the policy in front of me. I don't know whether it comports with the fleeing felon rule or goes against it, or self-defense or goes against it. I cannot possibly make an evidentiary determination with respect to that. I was only referring to what that case said, which again, I'm only talking about because the district court decided to go that route and perform an analysis on all of the potential defense theories, which I don't believe he had an obligation to do.
So, I mean, I understand justification to be an element of the offense. Is that not the court's? You seem to be treating it as if it's a affirmative defense.
As if what is?
A justification is an element of the crime, rather an affirmative defense. So the court's suggesting that the only way the prosecution has to show probable cause is if, in other words, there's no way that the court can rule on whether or not Officer Schurr was justified in this circumstance?
I think that he did say that there's probable cause that he lacked justification or excuse at the prelim, given the video that he summarized and the injuries that were testified to by the medical examiner. I'm simply stating that those were sufficient for a probable cause that he did not have justification.
Okay, but
I'm not saying he doesn't have a defense. I'm saying there's probable cause, not even beyond a reasonable doubt, but probably there's probable cause that there was no justification or excuse.
And the court indicates that this court should not have considered Captain McCreasy's testimony?
I'm stating that according to the case law, that yes, at a preliminary stage, I don't believe it was admissible testimony at that point.
Admissible because it's not relevant, or admissible because it shouldn't be germane to his determination?
Correct. Inadmissible for a prelim in determining probable cause or not. Because he can't, whatever he says cannot supersede what the law is. So whatever the policies are, don't. For example, if the policy was, hey, you could just go shoot whoever you want in the face, that's not the law. The law does not support that.
Sure.
So to the extent that the policy violates what the common law rule is or what the law is, to the extent that that's true, it's definitely inadmissible because it does not assist the trier of fact in determining whether or not a fact and issue is true or not.
Okay. And I'm sorry, I don't mean to try the court's patience, but with regard to the self-defense defense for justification, is it the court's holding that the only defense Officer Schurr has is the same self-defense standard that a private citizen has, and that there's not this Tennessee v. Garner standard?
No, I'm not holding anything with respect to a defense. I'm simply responding to the arguments that were in the motion, the brief, and addressing the analyses in the opinion of the district court. I'm not holding any of that.
Okay.
I'm simply saying he did not abuse his discretion. That's the only thing I'm here to determine. That and whether or not the statute is void for vagueness, which I already found that it's not. And I also find that the district court judge did not abuse his discretion, irrespective of his analysis with respect to any defenses, because he can't say, oh, well, you put on a defense in district court case, there's no case. He can't do that because he has to either find probable cause exists or it doesn't. Any defenses are brought in at trial and based on the evidence at trial. In fact, that particular element is an optional element. If there's evidence put on at trial that, hey, there's justification, well, then you give that instruction. But if the evidence doesn't bear that out, then you don't even give the instruction.
So it is a defense, not an element.
What, self-defense?
My understanding is that the prosecution has to put on probable cause.
Right,
that he didn't act.
And they did so.
And it wasn't justified.
And they did so.
I'm asking for clarification on what actually the probable cause to do, in what regard. I mean, so... Okay,
because you're allowed to decide using direct or circumstantial evidence. The district court, in watching the video, right, and in listening to the medical examiner, found that a reasonable person, juror, unprejudiced person could find that there was no justification given those facts. I cannot substitute my judgment for his. I can't say, oh no, he was wrong. That's not true because that's his. He didn't abuse his standard. I mean, abuse his discretion in finding that provided probable cause.
With regard to the facts, but with regard to the law, I'm just looking for clarification. Did Officer Schurr have to honestly and reasonably believe in his own mind that he was in fear, or is it the standard in Tennessee v. Garner, where the prosecution has to show that no reasonable officer could have found? Because the civil standard is actually tougher than the criminal standard, and that doesn't comport with any other area of law.
And so, Gardner did not make a determination with respect to a criminal case because it was a civil case, right?
Correct.
Okay. And then in Garner, they said use of deadly force to apprehend a felon who posed no harm or to the officer or others was unreasonable for purposes of the Fourth Amendment. But they didn't mention the officer's criminal responsibility in that case because it was a civil case.
Correct.
So I'm really not, all I'm doing is ruling on this motion to quash. I'm not making any evidentiary rulings. There's no evidentiary motions in front of me. Again, the only reason I'm even talking about these defenses is because the district court judge decided to refer to them in his opinion, which I find he was not required to do. It's not required under the law. If he found there was probable cause, then he found there was probable cause. I don't think that he abused his discretion in finding. So I don't believe that the evidence is just so egregiously to the opposite that there's no way he could have found that. It's just not the case.
I understand that, Your Honor. Maybe this is an argument to be made by the defense at a different juncture when talking about jury instructions, for example, because we don't know what the law is.
Exactly, and we don't know what the testimony or the evidence would bear out.
So I mean, the defense actually needs some guidance as to what the parties are going to have to prove at trial. So we'll file a separate pleading or some sort to figure out what that law is. I understand the court's point. I appreciate the court's patience. I know we filed extensive briefing. It is an important issue, obviously, not only to Officer Schurr, but pretty much every police officer, because this law, I think, because it is the first time an officer has been charged with second-degree murder in a circumstance like this, will have significant ramifications down the road. So I thank the court for its well-reasoned opinion and its time.
Thank you. All right, so if there are no other questions, go on to our next motion.
Thank you.
Thank you.
Looks like we get a little press conference here. Let's check
The
this
motion
out.
to quash hearing to the People versus Christopher Schurr has just wrapped up. In just moments, we'll hear from Kent County Prosecutor Christopher Becker, who is prosecuting the case against former Grand Rapids Police Officer Christopher Schurr in the killing of Patrick Lyoya. Stay with 13 on Your Side as we continue to cover this story on the air, on 13onyourside.com, on our news app, and on 13+.
And so, parties have to know what exactly each side has to prove or not prove in this case. And it comes down to, when we're talking about the preliminary exam, whether or not a police officer is justified in using deadly force in the circumstances that were shown at the preliminary exam. When you have a suspect who had committed several felonies, that's undisputed, and that, under the common law, and I didn't get to tell my Jesse James story because the court didn't want to hear it, but okay, so I'm going to tell you now. I mean, it was a trip down memory lane, or history here, because in 1870, when Jesse James, everybody knows who Jesse James is, when he was this notorious bank robber, which most people over 40 know. There's another Jesse James apparently.
Yeah, I don't know that Jesse.
Okay, so yeah, there's a Jesse James that my kids know. It's not the one I'm talking about. I'm talking about the notorious bank robber from the 1870s. He's going across the Midwest and the Great Plains states, and he's robbing all these banks. And so they started putting these posters up, wanted dead or alive, because he's a thorn in the side of law enforcement. And so his partner in crime, Bob Ford, sees this wanted dead or alive reward $10,000, decides that he's going to wait until Jesse takes off his pistol for the night and isn't looking. He shoots him in the back of the head while he's basically turned away from him. And then he takes the body to the authorities and says, I want my $10,000. And they said, well, that's not what we meant, and they charge him with murder. And the reason is, wanted dead or alive doesn't mean you can just kill somebody. And that's never been the defense's point of view. Wanted dead or alive when you're making an arrest means if they're fleeing and they're a felon, then you can use deadly force. And that's what the common law says. Once you establish, in 1870 as it is today, that someone is fleeing and they've committed a felony, which is undisputed here, then you can use deadly force. It doesn't matter how much deadly force you use, or whether you use your gun or the taser or a nightstick. That's not the question. And had Bob Ford, the guy that shot Jesse James, simply said, he was fleeing, he probably wouldn't have been charged with murder.
Yeah, but Matt, you've argued this Wild Wild West 1846 law twice now in front of two different judges. You even said last time that you didn't think it necessarily should be the law, but the state legislature failed to act. Two judges have said it isn't actually the law, and that there is the same standard for citizens as police officers, as Becker said today. So, I mean, where is this argument going? Are we going to see this again?
See, there's the interesting thing. They both said that is the law. In fact, Judge Ayub called it draconian. And frankly, most people today would agree. But what they're saying is that private citizens today, as they could back then, have the protections of the same law. And that's not right. We don't allow vigilantes to run around and chase after a fleeing felon. What do we do if someone commits a felony and they run away? If you're not a police officer, what do? You call 911. So the prosecutor's argument has the perverse effect of essentially saying it's okay for vigilantes to shoot people in the back. And so because they don't want that result, they're saying that police officers are held to the same standard as a random guy, a private citizen who wants to make a citizen's arrest. And that's not the law either.
But the judge said today that there should not be two different standards of murder for citizens and police officers. Isn't that not what she said?
That's what she said, but under the law, because the legislature hasn't done anything on this, what that means, if the common law still applied to private citizens, like an officer, it means you can shoot someone when they're fleeing. And that's not what the court actually said. They considered whether or not they were fleeing, and that's the question of fact.
Is it relevant if he's fleeing while the shot is fired? You know, in the video, he's on top of them, not running at that point. Will that prove to be relevant? Well,
fleeing does not mean running. Fleeing means escaping. And there's two prongs to that, either escaping or using force in response to a lawful arrest. And so, it's tough at a preliminary exam, but I don't know how anybody can look at that video and say he wasn't either trying to escape during the entire time or using force to try to get away. And you can argue whether or not he was trying to hurt Officer Schurr, but that's what we're saying is not the question. The question is whether it can't be the only time an officer can use his firearm is when he's about to be hurt. Maybe that could be the law, but that's not the common law. It's certainly not the common law in 1846.
I guess the point is you've argued the law twice now. As a point of law, is this going to? Are you going to appeal it somewhere? I mean, that's not going to be what the trial is about, is it?
I have no idea what the jury instructions are going to say. In fact, at the end of my argument, I asked the judge, can you tell us what the law is? Because there are three defenses here, basically. And it's an element of the offense whether it wasn't justified. So the government's going to have to prove at trial, if we go to a trial, beyond a reasonable doubt, that the fleeing a felon rule doesn't apply, the use of force in response to force doesn't apply, and whether or not Officer Schurr acted reasonably in self-defense. He's always got a right to self-defense. And the cases that discuss this, they don't limit the officer's use of these defenses. What they're doing is limiting the use of the private citizen. Because when we've addressed this in the past, when people have been charged with murder, it's usually it's because they used too much force and they should have called the cop. All those cases that the court referred to, except for one, Fiedler, all those are private citizens. This idea that officers and private citizens should be treated alike, that comes from a 1930s case where what was had was prohibition, right? And so in this case called Gonsler, this guy's making moonshine in his garage, and it was illegal back then, okay? And someone tries to steal his moonshine. And then he claimed that the guy ran away, and because he was stealing his moonshine, he shot him and killed him. He got charged with murder. And so when it goes up to the Court of Appeals, the issue is, well, does the fleeing a felon rule apply in that situation? You have a guy who's doing something illegal, and a guy runs away, and they still held it applies, but you have to have a reasonable belief that the person that is running is actually a person, or an actual belief. So, and they have actually committed a felony. The guy got convicted. All those cases relate to vigilante justice. And if we're going to start treating the police officers as vigilantes, why would anybody want to be a police officer? This arrest was textbook, was absolutely textbook. It started with a lawful stop where the plates didn't match the car. There were lawful commands. The officer was respectful and polite and firm, which he's supposed to be. Every step of the way. Captain McCursey testified that he followed his policy and training every step of the way. And so, whether or not that's reasonable under the circumstances, if that's going to be left to the jury, I hope that we get to at least put evidence on that every officer that's looked at this and reviewed it, nearly every prosecutor that's reviewed it, does not think that's murder under the law. And so that issue is going to have to be decided.
How do you justify, though, the shot in the back of the head? Trying to, with a jury, how do you get that?
It's where the deadly force is used is absolutely irrelevant under the law. The question is, when can you use deadly force? Not where. So, because the reason that's the rule is because you can kill somebody if you shoot them in the back of the leg, right? Just like you could shoot someone in the back of the head and they not die. So where you use the deadly force is irrelevant. All the cases discuss when. When can an officer use deadly force? So where is irrelevant.
So moving forward, and I know you've indicated that you will appeal, but looking ahead as we stand now to a trial, in terms of the jury, there's going to be very few people to find who haven't heard of this case, very few people who may not be pressured by societal concerns. Are you fearful when it comes to the jury selection?
I'm always fearful picking a jury because I never know what they're going to do. But we'll try to get a fair and impartial jury. And I think the people of Kent County can do that. If we're going through the jury process and no one can say they're going to be fair and impartial, then we could consider moving it to another county. But right now, there's on both sides. I could see people feeling very strongly one way or the other, and they're going to be asked, can you set that aside, those opinions, and look at all the evidence and apply it to the law? I mean, the question that we're arguing about today is not necessarily the facts. We're really arguing about the law because it's still not clear. And Officer Schurr only wants the opportunity to go to trial and have his day in court with the correct law. Obviously, he does not feel like he committed a crime, but right now the crime is still undefined.
So you plan to appeal today's ruling? Is that what?
Yes, we plan to seek leave to appeal. So
State Court of Appeals.
It's not an automatic
State
appeal.
Court of Appeals.
It would be up to the Court of Appeals, yeah.
So do you expect, the trial is scheduled for March, right? If you take it to the Court of Appeals, is that even going to happen? Do you expect it to start in March?
Well, the court could stay the action. I don't know if the court will or will not. No, if it were brought to an appeal, I would expect that the proceedings would be stayed and it wouldn't go on March 13th.
It seems, it seems like the judges have agreed with you with the question is like when is deadly force authorized, but it seems like they both interpreted that it's a question for a jury. Not that you have to get into like trial strategy or anything, but how do you plan on approaching the jury in kind of saying that Officer Schurr was justified in his use of deadly force?
I think it's a good question. Certainly, I think everybody knows our defense at this point. You have a suspect who flees, who doesn't get very far, and will not respond to any lawful command. And so our defense is that Officer Schurr was doing his job. He was trying to arrest him for a host of different felonies. Patrick Lyoya was fleeing because he did not want to be arrested. And so the law affords police officers the right to arrest somebody under those circumstances. And the law affords him the right to use deadly force under certain circumstances. We're still arguing about that. But the facts are relatively undisputed. Patrick Lyoya fought with Officer Schurr for several minutes, didn't listen to a single command, disarmed him of his taser. In our point of view, had the taser in his exclusive control, which is a finding that the district court already made. And he transferred it from his left hand to his right hand. And then the moment before the shot, he was rising off the ground. And so our defense is, first of all, there's the common law fleeing felon rule and the use of force and response to force, but also that he acted as any officer, and I think we only have to show a officer would have under the circumstances. Would any officer be justified and using deadly force under those circumstances. And the prosecutor has to prove beyond a reasonable doubt that no officer was justified. And so I think the prosecutor's got a tough burden in this case.
So was Patrick Lyoya, fighting with him or fighting to get away? Is there a distinction there?
He's fighting with him to get away. Obviously, the officer's trying to arrest him, and he doesn't want to be arrested. I mean, you've seen the video. Looks like he's trying to get away, right? Well, you can't do that. It's a lawful arrest. And he's asking him to stop. And then he's telling him to drop the taser. The law isn't that he's, with regard to the fleeing felon rule, that he's about to hit him with the taser. That's why Judge Ayub called it draconian. Because a lot of people, and I'm not saying this is the right law or the wrong law, believe that the only time an officer should use deadly force is when it's reasonable in the circumstances to use deadly force. But we're still in 1846. So, I mean, you guys can watch the video as well as I. I mean, it appears to me that he's doing everything he can to get away, including yelling to his passenger, get the keys, meaning we're getting out of here. Or maybe move the evidence of the crime away from here, one of the two. But it's not permitted under the law that you can fight with a police officer.
In any way, do you think it'll help or hurt your case that someone was standing by recording the altercation?
It is what it is. And I'm glad that there are more recording devices these days because these things come to light more often. And, good or bad. And I think society in general is benefited by the fact that things are recorded. And so, there are witnesses too, but here you have video evidence. The video evidence actually doesn't capture the entire thing. It goes up and down, and Officer Schurr's body cam goes off and on. But I think we're helped by the video evidence because while you can take a snapshot of a picture and make it look bad the instant the shot was fired, that doesn't erase the minutes beforehand when Patrick Lyoya was violently resisting arrest.
Given that you're using a pre-Civil War era law in this fleeing felon law, can you talk about the difficulties that imposes upon bringing forth this case in 2023 when we've had so much social justice movements even here in Grand Rapids, and explain does that make your job harder, the way that how low this law is?
Yes, and I'm shame on the legislature for doing nothing when the Michigan Supreme Court in 1990 specifically called on the legislature. It's in the opinion. We're not going to decide this. We're not going to decide what's justification in these circumstances. You guys do it, because we don't want to pass on this as a crime, because that's not our job. The legislature makes the laws. So perhaps the legislature, now that we have this situation where nobody seems to know what Officer Schurr's held accountable for, or if this old law applies, whether we want it to apply, maybe they'll do something now.
Are you confident that you'll prevail at trial?
Yes.
Thanks, man. Thank you. Thank you.
Thanks, sir.
Very few things in your hand comparative to the defense. What makes you so confident today?
I don't think it was confident. I thought, like the motion when we had the bind over, I think the law was on our side. I mean, I think, we prepared a good brief, and I just didn't think there was an issue that was going to be even close. I mean, I think the judge summed it up pretty well in her decision that, the law's on our side in terms of this should be, at this stage, is of a jury question. I mean, that's what it's basically about. It's not whether, the final determination. It's whether the jury should hear the case, and we clearly believe that, and the judge upheld that today, so I think that would be the confidence, I guess.
How confident are you that a jury will decide that he was not justified?
That's going to be up to the jury. I'm not going to make any predictions on that. That's up to a jury ultimately, and we'll see.
What do you make of the judge's thoughts on police department policy and whether that could be evidence?
Yeah, I think she was saying it's kind of an interesting, splitting of the hairs, if you will. She's saying, I don't think the judge should have, dealt with it at the preliminary hearing, but she was quite clear that she's not making any preliminary determinations, saying it can't come in at the trial. So I think that was just kind of, maybe a little inside baseball in terms of, she's not saying it can't come in at the trial. So that may be something we hash out down the road, but, at this point in time, I don't think that was that big of an issue.
Well, but in terms of your trial strategy, are you going to try to get that excluded as evidence based on what she said today?
I'm not going to divulge what my trial strategy is, so...
Do you feel like the law is clear here? I mean, we just spoke with the defense. He feels like there's some...
I said that in my brief thing. We speak the same language, but we're not understanding each other because I think it's perfectly clear. I mean, it's not a close call. So yeah, I think there's a difference at least, but in our interpretation is this is very clear that police officers are treated the same.
Chris, is the fleeing felon argument circular because Mr. Schurr, Mr. Lyoya was just a traffic stop, and then the officer escalated everything to felonies. It wasn't like he's a bank robber right down the street. They keep saying he's a felon running. He wasn't. He was a traffic stop.
Well, it was a resisting opposing. Resisting opposing, he ran. He clearly ran, and we conceded that at the preliminary exam, so it's hard for us to say it's not a fleeing. He was fleeing. It was resisting, so those are issues that,
and that's a felony.
Yeah, resisting an officer is a felony.
And this is an 1846 law, pre-Civil War era law.
No. He was talking about the common law, the fleeing felon, but that's a law, but it's been developed over time, and that's our position. It's not like we're stuck in 1846. There's been case law and Supreme Court cases that the judge cited and that we cited that have developed that law over time.
So Jesse James is not relevant here?
I don't think so.
That's my point, because he's parading him as a bank robber, fleeing felon. I mean, this is a traffic stop.
Yeah, but it's still a felony, and we conceded that. So it's hard for me to say no, it's not. I mean, we said that at the preliminary exam.
So he's still trying to argue that he thinks citizens and police officers should not be held to the same standard, because then that sort of elevates citizens to be vigilantes on the streets. Do you see any possible bad side effects here by arguing that citizens and police officers should be held to the same legal standard for use of force?
Well, that's the thing in terms of, I think my concern is that if police are held to a different standard, you pull a police officer says, hey, come with me, and you pull away, all of a sudden the police officer can kill you. That's stunning in its application. So I think that's the biggest thing. Civilians have always reasonable force and only when immediately necessary. I think that's clearly for civilians, and it's clearly for police too. That was our point.
Defense has indicated that they're going to seek leave to appeal Judge Elmore's decision. Do you have any concerns about the trial getting pushed back possibly, or is that just part of the process?
No, it could be. I mean, quite frankly, it could be. That's something we're going to have to see how it hashes out. March is coming up quickly, and so I'm not going to predict at any point in time what's going to happen, but that is a possibility.
Is the county at all in communication with the Lyoya family? I know that they've been frustrated that the trial has taken so long. Any communication with them? We've
been in communication. That's they're our victim witness unit, and we're in communication with them at all times. We let them know this was going to happen today. They said they weren't going to show up, but we're always in contact with them, and we'll notify them what's going on, and I'll try and keep them abreast as best we can.
So no surprises today?
Not for me. I mean, I think this is kind of how I expected it to go, because I thought, like I said, I thought the law was fairly clear and on our side.
Thanks, Chris.
Thank you, sir.
All right, we have one more piece to play for you guys. This is only 1 minute and 51 seconds, and then I'm going to go pass out. All right, one more. I got one more piece.
Starts right now.
Less than 2. Sorry. All right. Last segment for the night.
Weeks before his criminal trial, former Grand Rapids police officer Christopher Schurr appeared in court. Schurr is accused of second-degree murder in the death of Patrick Lyoya, and as he sat next to his lawyers on Tuesday, Judge Christina Mims ruled on a number of pre-trial motions. In particular, she denied a motion from the defense, which sought to include a live taser demonstration during the trial.
Just like I wouldn't allow someone to come in and shoot someone in the shoulder to demonstrate that they could survive that wound, I'm not allowing a taser demonstration. So,
in regard to expert testimony, Judge Mims said if necessary, she would excuse the jury during the trial so she could first determine the reliability of the witness and the parameters of their testimony before allowing them to take the stand. Tuesday, I also spoke with the father of Patrick Lyoya, Peter Lyoya, about the time that's passed since his son's death.
The thing that I would like to add is I did not know when I came to America that it would take me this long to get a justice for my son, because I was expecting for justice to be done from the moment that my son was put in the ground.
Meanwhile, the attorneys for Schurr say the publicity of this trial will make for a lengthy jury selection process.
I think they're concerned that people, because the video was made public, have already seen the video and drawn conclusions. We don't want people that have already made up their mind before they hear the evidence.
Jury selection in the trial of Christopher Schurr begins Monday, April 21st. The trial itself will begin Monday, April 28th. For now in Grand Rapids, Sam Lanstra, Fox 17 News.
All right, Drunky the Bear. Thank you so much for that. And I could reply in saying, our chat is the best chat on the entire freaking internet. That's great. Oh, what did I just do? I did something. Uh-oh. What did you just do? I don't know. And therapist says, yeah. All right, I was going to take a screenshot, and I think I did something wrong. I cleared out chat. All right, all right. I'm doing things that I shouldn't be doing. It's been a long day. I had two meetings starting at 10, I had back-to-back meetings at 10 from 10:30 and then 11:30. Then we streamed Wagner from 12 until 3, and then now this from 3 until 11. So. Anyway, guys, thank you so much for being with us. This is going to be a very, very intense trial. It's going to elicit a lot of emotions. So there were some issues, well, not issues, but it was a bumpy start, but I think everybody found their groove, and I think we're in a good place right now. So thank you for joining us. Thank you, Aaron, for putting together these graphics. Thank you to our mods. Yeah, Super Ball. She slept most of it. She's not even here. She's looking out the window. I can't even show you. Oh, here she comes. Here comes Super Ball. Whoop, drive by. Drive by Super Ball. Come here. You want to come here? Hey, come here. Come here. Meow, meow, meow. Yeah, hi. Tell the people how you feel. Hi. Hi. Did you have a tough day? Did you have a tough day? What? How tough was your day? How tough was your day? All right, guys. Thank you so much for joining us. Appreciate you guys. We will see you tomorrow at 11:30 for we're going to finish up Dr. Schurr. All right. Tomorrow we're going to finish up Dr. Turek. I don't know where Dr. Schurr. Oh man. All right. Tomorrow, I can't even form sentences right now. Tomorrow morning, we're going to stream the day 8 and day 9 of Dr. Turek, Massachusetts versus Turek. And then Monday, this trial starts at 8:30. 8:30 start, 8:30 Eastern. So please join us for Massachusetts versus Dr. Turek tomorrow. And then Monday, we're going to start this trial. So have a good night, guys. Take care. Definitely get some self-help, because this brings up a lot of feelings, a lot of emotions. Take care of yourselves. Make sure that you take care of yourselves. So we'll see you. Bye.